Good morning from India. My name is Rajkumar. I'm the founding Vice Chancellor of OP Jindal Global University. Good afternoon to our friends in Southeast Asia. Good evening to our friends in Australia. And good afternoon again to our friends in Hawaii as well. It is such a pleasure for me to welcome all of you to this third day of the Global Virtual Conference on Reimagining and Transforming the Future of Legal Education and Law Schools. We are, of course, on the 21st thematic session of this conference on the theme Teaching, Mooting, and Advocacy Online. When OP Jindal Global University conceived of this conference, little did we know that this collective consciousness of humanity that has been shaken by the COVID-19 crisis has brought us all together to discuss on issues that confront our present and indeed our future. We couldn't have had a better group of people who have assembled here today in this panel to discuss about issues surrounding teaching, mooting, and advocacy online in a larger context of judges and lawyers working even in courts which have gone virtual. I have great pleasure in welcoming Honorable Ms. Justice Sabrina McKenna, Judge of the Supreme Court of Hawaii in the United States of America. We have with us Professor Nick James, Executive Dean of the Faculty of Law, Bond University, one of the leading law schools in Australia. We have with us Dr. Surat Singh, a very dear friend and a mentor and senior advocate in the Supreme Court of India, a distinguished graduate of both Oxford and Harvard universities. We also have with us my colleague, Professor Karan Latyan, Assistant Professor and Assistant Dean, Jindal Global Law School, one of the core organizers of this conference as well. And I'm also grateful to my colleague, Professor Sarbani Sen, who is a professor at Jindal Global Law School at OP Jindal Global University, who has agreed to moderate this panel. In many ways, this is a global panel, not only because of the organizations and institutions that we are representing, but more importantly, from the locations that we are. Although Sarbani teaches at Jindal, she is now speaking in this panel from Canada. Such is the global engagement that has happened, and COVID-19 has created both a challenge and indeed an opportunity. With those words, I'm going to hand this panel over to Sarbani for taking this forward. Thank you very much.
Thank you, Raj. A very warm welcome to the distinguished panelists participating in the discussion today. The theme for today's discussion is Teaching, Mooting, and Advocacy Online. Mooting and advocacy play an important role in legal education, both for students and faculty, since it offers the closest experience to a courtroom. There are medieval origins to mooting, which can be traced back to the Inns of Court. Apprentices had to undergo mooting for many years before they could actually start practicing before the courts. Cases were discussed after dinner at the hall of the inn, followed by mooting sessions with a bench and apprentices assuming relevant roles. The essence of mooting has not changed much since then. Students continue to simulate the role of advocates before a bench, making arguments based on a hypothetical case. Mooting requires multiple skills: logical argument, the ability to think on one's feet, rhetoric, and a display of proper court etiquette. Mooting is also a mode of contestation between law schools through many prestigious moot court competitions. Mooting requires the use of a defined physical space, and it is also a time-bound activity. As legal education moved online during the pandemic, the conduct of mooting sessions as an essential law school activity has become challenging. Mooting sessions in law schools, as well as prestigious moot court competitions, has shifted online. But online mooting is heavily reliant on technology. Such reliance has prompted many mooting events to rewrite mooting rules so as to accommodate disruptions caused by power and internet disruptions or software and hardware failures. The mooting room has lost its confidentiality as well as the challenge of being extempore. There can also be privacy, intellectual property, and cybersecurity issues. Thus, it is important to reimagine the concept of mooting without letting the spirit of the activity fade. Such reimagination is appropriate since during the pandemic, actual courtrooms have also had to shift to online platforms. There are many questions that law schools face regarding teaching mooting and advocacy online. For instance, is it possible to recreate the same learning experience in online platforms that mooting in physical moot rooms offer? What aspects of physical mooting might get lost when the activity goes online? can essential mooting skills still be taught? Given the pedagogical objective of moot courts, is the loss of physical space significant? So these and similar questions are going to be the subject matter for deliberation by the learned panelists today. The discussion will take place by asking questions which are addressed to the panelists, and each speaker has 3 to 4 minutes in which to respond. We have to sum up 10 minutes before the session ends so that there can be some questions from the audience. So the first question that I would like to ask, I would like to pose to Professor James. Considering that mooting requires public as much as public speaking as much as debates, why do law schools stress mooting over other activities? How are the skills developed through mooting different from those obtained through other public speaking activities? Considering that historically, apprentices had to perform at moots for many years before taking up advocacy, can we infer that the skills gained in mooting translate into relevant experience before the courts? Professor.
Thank you very much, Professor. It's a good question to start the conversation, a nice general question about the value of mooting generally to law schools and to law students. So initially, a little bit of background. So I'm the Dean of the Faculty of Law at Bond University in Australia. And here at Bond, we try very hard to promote a strong mooting culture. And we're able to do that because, one, we have a very low student-staff ratio, so we have very small classes here. And we're able to use mooting as a teaching and assessment tool in many of our subjects, as well as supporting our students to participate in international mooting competitions. So all of our students experience being required to moot and being assessed on their mooting skills periodically throughout the degree. And the other reason we have a strong mooting culture is, as a private university, we're very well resourced. And so we're able to support our teams to travel and compete internationally as well as domestically. Now, the reason why we embed mooting as a teaching and an assessment tool throughout the curriculum, which goes to the question that you asked, is because in our view, there are very few better ways in which a student can be called upon to demonstrate their understanding of the law and their ability to exercise practical legal skills. So while it's true that mooting does go a long way towards preparing law students for courtroom practice, the value of mooting goes far beyond that, because it teaches students the importance of researching their case, presenting their arguments articulately and persuasively. It refines their oral communication skills, and it teaches them that very, very important ability to think on your feet. And that's something that debating, in a general sense, doesn't do. Debating can be very well rehearsed, but mooting, there is nothing like standing up with your case prepared and having a judge immediately start interrupting you and challenging you and forcing you to rethink your argument and come up with a persuasive argument on the spot. And even if the law student never goes into the courtroom and never practices as a member of the bar, the value of learning how to moot is going to be beneficial no matter what they do. So that's why we embed mooting wherever we possibly can in our curriculum. It's an extraordinarily valuable teaching tool.
Thank you, Professor James. Would anybody like to respond before I move on to the next question? Any of the other panelists?
Well, Professor Sarbani, see, being both a Supreme Court lawyer and teacher, the mooting I found, as Dean James rightly pointed out, extremely effective tool to communicate competence, confidence, communication, 3 skills, and understanding the concept. Because as he has rightly pointed out, the moment you enter in the court, whatever written is already there before the judges, and they start asking questions. So responding to them makes all the difference whether you will win the case or not. Particularly more so at the higher level, like Supreme Court. In special leave petition, we get 2 minutes, 3 minutes. There are 70 cases listed in a day. So if you are well rehearsed in mooting at law school, it is extremely helpful because then you can think on your feet and you can respond spontaneously. So mooting as an effective tool of teaching is best indicator whether a student has likelihood of succeeding in legal practice. So Dean is absolutely right, and that's why. And mooting can be done online. Like for example, when I was teaching my course, Lawyering in Supreme Court. Now, idea was how to show them how to argue. So I asked them online that supposing if you're Attorney General of India, how you will argue, or if you're defense lawyer, how will you argue? And the students did that on line. And I was able to give feedback to them there and then and demonstrate them that how it could have been done differently. So yes, mooting online is an extremely effective tool.
Thank you, Dr. Singh. My next question goes to Honorable Justice McKenna. Courtrooms across the globe have undergone a digital transformation due to the pandemic. What are your views on the effectiveness of online hearings? How challenging has this transformation been?
Thank you, and aloha to everyone around the world. It's really an honor to be able to join you today. Yes, we have started in May, we started doing our oral arguments online. You know, I think March and April, we weren't sure what was happening. By May, it was very clear that this situation would continue for a while. So we started doing online oral arguments. There are 5 of us on our court, the Hawaii Supreme Court, which is the highest court of one of the 50 states in the United States. And our oral arguments, our hearings are different from for the high courts or the India Supreme Court, where it, as the advocate has said, it's 2 to 3 minutes. We have arguments that last for 40 minutes to about an hour, and we give 20 minutes or 30 minutes to each side. And so our court is known as, I think, to be what we call a hot bench, which is a bench that starts asking a lot of questions fairly early. And as the advocate has said, it is for the attorneys to argue in front of us. So, you know, we had to make some adjustments because instead of sitting in the courtroom for the 5 of us, because we need to socially distance, we do this from our chambers. And I do it from here. This is my chambers. The only difference is I have my robe on. The Chief Justice is in the courtroom, but the remaining 4 of us are in our chambers with our robes on. So how do you ask questions? What we have gone, since we only have 5 of us, we have just gone to the Chief Justice, sees all of us on the screen, and if we have a question, we raise our hand, and the Chief Justice calls on us and says, Justice McKenna has a question. And that's how we do it. I have found that the challenges have also created opportunities, as Vice Chancellor Kumar has said. What we have found is that this really works for appellate oral arguments. Our trial courts, for example, our district court has also gone to Zoom hearings for minor matters, such as initial appearances in criminal matters, or for our traffic cases. And ironically, for our traffic citation cases, our experience now in district court is that we have a much higher percentage of people that actually appear, because it's so much easier to appear via Zoom than it is to get on a bus or drive and park and get into a very crowded courtroom, go through the security line. It takes a long time, but on Zoom, people can just appear and say, yes, I admit, or I deny, or the prosecutor will say, if you admit, we will go ahead and reduce the fine. Do you want to, just pay the fine today? And people can take care of the matter. So the bottom line is, I think that this has created opportunities, especially because we are an island state. We have several major islands, and we've had oral arguments in our courtroom, which means that if we have cases from other islands, the attorneys would have to get on an airplane, fly to our island, rent a car, or have somebody pick them up, drop them off at our courtroom. It takes an entire day to do a 1 hour or 40-minute oral argument. Whereas now, all of the attorneys are doing this from their own offices, and if they're from another island, they don't have to travel. And one of the real advantages also that we've had is that when there's 5 of us, and our law requires that there be 5 of us hearing each case. And for example, if one justice has retired or has to recuse due to a conflict of interest from a case, we have trial court judges, our higher level trial court judges come and sit with us. But up until now, it's only been judges on this island that have been able to sit with us. But because we're doing it via Zoom now, we can have judges from the other islands, which is a wonderful educational experience for judges, because I, as a trial court judge, also used to come up to the Supreme Court sometimes on these cases that justices were recused. And I learned a lot about how the appellate courts view my cases as a trial judge, the standard of review, the things that the appellate courts are thinking of, which help me as a trial judge make better decisions. So I do think that this remote experience has provided opportunities for appellate arguments and for minor matters in the minor matters, or for initial experiences or traffic cases. However, I do not think that this is something that really works when judging the credibility of witnesses is at stake. And actually, for example, you probably know that not only is there a federal constitution, but each of the 50 states have our own constitutions. Most state constitutions have the right of confrontation in our constitution. Under Hawaii law, under the Hawaii Constitution, in criminal cases, the right of confrontation means face-to-face. This isn't necessarily true of all states. So some states have been doing criminal cases online. Our Constitution requires that a criminal defendant be able to confront the witness face-to-face, which means that we cannot do criminal trials online. So we have a major backlog of criminal trials, and also jury trials, which is a big issue. But we have we are now starting to do our criminal trials and jury trials live with appropriate social distancing and measures, and we have started doing that. So I think it's working.
Thank you. Let me get to the third question, and I would like to address this question to Professor James as well as Professor Lahar. So mooting is the most authentic form of courtroom experience that law schools provide to students. The mode of hearings and mooting during this pandemic has had to change. How should law schools reimagine the way in which to conduct and mooting, and what support should they give students, should universities or law schools give students in organizing virtual moot courts?
Another excellent question. Thank you. So conveniently last night, my faculty hosted a special dinner for all of our mooting teams who've been participating in the last year. And so, I couldn't have asked for a better way to prepare for this conference, because I was sat at dinner at an event with dozens of students who have, over the last 12 months, experienced online mooting. And I told them I was coming to this conference, and I was asking them lots of questions about their experiences, and heard a lot of very positive stories about the transition that was made to online mooting, because it took many people by surprise. When the pandemic hit, many of our students were already in teams preparing for competitions. So some of our students experienced the disappointment of competitions being cancelled very early in the pandemic, but then having to make the transition from what was proposed to be a face-to-face mooting competition to an online competition, which often meant delays. But generally, students who participate in competitive mooting are extremely resilient anyway. Mooting, as we know, is a very, very difficult and challenging experience. And so these students are quite intellectually, if not physically, tough in order to withstand the pressure of mooting. So they were able to adjust relatively quickly. I think one of the hardest challenges was the enormous disappointment that they experienced in not getting to physically travel to other jurisdictions and other places in order to compete. But once they got past the disappointment of not going to The Hague or Washington or Beijing in order to moot, they realized that the online mooting was actually providing them with some extraordinary experiences and opportunities to, while they couldn't travel to one other country, they got to peer through a window into the lives of students and judges and academics all over the world, and see what their backgrounds look like and have conversations and learn about other cultures, which was wonderful. In terms of helping students to make that transition, I think there's a few points. One is that, as I think the judge has already made the point, that any adjustments made on the part of the courts is in many regards temporary. So that's the case here as well, that while some processes have moved online and are likely to stay online, many of the more important trials, the courts are keen to get back to face-to-face as quickly as possible. And so we're not talking about a radical transformation of mooting towards only having online mooting. What I suspect is going to happen, as will happen with the courts, is that where appropriate, things will be done electronically and virtually, but wherever possible, the more important matters and the more prestigious moots will be held face-to-face. So now law schools have an obligation, I think, to prepare students for both styles of mooting. And when it comes to, while of course we have a lot of experience with supporting students with the traditional face-to-face mooting, in terms of helping them with virtual mooting, apart from the obvious obligation to ensure they have, an excellent internet connection and access to equipment and cameras and quiet spaces in which to actually engage in the mooting, where they're not going to be interrupted by other students or by academics, but also training them in the differences between face-to-face and online mooting. And I think we're going to explore that a little later in the panel discussion, because what's come through is that there are some very, very important differences between the way one moots and advocates in person and online. And I'm looking forward to exploring those differences.
Great. Mr. Lahan, would you like to add anything to what Professor James can say?
Yes, thank you, Professor Sen. Thank you so much for this opportunity. Good morning to everyone. So I'll try to answer this question from the perspective of being a mooter, though I have been disconnected from the mooting circuit for a while now. But if I put myself in the shoes of a mooter who's going for a moot court competition during the pandemic, so the biggest challenge that I would face is basically how to deal with the absence of the courtroom theatrics. So one of the major aids that I had available to me was a sense of the bench, whether they are with me, while I'm arguing a case, whether they are disconnected, whether they agree with me, disagree with me. Reading the bench, which is an integral part of mooting, is something which I feel would be of a challenge, specifically, on the online platforms. And as already indicated by Justice McKenna and also Professor James, there are certain critical, physical confrontations that require a face-to-face conversation, like reading the witness. that touch of the cheek, that scratch behind the ear that you can't see on the online platform is very important for, like in India, we have cross examinations. There are trial advocacy modes where, these things matter. Like students are trained to, like, kind of pick on these actions in the courtroom. So having said that, there is a challenge, and I feel mooting as a core academic activity, it needs to continue. So online mooting is a good means of continuity, but in a way, having mooted in the past, I would still want mooting to be a physical experience. But with respect to the suggestions or the training that is required with respect to online mooting nowadays, the biggest challenge I feel is that, when you're not in the courtroom, you can't move your hands, you can't be animated behind the dais. And that kind of makes this disconnect apparent. So I would suggest that, if I am training a moot team, I would be more stressing upon the speech modulation, which now needs to be even more than before. It's through their speeches that students need to summon the golden age of radio again, where the listener can close their eyes and still feel connected to the listener, to the speaker. So that is, I think, is a bigger challenge. Also, it's a tangential point, but I would still want to make it. Court etiquettes is a big thing, but when the court transforms, onto an online platform, there are certain additional etiquettes and mannerisms that need to be taught. For example, there may be a voice lag, right? The speaker who's speaking on the other side, you may not be able to hear him in real time. So, understanding those dynamics, ensuring that, you understand your environment and surroundings, I think that's an added responsibility that needs to be taught to the students as to how to conduct on an online platform. Thank you so much.
Thank you. So just taking off on the points that Professor Latan made, and I think also Professor James, there are some kind of challenges to online mooting, which kind of makes it different from the physical moot courtroom. So this question I would like to ask to Dr. Singh. So being able to observe witnesses in person forms an important aspect of physical courtrooms. High-resolution videos can conceal the minutiae of physical facial expressions, and a network lag can be misinterpreted as a hesitation to respond on the part of the witness. So what level of training should law students undergo to prepare for the needs of online hearings? Will online mooting be transitional or actually a necessity for managing virtual hearings that may possibly represent the future? Through what other means should law schools engage in teaching advocacy online?
Professor Sen, thank you very much. See, whether it's mooting, teaching, or advocacy, online or in person, the true test is effectiveness. And effectiveness means the purpose for which the activity is done. Say, for example, as a lawyer in court, our purpose is to persuade the judge to our way of thinking. Same thing is required in mooting. Now, and apart from, so three qualities are needed, as I say, of a top lawyer. One is competence, of course. Second is communication, because one might be having a clarity in his head or her head, but unless it is communicated, Justice McKenna will agree with me that unless it reaches the judge, it is not effective. So competence, communication, and connecting. Connecting means able to communicate, able to connect with whatever the judges are saying, because if you are not addressing the questions which judges are having, then it means you are just talking to yourself. So it is very important that students have that sense that these things are to be communicated. And that's why, as Latan said, that you will not see the interaction of judges online. Now that's very important, because arguing is a two-way traffic. It is what you say and how the judge respond, and the judicial decision making is an interaction between the advocates and the judges. So Now, for example, what I did this time when I was teaching a course of lawyering in Supreme Court at Jindal University, apart from producing the arguments for both sides, petitioners as well as defendant, we also gave an assignment to write a judgment so that they understand that how the arguments are perceived. So we gave a Supreme Court case and we said that supposing if you were to write a judgment, write a 30-page judgment, these are the arguments on both sides. So they get the sense also that apart from the advocacy, there's a target audience, that is the judge or judges, that how they perceive it and how do you address their questions and concerns. As Justice Makina rightly said, that material is already there. 2 minutes are in special leave petition in Supreme Court. But when there are final arguments, Justice Makina, even in Indian Supreme Court, we get not only 30 minutes, but even days together. And then judges ask the question that, okay, Mr. Singh, you have given this interpretation. How about this? What are the consequences in scenario this? So all this interaction is very important. So the test, whether in online or in person, will always be effectiveness. And as the theme, overall theme of this conference, Professor Raj has said, reimagining and transforming law schools and legal education. So what I would say that whether it's online or in person, the substantive aspect will always remain. For example, the contents, effectiveness. So 3 things I emphasize: competence, communication, and care. Teachers should care, judges should care, advocates should care about the objects for which we are engaged in. And one transformation, if I can suggest, is that instead of teaching at law school, because I am both a Supreme Court lawyer and an honorary professor at Jindal University, so the vision of law school legal education, instead of just training them just as a lawyer, training them as how to be great judges, how to be great lawyer, how to be great jurist also. Because at least in India, we need more reflections the way law works. And we have some very distinguished jurists like Professor Raj Kumar, Professor Bakshi, of course, earlier Nani Palkiwala. But on jurist, reflecting upon the role of the law is very important. And there I say that instead of just focusing on black letter of law, focusing on big picture of law is very important. Instead of just focusing on lawyer's law, focusing on what I will call statesman law, means how law is applied by legislature, executive, judiciary. So overall picture of the law in transforming the society is very important, which is to be communicated whether in person or online.
Thank you, Dr. Singh. The next question is one that I think Professor James and Professor Lafian can again address. Some of the world's largest mooting competitions, JESA, has now moved online. Will online mooting provide students with the same set of skills as the traditional format, or does it develop new skills? Will the skills, these new skill sets, which are gained through online mooting, be relevant in a physical courtroom post-pandemic?
So this is, we're going to sort of look more closely now at the differences between online mooting and face-to-face, and whether the new skills that the students are going to be having to learn in order to compete in online moots is going to be useful to face-to-face. Just starting with that final point, I think the ability to communicate persuasively and effectively, thanks to Dr. Singh, via online media is something that all lawyers are going to have to do going forward. It's the reality of the legal workplace is that a significant proportion of their work, whether it's communicating with clients or with colleagues or with members of the judiciary, is going to be via this screen. So I think any skills that they develop as a result of online mooting are going to be useful in legal practice from now on, even if they aren't necessarily directly relevant to face-to-face advocacy. So what are the differences? And this is what I picked up from having conversations with numerous mooting students who have had the opportunity to compete in face-to-face moots and online moots and are very conscious of the difference. And it picks up on something that some of the earlier speakers have said, is that when you're advocating online, because you can only see part of the body and often only the face, a lot of the normal body language and performativity that advocates engage in the classroom is lost. You don't get to walk around and wave your arms and so on. But you do still need to perform. And the fact that the camera is often very close to the face of the student and, of course, the bench means that, as has been pointed out, micro expressions, performance in the face and in the voice become extremely important. And the students I spoke to were expressing gratitude for being given the opportunity to develop a very new style of advocacy where it's all about having an animated expression and putting emphasis into the use of particular words and performing in the face. And again, I think that is going to be, I think being more mindful of performance on that more micro level is, I think, going to be useful even in the face-to-face courtroom or classroom. But that is something that's going to be useful in many forms of legal practice. The other big difference, jokingly, this was brought up by a few female students who said just how wonderful it was to be able to moot and not have to wear high heels, to just moot in slippers and socks and not only have to really prepare this part for the performance and be quite relaxed in the off-camera parts. And they also talked about how mooting from a safe space, from the campus or from home even, is helpful. It's kind of reassuring because mooting is difficult enough without also having the stress of traveling to somewhere strange and unusual, which is a great experience, but it's also stressful. And so online mooting can be less stressful in many instances.
If I may, one sentence from practical experience. I was arguing before the Supreme Court and Chief Justice said, Dr. Singh, you are staring down at us, so be away from the camera.
Actually, just on the point about cameras, another point that the students made was that they feel that online mooting is fairer in the sense that everybody sees the same angle. So that when students are competing in a courtroom, the students who are advocating are talking to the judge, and so they see the judges and the judges see the student, but everyone else sees it from the side and from different angles or from behind, and you can't really see what's happening. Whereas when it's done online, all of the other students can see the same thing, so it's fairer. And the other point was that the students found it, the new skill was to stare at the camera, not stare at the faces on the screen. So you're not constantly looking around. It's actually easier because ideally you want to look at each judge that you're trying to persuade. And when you're doing it face to face, you have to look at the judge, look at the judge, look at the judge, and maintain eye contact with each one, be constantly calculating, I haven't looked at that one enough. I need to focus on that judge more. I don't want to leave him or her out. Online, you just need to focus at the camera, and then all the judges get that direct line of sight. So they found that initially quite challenging, but eventually they thought it's much simpler and easier. I just stare at the camera now. I don't have to worry about where I'm looking anymore. I'm looking at one place.
Professor Lahar, would you have any responses?
Yes, Professor Singh, thank you so much. So I would like to add to Professor James with respect to this question. So mooting as an activity is not only about speaking, but we are forgetting an integral part of mooting, the activity, which is also research and writing. Mooting also inculcates organizational skills, right? I mean, how to structure your arguments, how to present them in a better way, and also teamwork. So these aspects about the mooting activity, they are not going to be undermined during the pandemic. Definitely speeches and how you conduct yourself in the courtroom definitely is going to be impacted. But the fact that key takeaway from mooting is your research, your writing, your understanding of the law. those things are still going to carry forward. Those things are still going to be like aided by mooting activities across the globe. And just to I remember this one incident, and this is very important. So these are the subtle differences that we need to understand that have happened now when we have shifted to an online space. I still remember, whenever teams used to go for moot courts, they used to carry like one bag of books that they referred to, and the other bag of books was only to scare the other team that see how much we have read. So all those things have now died down. I personally remember in my first moot, it was a constitutional law moot, and I took the fattest book out of the library, and I was just flagging that book, not because I had read it, but because I wanted to show to my opponent that, see, this is how well I'm prepared. So those mental battles that can only be fought in a physical space, those mental battles have been diminished by online voting. But again, that being said, we cannot take away other key aspects of this activity that do add to a law student's life of being a professional.
I had a kind of a related question, and this question can go to Professor James and Professor Latan again. So with the demand for technological proficiency from lawyers and judges in these times, should law schools focus on imparting technology skills as much as they do on promoting mooting skills in order to promote online teaching? So Professor Latan, you can respond, and then Professor James.
Well, I kind of agree with this, but we need to understand the practicality of how much technology a lawyer needs to know or a student needs to know when they're mooting. So definitely they need to inculcate the new norms, the new etiquettes, the new mannerisms that you require to engage on an online platform. But yes, in addition to that, I would say that the soft skills, like for example, when you're arguing and suddenly there's a lag, right? You realize that your voice was not heard. Instead of panicking, those trainings are more important, because while arguing, it's the flow of the argument that matters the most to a speaker. And you might be thinking that you have made the most logical of points, but suddenly from the other side there would be a meek voice saying that, can you please repeat? And suddenly you find yourself, your flow is completely lost. And that is when the students panic, because they would feel that they have lost time, they have also lost on that good flow that they were building on. So I still feel that mooting as an activity needs to be reinvented. Technology is something, which is important, but more than technological training, it's still the mooting which should be in the center of online mooting activities.
I totally agree with Professor Latan that apart from the technology, which is of course important and training is to be given, the substantive aspect of how to be a great lawyer, how to be a great judge, how to be a great jurist, which in all times, since time immemorial, we have inculcated, should also continue to be done, because we should not overestimate the importance of technology. What you argue on computer, on internet, is what you are. So what you are is far more important than, of course, technology. They are supposing you might be a brilliant lawyer, and if there is no internet connection, then that will not go through. But what you are basically conveying is what you are. That's why the basic requirements of being competent, being effective in communication, caring, all those qualities which we always inculcate should continue to be. And as Dean James rightly pointed out, it is not either or, that whether it would be online or person. The best combination would be both. Some, of course, because of COVID, we are under artificial restriction. But once the thing normalize, the personal touch, like the thing which I learned at Oxford on one-to-one level on tutorial, online, that can be done, but that can't be done exactly. So the importance of personal touch, personal interaction will always be there, though at the moment, because of special circumstances, we are more dependent on technology than on personal interaction. So both training in training or technology, and training in all those wonderful skills which are needed are to be emphasized upon.
Thank you, Dr. Singh. Professor James, a related question. To the extent that there is an unprecedented reliance on technology in these times, can online mooting put certain sections of students at a disadvantage in terms of lack of equipment, technological knowledge, and connectivity? And what can schools do to address this divide?
I think my answer to that is yes and no. I mean, obviously, in order to participate in an online moot effectively, you need relatively good quality equipment and an internet connection. Otherwise, the issues that you flagged earlier around lags in streaming affecting the persuasiveness of the argument and low resolution preventing the presentation of a persuasive case, all of those issues, of course, will come up. So yes, I think law schools, to the best of their ability, have an obligation to support their students to have access to at least the base level equipment that they need. But my view is, in fact, that the shift to online mooting has, in fact, expanded access to mooting opportunities rather than limited it. Because while, of course, getting good equipment is expensive, it's even more expensive to fly a team of students around the world to participate in the competition. And so what we've seen is that a lot of the competitions are larger because they're online, because there are more students and more law schools that are able to compete and participate. So I think that the shift to online mooting, whether temporary or permanent, is a positive move in that it has expanded access to participation in these competitions. And for that reason, it's a good thing.
One question I would like Justice McKenna to address is that, being on the bench, what kind of the qualities you would like to inculcate in students during these times? Justice McKenna.
Thank you. Yes, thank you for that question. I think so many things have been covered, but I agree, the lack of distraction and also knowing that it is just basically this space. So what are you going to do with this space? What tone of voice? How quickly are you going to speak? You really need to make sure what you are doing comes across well to the judges on the other side, whether it's moot or whether you actually come into court. Because I've been asked to do so many online things, just a couple practical things that I have been told. And that is the camera, it should be about this much of your body that shows. That the camera should not be below you. It should be above you. And you need to figure out, one thing that I really learned is that you need to figure out, where does your camera, as Dean James has said, you need to be speaking to the judges. So I'm not entirely sure yet exactly where I'm supposed to be looking, where it looks like I'm straight ahead. But my camera, I have a webcam that is connected to the top of my computer. I thought looking into it made me look straight in. And I realized when I saw a recording of myself is that when I'm looking into my camera, I'm actually, it looks like I'm looking above. So I believe that when I'm looking at the screen is about when it looks like I'm looking straight on to people, I think. And I still have to figure this out myself. But the other thing is, yes, one additional thing I would say is, for mooting, you're going to have a panel of judges usually. If you have a panel of judges, make sure you're on gallery view and not speaker view, because at least while the other side is arguing, you can see the judges' reactions to what the other side is arguing. So you will still be able to see micro responses from the judges. You might see them frowning, or you might see them nodding or shaking their head, and you can see, or like furrowing their brows, like you can get senses. So make sure you're on gallery view instead of speaker view. And when you do speak, don't speak too quickly, think about your tone, and make sure that the judges can hear you. So practice that way.
I think just one more question for you. To what extent can online voting be utilized as an opportunity to engage with distinguished members of the judiciary globally?
Yes, as Dean James has said, I think I was recently invited to be a judge for a final moot for the National Asia Pacific American Bar Association. Unfortunately, the time conflicted with our own oral argument, so I couldn't do it. But that final was connecting 9 state and United States federal court judges from around the country. Of course, in terms of time differences, we'd have to figure it out, but there's no reason it couldn't be done internationally also. And as Dean James said, because it was remote, there were so many more schools that participated this year as compared to past years. So in that sense, it did increase participation. And let me just say, this is a little bit of an aside, but because things are so remote now, for example, my son is a law student. He has actually visited Jindal in India, but he is a law student. And this summer, he was back home in Hawaii. He was supposed to be clerking for a New York appellate judge, Justice Cooper, who has actually spoken at Jindal on various occasions. But because of the pandemic, he was not able to go to New York, but he was still able to do his clerkship online from Hawaii. Now, the time difference made it that he had to wake up at 3 o'clock in the morning, Hawaii time, sometimes for hearings in New York. But there is no reason why some of these things can't continue globally. You can do remote internships also, not just mooting. I just wanted to mention that.
Thank you, Dr. McKenna. Professor Latayan, perhaps this question can go to you. This is a question now from the audience. This question says, mooting and trial advocacy being integral to the curriculum in law schools demand hours of research and practice on the part of students. A variety of books and reporters are required for preparing memorials and compendiums. However, since the pandemic hit, students have not been able to access libraries, and the online database does not seem to replace what the campus library has to offer. So what resources can you provide students and please research, their ability to research and to participate?
Well, that's true, and you can't really replace a physical library or that physical space where you're surrounded by books. But definitely to have a robust online mooting culture in institutions, online resources are the need of the day right now. You need books, you need reporters, you need journals, access to journals, online, so that students. Their preparation is not hampered. That's actually correct. But in addition to that, having said that, there are limitations associated with physical access as well. So I mean, navigating through a 1,000-page book is much more difficult, when you have the book actually in your hand than when you have computer in front of you and you have an online version of the book. Features like control Fing, finding specific words in the books, those things are also some things that add to the convenience of the whole exercise. So yes, but that's true, and I agree with it that at times, because law has such it has endless possibilities. There's a dearth of material on every topic, even though that topic has been written over and over again for thousands of times. But yes, I mean, perspectives matter. You need to read different authors. You want to know how many different times a particular case was argued, cited, how many times it was not relied upon. All those things definitely they come from resources, physical as well as online. So yeah, online libraries, online research, databases, they need to be available to students to actually make online mooting a success. I completely agree with that.
Professor James, any comments?
Yeah, I just want to pick up on a point that was made earlier about how the fact that the shift to online mooting doesn't change a big part of the mooting experience, which is, of course, the preparation. And the COVID pandemic has, in fact, forced our students to rethink the way in which they collaborate and prepare for moot. So in addition to the shift to accessing electronic resources that the Professor Latan was just talking about, just the way in which the students interact with each other. So traditionally, they tend to lock themselves in a room for 3 months and work together in a physical space in preparing for the moot competition. But because our students were scattered all over the country at the moment, our students were working together still very closely for hours and hours at a time, but via their devices, via WhatsApp, by Zoom. And last night I got to speak to some students who performed very well in a competition. They never met each other in person at all. They were in 3 different locations around the country. They prepared, they participated in the moot, they performed extremely well, and they still hadn't ever physically met each other. And I think that's the kind of benefit or advantage that isn't going away anytime soon.
So just to add a point there, and this is fascinating. So the level of team play that is involved in online mooting is something which needs to be understood, and it needs to be inculcated. People without meeting each other are a team, and they work together, they assist each other. That is a big takeaway from online mooting exercises that students need to inculcate and develop upon. I mean, being a team player and working in a team is a great ethic to acquire out of this experience of online mooting.
Professor Latan, so just to carry on from this point, there is a question from the audience which says participants in online moots find themselves sitting in the warmth of their homes or comfort zones and may not carry the true spirit of arguing and presenting before a court of law against another counsel. How do we address the probable dilution in values and ethics due to a lack of physical proximity, which would otherwise be followed by mooters?
Well, this is an interesting question, and I want to develop upon this point, which was initially made by Professor James and then forwarded by Justice McKenna. So the window in which you are seen has reduced, and hence the ethics, the mannerisms are now limited to this window. Earlier, so for example, when you go to a court, you are all dressed up. You wear your robes, you wear your trousers, and you wear your shoes. But now on the online platform, the shoes aren't visible. So definitely, if the question hits on the point that students may not feel obligated to dress completely from head to toe, yes, that's true. But when mooting, I don't understand how it dilutes your rigor or your enthusiasm, because even though so even if I'm going for a moot today and I'm told to speak, I would be as passionate about my case as I would be in a physical court. And as Dr. Singh also mentioned, it's the person who's arguing than the platform on which the person is arguing. So if you are if you have the zeal to argue, you can argue even in your sleep. So that is what I feel.
Just adding a point to Professor Latan, when a person like Kapil Sibal or Mukul Rohatgi argue, even online, one can make the difference that how different they are than an ordinary lawyer. One more point I will add on this mooting is that mooting is for the purpose of becoming effective lawyer. So it cannot be substituted for actual experience of the court. So I would strongly recommend that internship, and it is, as Justice McKenna said, it is possible to have the internship anywhere in the world. So this opportunity of having internship with some of the greatest lawyers, some of the greatest judges is an opportunity which students should take, because now it is possible. It may not be possible when things get normal.
Great.
Raj, is there room for one more question, or should I?
Yeah, we are coming to the end, but you can do one more question. Yes.
Yes. So the last question to Justice McKenna. This is again a question from the audience. It says the traditional method of mooting offers an opportunity to understand court manners and etiquette, be followed by a lawyer. Imbibing these skills becomes challenging for the learners in the online mode. How do you think this concern can be overcome while engaging in the online platform?
That is a very good question. That's true. The courtroom etiquette in terms of entering, where you seat, how you stand, how you address the court. But there are things that are still the same in terms of how you address the court, how you speak, your intonation, how you respond to questions. There are certain things that are just so the same. So I would just say that, and as I said before, I believe that online may continue for certain types of cases. For example, I believe we will now continue doing online remote oral arguments when we have a judge from another island, or perhaps when we have attorneys from other islands. So if they don't want to travel, we can just do it online. And for some minor traffic cases, we can do it online. But for regular cases, I believe as soon as this is over, we're going back to regular court. So you're going to be able to learn the court etiquette. I do not see us going completely online. It'll just be certain types of cases in certain situations. So you'll still have the opportunity to learn courtroom etiquette.
Thank you, Justice McKenna. Raj, would you like to sum up?
Thank you very much, Sarbani, for so skillfully and nicely chairing this session, moderating the panel. I deeply appreciate your comments and reflections on this because, when we put together this conference, we were conscious of the fact that we want to dedicate a few panels with a focus on students' interest, where students could directly resonate with the kind of discussion that we're having in this conference. That this is one such thematic session. I am particularly grateful to all of you, Justice Sabrina McKenna, Dean James, Dr. Surat Singh, Karan, and of course Sarbani, because so many points and perspectives that you shared will lay with the students' mindset as they think about mooting and advocacy. But it goes beyond the online dimension. Online is more, or physical is more, a tool. The idea of mooting is so integrally connected to advocacy and articulation. And I really enjoyed the panel, and I deeply appreciate your presence. Thank you very much for your time. Be safe. We'll have a short break, and we will move into the 22nd thematic session on role of regulatory bodies and courts during the pandemic. We will have Honorable Justice Arjun Sikri, International Judge of the Singapore International Commercial Court, Professor Pip Nicholson, Dean of the Faculty of Law, University of Melbourne, Professor Vijay Kumar, Vice Chancellor, National Law Institute, Bhopal, Honorable Mr. Justice Michael Wilson, colleague of Sabrina in Hawaii, and chaired by Professor Sudarshan, Dean of a Public Policy School. Thank you very much. I look forward to all of you. Good morning from India. Good afternoon to our friends in Southeast Asia. Good evening to our friends in Australia and other parts of the world who are watching this program. We are entering into the third day of this global virtual conference on reimagining and transforming the future of law schools and legal education. We are also entering into the 22nd thematic session of the conference on the theme Role of Regulatory Bodies and Courts During the Pandemic. I'm very delighted to welcome a distinguished set of individuals, legal scholars, leaders, judges who have been part of this panel. Let me quickly introduce them. We have with us Honorable Mr. Justice Arjun Sikri, former judge of the Supreme Court of India, currently international judge at the Singapore International Commercial Court. We have Professor Dr. Pip Nicholson, Dean of the Melbourne Law School, University of Melbourne, Australia. We have Professor Dr. Vijay Kumar, Vice Chancellor of the National Law Institute, University, Bhopal in India, and Honorable Mr. Justice Michael Wilson, Judge of the Supreme Court of Hawaii, United States of America. I'm very grateful to my colleague, Professor R. Sudarshan, Dean of the Jindal School of Government and Public Policy, who has kindly agreed to moderate this session. When we conceived this conference, one of the things that we were very conscious of is that to what extent the role of regulatory bodies and courts are significantly impacting and shaping the consequences of the pandemic itself. And this juxtaposed with the context of to what extent law schools and legal education should prepare our young people to be part of this process was also equally important. So that led to the creation of this particular thematic session, and we are very excited that we couldn't have found a better group of people representing the legal community, including the judiciary, but also academics who will be engaging in this conversation. I'm going to give this session to Dean Sudarshan to moderate it. I'll be back shortly. Thank you very much.
Thank you. Thank you, Raj. It's a real pleasure for me to moderate this session on regulatory bodies, particularly in the context of the pandemic situation. We have a well-balanced panel, I should say, with two academics and scholars and two judges, although it's not quite well-balanced gender-wise. We'll try. And this is a very important context because, you know, the regulatory bodies are important to maintain quality and standards and to have some kind of a uniformity across different institutions that are engaged in legal education and education in general. But the pandemic has posed severe challenges, and we want to explore how regulatory bodies can cope with these challenges, particularly with the introduction of technology. So I know Professor Nicholson's worked on the implications of technology. There are different platforms that we use for teaching. There are concerns about privacy. There are concerns about you know, the multinational or scope of these platforms, whether what's said on them is well protected. You know, for instance, the government of India does not use Zoom because it has concerns about security vis-a-vis the platform we are now using. So if we had somebody from the government, we wouldn't be able to have them on this Zoom platform because the government has decided not to use it. And there have been concerns. So there are all of these concerns as well. And there's a very important concern about students and how to get feedback from them. The regulatory agencies typically don't generally have avenues and modalities to consult with or to take into account concerns of our main constituency, which is students. And so some reflections on that going forward, how we might do that would be wonderful and welcome. So I'd like to, you know, also mention that, you know, the judiciary in India particularly, I don't know about Hawaii, but in India, the judiciary has very often had to intervene in decisions made by the regulatory bodies, particularly the University Grants Commission. and sometimes state governments in terms of what they propose to do with education. And very recently, for instance, the UGC said that in the context of the pandemic, they may dispense with an end-of-term exam for law students, and the Supreme Court intervened and was concerned that that needn't be done. So in many contexts, whether it has to do with affirmative action, which is a classic instance of judicial intervention in UGC or decisions of universities. So the judiciary is a big actor, and so it has an important role in keeping regulatory bodies on their toes. And so it's wonderful to have two judges on our panel. But I'd like to begin first with Professor Pip Nicholson on these challenges, particularly how are we to prepare to cope with these technological issues, and in fact, what contribution could the law make and legal education in this context, because it's very important to get that sorted out first, because we've become so dependent on technology, and it's very important that technology is properly regulated, and there are laws and clear rules about it. So why don't you start us off, Professor Nicholson, and then we'll move on about 3, 4, 5 minutes. Thank you.
Sure, lovely, and thanks very much. And welcome to all of those who are participating, and we look forward to your questions. I think the pivot to what I call the virtual classroom in my own case in Australia happened in 2 weeks. In March, we indicated that we would move online, and 2 weeks later we commenced teaching on fully virtually. And there's a separate story which your question doesn't draw on how we engaged with the regulatory authorities here around that pivot, but I'm happy to talk to that later because it was actually a very constructive experience. But we also had to work through very quickly our engagement with technology and the delivery of classes. And ultimately the decision was made to privilege synchronous teaching so that there would be the use of lectures that would be recorded, imagining a flipped classroom modality, because traditionally Melbourne has taught entirely through the seminar mode and a dialogical mode, but we had to revert to a flipped mode. And my staff commenced building lecture content, activities and group work online, but with a commitment to continuing synchronous classroom exchanges. And for that, we used Zoom. We used the technology that we're using here today. We have reflected on how this changes the privacy of the student and also the privacy of the lecturer. And one of the considerations is what you do with film if you were to take film, and it is our very strong view at the moment that you ought not. The privacy of the home of both staff and student ought to be protected. But we reflect on collecting and sharing the questions that come through the group chat, the questions that come through group Q&A, because they can be very useful pedagogically for students to reflect on. And also there's a variation of approaches to the audio. But that's one of the first considerations which we had never had to make when we bring staff and students together in a neutral space. Obviously, there's the ongoing protection of IP and teaching materials. There's the ongoing use of security mechanisms through our teaching and learning platform. And in the case of this university, we use Canvas. But I think looking ahead to the question of regulators, for me, there's a separation out around who is the university accountable for the quality of its teaching and who is the university accountable for the substantive quality of its teaching of law. And they're treated slightly differently in this country. But they were some of the preliminary privacy issues that emerged with the pivot to synchronous teaching using a platform such as Zoom.
Well, thank you. I'd like to turn over to Professor Vijay Kumar to, because like many of us, he's dealing with the situation where there's such a diversity in the student population, their backgrounds, where they come from, how many of them can access this mode. There are important challenges and related to equity of access to education. And so we need mechanisms, I think, to keep a tab on how that's going, make changes in order to reach out to certain students who are unable to, say, come on a platform like this. So these are all concerns that I'm sure Professor Vijay Kumar deals with on a day-to-day basis. So could you reflect a bit on those challenges, Professor Vijay Kumar?
Yeah, thank you, Dr. Sudarshan. Good morning, Justice Sikri and Judge Michael Wilson and my colleague Pip Nicholson. It's interesting to discuss these issues openly. I don't think I would like to hide anything. India is a vast country and we have around 1,600 plus legal education institutions. And from 15th March when the lockdown began, the law schools, the law universities, about 24 of them, we have students from all over the country. And some of the law schools also have people from other countries as well. And we are all residential in nature. So evicting them from the hostels and seeing them off was the first task that we had to undertake during this pandemic. We never bothered about the covering of the syllabus for another year, another month and a half for the final examinations in May, June. That I think we never even looked about it. But subsequently, when we started looking at it, let me tell you, it was a huge problem for the law universities in the first place, the regular universities offering law courses, and innumerable private and public law colleges all over the country, which possibly may not have these type of sophisticated instruments, required bandwidth, and therefore the sufferers were the students by and large, because the teaching learning process possibly was not complete. Even in many of the law universities that I represent of, you can see that what we did for 1.5 months for substituting the physical classes was something in the name of online classes. But there was nothing called as online classes. The teachers used to send these PowerPoint presentations to them unexplained, and there was no method of recording and sending the lectures to them. But the summer vacation gave us, and we also realized the seriousness of the pandemic. And therefore, we had to redo the whole lot of things. And we had to, as the law institutions, universities in this country, invest lots of money in technology, in buying laptops for the teachers, because the old systems possibly could not take the load of the present systems. So I think the software process, the bandwidth required, the hardware, and we had to undertake all types of things in the next 2 months. And when we started the next session for this academic year, it was really wonderful. I never thought that we'll be speaking to the students the way that we do in the regular classes. Of course, there is a huge vacuum in the residential universities like ours, where without the students for 8 months, we are also going bonkers. Mm-hmm. So therefore, I can understand the feelings of the youngsters who are not out of their homes for quite some time, and they're all raring to come, but unfortunately they can't do so. But technology, to some extent, Dr. Sudarshan was absolutely right. We have to reach out to students. As I mentioned to you, they are from all over the country. And there are some people from the rural areas, some of them from Jammu and Kashmir, where there is nothing, no connection that is available beyond 2G. And therefore, some of the law schools, like the Nalsar University in Hyderabad, they recorded everything and sent the pen drive by post to those people who could not access the internet-based classes. So therefore, the law schools are able to do it. This is what you call it as the cream of legal education in this country. But looking down, the colleges run by the universities and the private colleges. Many of the private colleges have wonderful infrastructure. Possibly they could have done it. But many of the public and private law colleges in this country possibly would have failed. I am very confident that they are not able to do anything meaningful. And therefore, it is a huge exercise. In one sense, I do appreciate the positive side of pandemic, because in every challenge, we have to see an opportunity. And that opportunity is this platform in which virtually we are meeting each other, and we are able to deliver goods to the students. Let me tell you, what we did in the first 3 months and what we are doing is absolute U-turn. It's absolute U-turn, and it is really marvelous. And the students are also able to interact. The students are organizing webinars. They're organizing moot court competitions. They're organizing almost every type of competition as if they are physically present on the campus. So these challenges also brings in what you call it as the talent that is required. And this is the time many teachers and maybe senior teachers like us, we also got hooked to the technology, which we never did. So therefore, it brings everyone together to understand the issues properly and effectively. And I think many of the Western universities were really good, really marvelous. They declared that till May 2021, they are not going to have any physical classes. But unfortunately, in this country, with too many regulators around, we were not sure that every month it gets postponed. So the classes will commence in July, August, September. Now up to December, you may open, you may not open, subject to all conditions. I think we have lots of our own, imposed problems on us. But I think it is a marvelous area through which now we are able to interact with many students very meaningfully, including we are addressing the psychosocial problems the students face. We have a counselor appointed on the campus, and she is in touch with almost all the students whenever they have some problems. I think these are all the things which I don't think during the regular times we would have done this. But really, this is marvelous. But there are issues. For example, all these lectures are recorded. And if they are recorded, I don't know whether something could be commercially sold afterwards, or whether there are issues of privacy. Because I do hear some complaints from parents. Oh, your teachers can't even pronounce the words properly. How can they teach? These are all issues. I think it's a challenge, but I think people will come out of it soon, right? For the next another 3 to 4 months, I don't think any physical classes possibly would take place. I'll stop here. I'll get back to Sudarshan a little later.
Thank you very much, Professor Vijay Kumar. And thank you for infusing an optimistic note. Indeed, it's true. For instance, in my School of Public Policy, we've had a board of advisors, international advisors. And what we would do is when they happen to come to Delhi, we would invite them and have a consultation. And it never occurred to us that this is a platform that we could have always used at any time, really, with an international board. So many of us are discovering the possibilities that this platform offers, notwithstanding its downsides. But I think on the whole, it's good to be upbeat about this. And I'm glad that, your students in the Law University in Bhopal, have your leadership and the concern for them. I want to turn to Justice Sikri to ask, what is, why is the judiciary involved? You see, there is the Bar Council regulates legal education. The University Grants Commission regulates all other education. So it's only some professional courses like law, architecture, medicine have come under a different regulatory regime in our country. But the link between legal education, lawyers and judges has always remained very strong. So I'd like Justice Sikri's reflections on, what ought to be the stance of this regulatory body that's concerned about legal education in this particular context. And is, in your opinion, enough being done? Are there people thinking about what regulations are appropriate? How are we to help legal education institutions in their work?
Thank you, Dr. Sudarshan, and first, good morning to everybody. It's a very important question in our Indian context. Let me first explain in a minute or so the legal regime behind this regulatory process. And then I would come to where the law schools and law universities and legal profession, and then judiciary, that how that relationship comes into being. Now, as you know, there have been various regulators, which we call sectoral regulators now, and particularly after globalization in this country earlier, so many, I'm not talking of education for time being, but general comments, that up to, we know 1990s, etc., it was the government regulation in so many sectors, whether business activities or other activities. But with the opening of the economies, etc., and the many changes were made and statutory regulators were brought in. And these are in every field. You know, it is in insurance, it is in telecom, and all other sectors. Now, you see, the question is that they are regulators, they work within their field, no doubt, and they are experts in their field. This is also, I mean, we have to keep in mind, and we have to keep in mind the role of these regulatory bodies also, which are independent and have been created in most of the countries through statutes, etc. And they are to work, but within the parameters of specified regulatory objectives in each case. Now, in our country, as you know, there is a power of judicial review, which is given to the courts. So therefore, in the exercise of power of judicial review, the courts can ultimately go into the functioning of these regulators as well. So that is available. The question that arises is that to what extent such a power has to be exercised. And that becomes a very, very important question. And if we see the, the law which has developed in this country, and which is elsewhere also in European countries, UK as well, America and all, and which principles are followed here as well, that normally it is not because they are the experts in their field. And while undertaking the, exercise of judicial review, the court is not to go into the merits of the decision, but the decision-making process. It is what is to be seen is whether principles of natural justice are followed in a particular case, or whether the guidelines which are provided under the statute, they were adhered to, etc. So it is, as it is said, Westbury's principles of, either fairness is one thing, or which is now incorporated, is that it is on 3 parameters, that illegality, proportionality, and etc. These are the aspects. Now, having said so, when we come to legal education, as you very rightly mentioned, Dr. Sudarshan, that I would say bonding also and relationship also goes into a different tangent, and different, because it is from law schools that people come into the profession, they become part of the legal system, of which judges are also a part, in a part of judiciary. And it is from this, legal system only the judges are appointed. So the connection between these 3, when it comes to law, assumes a totally different dimension. And therefore, maybe psychologically or otherwise, as the judges feel that, look, they have a larger role and more important role to play. Of course, when we come to sectoral regulation, insofar as legal education is concerned, we have UGC, which is in a way generally regulating the education of all types. And specifically, when it comes to legal education, we have also Bar Council of India, which is a statutory body. Now, so therefore, what happens is, and as you know, because the issues involved are of the students or of lawyers or budding lawyers, and they have all connection with the legal profession also. So they would try to, in comparison with other sectoral regulators, or as is rightly said, other branches of law, other branches of education, here the tendency is also to approach the court on the drop of the hat. But when the matter comes to the court, court has to decide. And in a case like this, the question that arises is, what kind of control should be there, or what kind of exercise of judicial power which should be there while dealing with this. Now, as far as policy matters are concerned, it has been accepted, as I said earlier, that that is the forte of these regulatory bodies, and courts are not going to substitute their judgment into that. But again, when it comes to legal, maybe wittingly, unwittingly, knowingly, unknowingly, because the judges also know about legal education. Because when it comes to, if it's a matter regarding, say, engineering or medical, the judges may not have knowledge. But when it comes to, I've seen, like, for example, when even the exams and some exam in a university or exam of even judicial, appointments, etc., when it comes to the court can look into the questions, whether the answers are right and not, although they will not do this exercise when it comes to medical, because they don't know anything. So they will say, no, those people, they know better and they will do their job. But when it comes to this, they will go into the merits also of the exercise, as I said, maybe unwittingly. But then, having said so, what happens in the context of, if you know, here also the Supreme Court had interfered recently in a matter, but then that became important in that case because of the dispute between the two regulators, or regulator on the one side and the government on the other side. Like if you remember, the question was whether the student should be upgraded to the next classes without any exams. UGC stood the ground and said, no, sorry, under the regulations, there cannot be, the exams will have to be there, maybe little late because of pandemic, etc. Now, many state governments and many state universities said, no, we want to cancel these. So therefore, it is the dispute landed before the court, not because of any other reason, because of the difference of opinion between these two, and naturally, and students also did not want that, no, we don't want to take exams because of this pandemic and the threat of exposure to this COVID-19, physical exams, etc., should not take place. So all those issues did arise, and which had to be settled by the court. So once such issues would arise, it is ultimately the court who has to settle. Of course, as I would say, it is not necessary to state in detail what happened in that case, but to some extent, some kind of balancing approach was adopted by the court. But what I would say at the end, when these such issues comes, that of course the wisdom of the regulatory bodies have to be kept in mind and have to be respected. At the same time, it has to be a collaborative decision making for the betterment of the students. That should be an approach of the judiciary. Thank you.
Thank you very much, Justice Sikri. For the benefit of those who may not know, Justice Sikri is known as the Professor Judge. And he was teaching in Delhi University and was one of the most sought after and popular teachers. But again, the regulator comes into play. He had to stop after 5 years because the Delhi University ordinance wouldn't permit a part-time teacher beyond 5 years. Now, one doesn't understand the rationale for a regulation of that kind. But somehow regulators seem to be able to hit upon regulations or rules. It's difficult to fathom why or what's the rationale for it. So with the result, of course, subsequent classes of law students in Delhi University, missed out. And so this, but he's well known as the Professor Judge. And I now want to turn to Justice Michael Wilson, because you see, one of the things, Justice Sikri explained why it is that there is a natural tendency for members of the bar and the judiciary to take an interest in what's going on in legal education. However, but legal education has itself changed. It's become very interdisciplinary. I mean, you would like legal education to have a very strong emphasis on understanding climate change, environmental issues, and you can't call yourself a qualified lawyer unless you're sensitized to that kind of a subject. So I would therefore ask you, what are your reflections about what a regulatory body for legal education ought to do in our current context? Both, you see, as we are in an age where the planet is threatened and there is this pandemic. In all of against all this background, do you think there's need for some radical reform in the way regulatory bodies approach legal education?
I appreciate that question, and you know me well, Dean Sudarshan, or Brother Sudarshan. Let me say aloha to Professor Vijayakumar, as well as Professor Nicholson, and my friend who I look up to tremendously, Justice Sikri, who I do think of as a professor as well, because what I'm going to say, you can tell, is in a way, a real request for maybe some feedback, perhaps at a later time, from all of you, because you are architects of education and a contemporary moment in time when the contemporary moment is a strange one. So with that in mind, let me talk about the strangeness that we perceive on our court here in Hawaii. Understand that we have one law school. Oh my goodness, you can imagine what the relationship is between our court and the law schools. We're ready to take over. Let the professors get out of the way. We can explain what the curriculum should be. We can talk about what kind of computers they should have. So it's, from a professor's point of view, a bit of a challenge. But also, we are the most remote landmass on Earth, and that causes us to be somewhat introspective. So what is happening, though, is a almost mirror of what's going on with India and perhaps as well with Australia. In other words, we have law students who are now looking at future education in a way that no lot of students have before, and in the midst of a society that's changing so rapidly. And that means that the challenges that we're facing at the moment have to be seen in a broader context involving the future. Justice Chandrachud spoke about that in his valedictory address. So our court, our Supreme Court, has to look towards the future. What are the trends for the future? For justice. My goodness, if you were a billionaire, you know, the Bloomberg Index keeps track of billionaires. So that since the beginning of the year, this has been a great year. A really good year. 23% return on investment if you're a billionaire. Almost unprecedented wealth creation. One of the more controversial billionaires that we have in the United States you've probably heard of, and that is Elon Musk. And just in the last year, and much of this has been in the last few months, his wealth has increased $100 billion. So there's a trend of great wealth and great influence. And I know, because I've learned from my brothers in India, how much that other part of the population that Justice Chandrachud spoke about is doing, because it's sort of the reverse in Hawaii. We have the highest unemployment. We used to have approximately a year ago, we had the highest employment. Now we have the highest unemployment. And we don't have a lot of emergency room space. So the trend with respect to justice is such that this tendency that's happening in the United States, where there's a lack of access to justice for those who can't afford it, is accelerating. And the influence of those who are in positions of authority and wealth is increasing. What does that mean with respect to regulating from the point of view of a court? We had to decide what was going to happen with the BARSA that was being given to our students here as well. Well, Justice Chandrachud said the financial crisis of the pandemic cannot justify overwhelming economic oppression. We have a lot of law students that can't really afford to go through this process again of taking the bar. So we had to postpone the bar because of the amount of COVID. Then do they have to take the bar? And if they take the bar, as Dean Sudarshan has alluded to, should they be close together? So to wrap up my point about where we were a divided court. There were those of us who felt they don't need to take the bar. This is a good law school. And look at what's happening to the part of the population that is focused on justice. You know, it's of course an open secret, perhaps, but it's nonetheless an open point to all of us. Lawyers are the handmaidens of the powerful. And the powerful are more powerful. And the wealth available to court the best law students is even greater. So yes, maybe there should be some serious reform where when the court intervenes and says in the curriculum it's going to happen, it's important to pay attention to the underprivileged, the disadvantaged, that part of the population that defines justice, because that is harder to reach now. And the students that care, the students that will define who becomes judges, because as Justice Sikri said, I mean, I have advocated actually this rather eccentric process of selecting judges in India where the judges select the judges. The court selects the judges. But what you end up with at least is a way of identifying people that are committed to justice. And so I'm an advocate now of don't require a bar here in Hawaii, because that will allow those that can't afford to take the bar to take it, because they can't take it more than once. And even more to the point, those that don't do so well on the bar often are from a disadvantaged background, but they're committed to principles that are more important than ever before. It's more important than ever before for society to have individuals that will attend to what is an increasing potential, if not reality, of injustice in terms of human rights, and also a potential increase, and I think a very dramatic increase in the violation of rights of future generations because of the fact that the regulatory agencies as well as the courts have not been responding to this existential threat of climate change. And if they're isolated in individual rooms and they're not allowed to mix with society and they're not allowed to represent that part of society Justice Chandrachud emphasized, it's in a pluralistic society, it's a society that needs to have recognition before the courts, and it needs attorneys that will take those very important emerging social issues before the court. So I'm really concerned about the virtual nature of the education as well as the restrictive nature of the education, and that it does not seem to assist disadvantaged societies nor the attorneys that have justice in mind when they go to law school. So
Thank you.
Thank you.
Thank you very much. That's important reflections. I want to turn back to, there are a number of questions now that people have posted. I'm afraid I can't take all of them, but I wanted you, Professor Nicholson, to complete the thought that you hinted at, which is the dialogue you had as the Dean of the Law School and the University with the regulatory body in Australia. Very quickly, if you can, tell us about the outcome.
Absolute pleasure, Dr. Sudarshan. It's a very interesting story. The Victorian Law Admissions Board is our regulator administering a national uniform scheme that only 2 states have signed up to at the current time, New South Wales and Victoria, and Western Australia to join relatively soon. So we call that regulator VLAB. VLAB reached out to us in the middle of March and said, we recognise that you will be transforming legal education. We want you to consider what you need to do and then articulate for us how you will meet the requirements that are set out under the Legal Profession Uniform Law Application Act, meet our admission requirements, accreditation requirements. And so we set up a committee of 3 who worked across every subject, looking at what the substantive learning requirements were and what the attributes, methodological attributes of the student needed to be, and how we would deliver that, and then documented that back into our regulatory body a month later. That was a very large piece of work. concurrently with that, we were, as I described before, flipping our teaching and moving online. And I do note the very prescient comments about the difficulties that posed for students who are less resourced than other students, and the commitment the university and the school had to do to make sure that students had both laptops and access to IT infrastructure. But the challenge is arguably slightly less than I can fully appreciate it was for the schools and students of India. So that the equity considerations were live. But having documented our changes to the regulator, they accepted those. And we didn't propose to cease assessment. We proposed to continue teaching and to deliver assessment, albeit in very different circumstances. Some of the law schools across the country suspended for a week or two and ran a week later in order to do the reconfiguration of the teaching. In our own case, there was a decision across the university to delay for 1 week and run the semester 1 week longer. The law school itself resisted that, but nevertheless, that's what took place. At the end of the day, I think what really helped in our relationship with the regulator here, and where Australia is somewhere between the Hawaii example and the Indian example, 39 law schools across the country, say 6 in my state. And there has always been, at least in the recent past, a very transparent process around accreditation. And that transparency and the clarity of the requirements and the clarity of a process to demonstrate that you've met those requirements meant that it produced what I've, on reflection, preparing for this, thought of as agility and trust between regulator and schools, at least in this state. And so, you know, we document on the papers how we meet those continuing requirements, and they trust us to deliver those undertakings that we give through that process. I've got to say, not every state in Australia reached out to schools in the way they did in Victoria, and I really commend our regulators for that. And I know we've got short time, a very quick extra comment. Our regulatory body is led by a retired judge, includes a judge of the Supreme Court, and then the profession is represented, the bar is represented. And that's breeds structurally a consultative forum at inception. And there is a tendency lest we simply don't have the litigation that Judge Sikri pointed out is endemic, and the sort of hyper involvement of both students, governments and regulators in testing the legislation. It's not present in Australia in that way, and certainly there's no litigation in Victoria at all. Although there's a mechanism for judicial review, it hasn't been tested. So I think a lot of it was trust, transparency and agility were the things that really assisted us at a very critical moment. And my heart goes out to all of you working in a system where there is a litigious streak. It must really complicate things for the deans of law schools of India.
Thank you. Thank you very much, Professor Nicholson. Very important observations, which leads me to ask Professor Vijay Kumar. You know, the National Law School of India, the first director was Professor Madhav Menon, who we sadly lost. But he was in charge of legal education in the Bar Council. So he moved, as it were, I mean, he had to be persuaded to take up the directorship of a very innovative and new adventure with the National Law School in Bangalore and the 5-year program. So Professor Vijay Kumar knows that well. So I'm going to ask him that if he were in Professor Menon's place in the legal education part of the Bar Council, you know, what thoughts would you share with them in this context?
Right. Thank you. That's a very tricky question, Dr. Sudarshan. I appreciate and I envy Professor Nicholson for the proactive regulator that they have in Australia. And as Justice Sikri mentioned, that we have too many regulators in our country. So therefore, to very quickly suggest something, it's very difficult. I have been on the Legal Education Committee of the Bar Council that drafted the first set of rules way back in 2008. So we brought in some shape to legal education through that. And I was also part of the second regulation that is being now sent to various law schools for vetting, right? The revision or acceptance, comments, whatever it is yet to come into force. But I think the second policy is also already on the web, and many law schools are supposed to respond to that. Now, this is one issue which whether the Bar Council should govern everything is something that we need to look at it. I would also just flag in something because the question is on what I would do in the place of Dr. Menon. Justice Sikri is also present here. I would like to take invite his attention as well. The new National Education Policy 2020, which has been rolled down by the Government of India very recently, is bringing lots and lots of what do you call it as spirit and life into higher education system in this country. And therefore, but very carefully, they have excluded legal education and medical education out of its purview. So it is time for the judges, the lawyers, and the academia to sit together to frame a regulation, a set of regulation, where I think not one single body should be given the authority to determine, and it should not come from above as a dictation. It should be through the process of consultation with all these three. Justice Sikri was absolutely marvelous and right. The law students first, the lawyers second, and the judges who are all, it's a link, it's a continuum. And all the three must play a major role in deciding a single regulator for this country, which we don't have a law. Of course, Justice Sikri will also appreciate that the Bar Council has been given the responsibility only in 1971, not before that, because Bar Council is created under the Advocates Act, which comes only after the courses are over. So they cannot be our regulator. So these are all issues, but still we have accepted. But time has come under the new education policy, and with all the diversities that we have, very quickly to capture one or two issues of the policy, that the autonomous universities, single faculty universities like the law universities, 24 of us, will also transform into multidisciplinary university by 2035. So as Vice Chancellor, as leaders of these educational institutions, we have a lot more responsibility of integrating the other disciplines also, which we have done. In many of the law schools, you see interdisciplinary courses are being taught the best. So therefore, we are not hesitant in doing that, but the phase that it is a law school, a law university, that tag will vanish in the next 15 years. So therefore, the regulator, which should represent all these three bodies, the students also should be taken on board because they are the affected interest. And through the process of consultation, we should have one single independent regulator to emerge in the next 1 year. Once the pandemic goes out, I think there will be a wider consultation with all these three stakeholders coming together, and that is going to create a different type of development in this country as far as legal education is concerned. I'll stop here. If there are any questions, I'll be too happy to respond.
Thank you very much, Professor Vijaykumar, and thank you for bringing up the new education policy and its expectation that all universities would be multidisciplinary. Justice Wilson would be very happy about it because with emphasis on environmental concerns. Now the questions that we've got quite a few, but interestingly, they are questions that are directed mostly to the courts and the judges, which is first one question is about, or one set of questions are about courts conducting their proceedings online. I mean, the legal education is one thing, and the risk of some inequities in that, because we've had currently many, and they are reflected in many comments that viewers have had. How do judges prioritize cases? Because in this online mode, the usual ways of determining which cases are taken up may change. And there are concerns about equity there. They think that, and the role of the Chief Justice as the master of the rolls, determining which cases will be heard by whom, kind of thing. So there are a set of questions about that. So, in deference to those questions, I'd like Justice Sikri to give us a few reflections about that.
Actually, it's as you know, Professor Sudarshan and Professor Vijay Kumar also from India, and everybody, that this is a very hot topic, much talked about in recent times because of various reasons, and I need not go into that. At the same time, yes, COVID-19 situation, which has, one thing which was triggered because of that was that the hearings started taking place only in a virtual mode, initially particularly. And so therefore, it was only through video. And as physical courts had to be closed because of this pandemic, like all other institutions, including law colleges. But at the same time, as very rightly pointed out, those who want to put these questions and want to ask this question, is that this justice delivery is also one of the services, if I may say so, which is an essential service, because so many issues which would keep arising, like in this case, and which have arisen even because of pandemic. Like we gave the example of this, whether the exam should be held or not because of pandemic, and the issue landed up in the court. So, and the issues of personal liberties, etc., bails, which had been the subject matter of discussion in our country, and so much of debates on that, those issues would be there, and therefore the access to justice has to be there, and speedy justice has to be there at the same time. So therefore, on the one hand, the courts are not able to function in its full strength in physical form, and the courts are having few matters. Of course, over a period of time, with the partial lifting of the lockdown, some physical hearings started, and even our, as it happened in education, it happened in on the legal system also, that over a period of time, the virtual mode of conducting the hearing also improved. And today I've seen many, even Supreme Court or many high courts, particularly I know Delhi High Court and some other high courts also, who are almost working, if not to full capacity, at least 70 or 80% of the normal capacity, they are working like that. But then in the whole process, when the cases cannot be taken up in a regular manner or in a routine manner, then the question arises, as you put, that how to give the preference to those cases which need immediate attention, and the cases which can be delayed or which can be taken up later. In India, COVID or no COVID situation, we have this kind of problem always because of the arrears in this court. Today, there are in our courts, from Supreme Court down to district courts. Of course, the figure is much more in district court, but the total cases, I think Michael knows it, whether Nicholson knows it or not, that 30 million cases pending in India. So if that is the backlog, and in each court, the dockets are overflowing, which case should be given primacy or which case should be given preference has always been an issue. It's not that it is now. Yes, it is reflected now. But question that arises is that, of course, like if I take the example, which may be in the mind of the person who has asked this question, that Arnab Goswami and bail granted to him within 24 hours, Supreme Court did that. So why it should not be extended to others? So therefore, what I feel is, as a master of roster, Chief Justice, either Chief Justice of India in the Supreme Court or Chief Justices of various high courts, etc., they should come out with a clear policy on this. It has become very, very important, because the court should not be, the subject matter of ridicule on this, and the courts strive on the trust of the people. That is very, very important. As it was said by American jurists long ago, that the judiciary has neither the purse nor the sword. and it is only the trust of the people which makes us going. So therefore, in order to assuage the apprehensions and feelings of the people at large, that there should be some policy, some norms should be laid down by the courts that how matters should be taken up, so that there is a transparency. Today, the problem is little opaqueness in this. That is creating the problem. Maybe not that the courts are internally what is happening is wrong, but it is not known to the people. So therefore, once there is a transparency, there are proper norms, proper guidelines, how the cases would be listed, which kinds of cases they may relate to personal liberties of the persons, they may relate to social justice, like or the issues, emergent issues arising out of pandemic only, like say, take the example of migrant laborers, which we face those problems, then where the justice is required to be done to millions of migrant laborers immediately. So such cases should be taken up. So, but then there should be a clear-cut policy, I would say, in order to avoid such debates in public, and the court should come out, more cleanly on this.
Well, thank you very much, Justice Sikri. That's very important advice. I'm sure that judges will pay great heed to what you just said, the need for clarity and transparency in how difficult choices are to be made. I'd like to have Justice Wilson say the last word. We are coming to the end of our session. Thank you. Justice Wilson attributed, referred a lot to Justice Chandrachud's talk in our conference, and the need for looking at justice from the vantage of the voiceless and the weak, and also to have an adequate reflection or representation of society on the bench, the diversity aspect. But with respect to this set of concerns about prioritizing cases, any reflections on that? Because most of the questions we've got have to do with this. There's a great anxiety and concern about how is it that issues are prioritized. The docket may be large, but you still have to deal with some matters on an urgent basis. And if that is so, what criterion of urgency would you apply, Justice Wilson?
Well, I think that this asks a question that is a telling one, as you have pointed out, Justice Sikri, in terms of how society perceives judges. How far do we go in distancing those that dispense justice from those who seek justice? Some of it's straightforward, although unfortunately, as straightforward as it is, it doesn't seem to be getting a reaction from courts that might be commensurate with the Constitution. All of us deal with constitutions. And when you think of the core rock solid principles of justice, it has to do with taking people's freedom away oftentimes. So without question, I think it's necessary to provide priority to those who are facing the possibility of freedom being taken away. And in our court, for example, there's great controversy about the concept of taking away the right to a jury trial for an indeterminate period of time. It's greatly, I think, undermined the degree to which the courts are seen as doing their job. Because we have big buildings, we have spaces, it's possible to have a jury. Similarly, if you are accused of an offense, it is also an iconic principle that it's important to see the person. Of course, it's also important to see the judge. So I would submit that in the criminal context, it is important, and we should never lose the significance of in-person proceedings where the judges can be seen as well as the accusers, and the fact finder, whether it's a jury or a judge, is watched as they go through the process. And this creates a certain amount of transparency. There's desperation and there's fear growing There's no doubt about it, around the world. And the courts are the possible reservoirs of a sense of solace and a sense of justice, but not unless there is some notion that there is going to be a new renewed commitment to allowing for a kind of judicial process that is personal and not getting more and more distant. So yes, we prioritize constitutional rights that deal with the freedom of individuals as a significant way of prioritizing our cases.
Thank you. Thank you very much. I'll now invite Vice Chancellor Rajkumar to join me in thanking all of you. It's an enormously educative and interesting panel. Thank you all very much for sparing your time. Over to you, Raj.
Thank you very much, Dean Sudarshan, for so skillfully moderating this panel. Thank you to Justice Sikri, Justice Wilson, Dean Nicholson, and of course, Vice Chancellor Vijay Kumar. So many important issues that were discussed in this particular panel has resonated across the conference, but also beyond. I am really grateful to each one of you for taking the time out to reflect, but also to answer and respond to some of the questions posed by the audience. This session is over. We will have a short break and we'll move towards the 23rd thematic session of the conference, Role of Law School Systems in Ensuring the Health and Well-Being of Faculty and Students. Thank you.
Thank you.
Good morning from India. Good afternoon to our friends in Southeast Asia. Good evening to our friends in Australia. It's such a pleasure to host all of you on the third day of this global virtual conference on reimagining and transforming the future of law schools and legal education. It is my distinct pleasure to welcome all of you to the 23rd thematic session of this conference on the theme, Role of Law School Systems in Ensuring the Health and Well-being of Faculty and Students. We have got a fantastic group of individuals who are leading institutions and also made significant contributions to the theme of this conference itself and indeed this specific theme. Let me begin by introducing my own distinguished colleague, Professor Dr. Sanjeev Pisani, Principal Director, Jindal Institute of Behavioral Sciences and advisor to the Vice Chancellor of OP Jindal Global University, who has kindly agreed to moderate the panel. Thank you very much, Dr. Pisani, for being here. We have a great pleasure in welcoming Professor Fiona Road, Deputy Dean Academic of the T.C. Baird School of Law, the University of Queensland, Australia, which is one of our close partner institutions. We have with us Professor Dr. Natalia G. Prisakina, Vice Dean of the FEFU School of Law at Far Eastern Federal University in Russia. We also have my own colleague, Professor Dr. Kirti Nakre, Professor at Jindal Global Law School at OP Jindal Global University, India. And of course, Professor Dr. Aid Maman Suherman, the Dean of the Faculty of Law, General Sudirman University in Indonesia. I look forward to engaging in this conversation. This particular session is so critical as this has laid the foundation for the way law schools need to be governed in relation to addressing the issues surrounding mental health and other aspects of health and well-being of the faculty and students. I would like to give this panel to my colleague, Dr. Sani, who will be moderating this panel. I'll be back in 55 minutes.
Thank you very much, Professor Rajkumar. And, I just want to say one thing that I must have attended over 500, 600 conferences by now, but this virtual conferences, although it's a new phenomena, but having a 30 sessions and all the sessions starting on time and finishing on time with very eminent, distinguished, accomplished person, my hats off to you, Professor Rajkumar, for it. Coming to the topic, I want to introduce to you about me. I'm basically a psychologist, and that's why the mental health conditions, especially for the students, and I will talk a little more about the younger students, is very critical at the moment. Why? Because, all the schools, once we have the lockdown in the last week of March, and, immediately one good thing happened that most of the schools have transited to online learning, and it was successful. What we were thinking that how we will be able to cope with this, because none of the school teachers were ready or have been trained for online learning, but it still worked well. But now with 8-9 months online, the smaller kids are spending 2, 3, 4, 5 hours on internet. And as a psychologist, I'm sure that most of them will definitely become an addict to internet addiction. That is one. Second, yes, it is a time of uncertainty. And as a psychologist, I'm also too, when after World War II, major psychological disorder was discovered as a PTSD, post-traumatic stress disorder, then this is the time which is having a similar kind of stress, if not trauma. And now in that case, if this particular stress can lead, not now, not tomorrow, maybe after a few months or few years, people may develop some sort of a psychological disorder. Now, coming to the students and faculty of a higher education. Now, we all know that it's not that students learn only from the faculty. Students learn from their peers. Student learns from interpersonal interaction. Student learn from the environment. That is missing from last 8 months. Not only students, think about the faculty. Now, the faculty which they are into the hard sciences, they have no access to their laboratories. think about that the faculty which was coming and conducting regular interactions is missing. So it's a mental health, emotional well-being issue, which is for everyone. So faculty and students are also suffering to a great deal. Just to let you know, 192 countries have stopped their educational institutions to the students. And this comprises 1.41 billion students. They don't have an access. So this is a UNESCO figure. But the place like India, where it's a poor country and not everybody has a gadgets, not everybody can study online, and many students are being deprived of that. They are also going through certain psychological issues. It is a cause of concern, and today we are going to have a debate on it. There are a number of questions which we have sent it to you as well, but I would, because most of you are deans, vice deans, and senior professor, I would like to know what is the role you people can play as a leader in creating a virtual ecosystem that will ensure that students have improved emotional resilience to adapt to ongoing pandemic. So I just want to know in 3 to 4 minutes each from all of you that how you are dealing in your university and at your level as a position of the leadership. So may I request Natalia to start with, please?
Yes, can you hear me well?
Yes, please.
Great, great. Dear distinguished participants, it is my great honor and privilege to take part in this global virtual conference. First of all, I would like to extend my great appreciation to the Vice Chancellor, Professor Raj Kumar, for his kind invitation, and to all involved in the organization of this outstanding event. Our university, which is called Far Eastern Federal University, and you could see behind me a picture of the main building on our campus, and campus of the Far Eastern Federal University is located on a beautiful island, which is called Russian Island. And we are located in the city of Vladivostok. So if you imagine Russia, you know where Moscow is. Moscow is on the western part, and we are on the very, very, very opposite part, close to Japan, close to China, close to South Korea. This is where we are located. And our School of Law since December 2016 has been in partnership with OP Jindal Global University and Jindal Global Law School when we concluded our cooperation agreement. And since then, our relations proved to be strong and long-term, and we hope to develop working ties with your respected university and the law school. Speaking about COVID-19, we cannot be silent about the elephant sitting in our room. And I'm comparing COVID as an elephant, not because I don't like elephants, but because it's big and serious and strong situation. We have to admit that COVID-19 is not only a certain fact and a reason for changes in the political, legal, and socioeconomic regimes of life of national states and the international community. It is also a point of no return, as the pandemic interrupted the usual course of things and formed a new horizon of meanings, risks, and threats. I would say that for Russia, for Russian universities, in July of this year, the season of total distance learning, unique for Russian higher education, ended. And the summary is that Russian universities passed the stress test. Now they face a different and equally difficult task, I would say. The pandemic has become a challenge for the higher educational system. It was important for us to understand the problems universities faced during the period of remote work and how to work in the changed conditions. The experience gained has given impetus to the further development of Russian higher education, including the university digital environment. Speaking about our own experience, and it's different in the eastern part of Russia from the western part where the Moscow and St. Petersburg is located. The situation there on the western part is much harder. That's why most of the universities there, they were moved to the total distance learning by the students. And in our university, we had a time from March when we switched to distance learning and distance teaching with our faculty members and students. And in September, we switched to hybrid teaching, where 1 week of classes is conducted in classroom and 1 week of classes is conducted online. And most lectures are conducted online, where practical seminars, they are mostly conducted offline. And we conducted a feedback. We asked for the feedback from our students, and they say that for the time being, the hybrid system is the most useful to them.
Professor Natalia, I would request you that if you can let us know that what kind of a system your university has adopted to understand and take care of mental health issues of students.
Yes, we have, our university and the law school had conducted different questionnaires to our students, what would be the most difficult for them for the well-being and staying distantly at their homes, because even I personally spoke with my students and some of them said that it was really hard time for them and they went almost crazy without face-to-face communication. And in order to facilitate that, we used mostly technology, our websites, our communication channels. We provided hotlines for our students, and our students also have flexibility to speak with faculty members, with professors on a more frequent basis. And they believe that this is really a positive sign, because earlier they just had to come to office hours to see the professor, and sometimes the professor is at the meeting or anywhere else. And now almost every minute the professor is available through technological means, which is
excellent. May I now ask Fiona from the University of Queensland, Australia, that what are you doing to handle this particular issue?
In regards to handling the mental health issues, one of the things that I think it was actually really interesting preparing for this, because I went back and thought all the things that we've done over such a short period of time and had 4 pages of initiatives. So we were lucky that we went into lockdown, I think it was about the 23rd of March. We had 1 week to prepare to go the entire university online 100%. We, as part of the wellness program, we've had a well-entrenched wellness program at the university here since 2015 with our own wellness officer. So those things have been developed across a 5-year period. So we had a lot of things in place. And what we had to do was simply work out how to, I won't say convert, but transition those things and those mechanisms into more of an online environment. Everything here was done pretty much through Zoom. So first thing we did was actually the head of school, our dean, myself, and our 2 student leaders from the 2 student bodies, being Justice and the Law and our UQLS. We had weekly, what we called wall cabinet meetings with our wellness officer. There were 5 of us on Zoom. We had weekly meetings where we could get the vibe of what was coming from the students to us, and we could communicating back to the students with some of the things that we knew were coming down the line from up above, so that we kept communication really well open. We were lucky that our new wellness officer, who'd only started literally 2 weeks before the pandemic hit, was also an expert in video, taking the videos, cutting and editing the videos. So we've used a lot of our students. So we had students create videos on things like transitioning to online learning, what the changes were going to be for our online exams, navigating unemployment during times of COVID. So we did a lot of those sort of things to keep communication lines open with them. We ran our coffee mornings. We did it virtually. So the new students would sit there and have a cup of coffee and a conversation via the internet. So most of the things that have happened that would normally be happening, we were doing just in a different mode. And I think that seemed to help students. The student war meeting, the war cabinet meetings every week were absolutely crucial. I also made sure, as our Director of Education, that we had weekly meetings of my entire teaching and learning committee as well, so that we could make sure. The university itself also had weekly meetings for the whole of its chairs of teaching and learning across the whole university, so that everything that happened was communicated, I won't say all the time clearly, but the lines of communication were always open, the doors were always open, and we did notice a very big difference between students in semester 1 and 2 with the issues that have been cropping up. We were lucky. We've been back on campus since the 15th of June. We have a different hybrid model to Natalia, where what we have is all lectures are online now. We're running about 2/3 of our seminars and tutorials on campus face-to-face, and about 1/3 are fully online. We have noticed that student engagement is difficult, that online is being difficult for the students to continue to engage through the whole year, and we're now looking at mechanisms for that.
Great.
We also did a lot of fun, we also did a lot of fun things, like we had to send photos of ourselves at the age of 20 or our pets, and the students had to guess who we were or who owned that pet. So we sort of tried to keep a light-hearted side to it too.
Great. Before I come to Professor Ede, I would like to have views of Professor Kirti Nakre, who's a good friend and a sociologist. And the question would be a little different for you, because these days we are jumping on each other's toes at home, and domestic abuse and domestic violence has increased. Although there are not the number have not increased in terms of complaints, because of a simple reason, that 24 hours when all the family members are staying at home, so maybe people are not getting a time to give a call to helpline numbers. So that could be a reason. But government is doing a lot. They have put the forms in the in the daily needs stores and so many things. So I'm sure you must have encountered, and people must have spoken to you about this particular issue. And what is your viewpoint on this?
Firstly, I would like to thank everybody for this opportunity to speak at this conference with a very esteemed panel. And I won't take up too much time, but answering Professor Sahni's question, it's not just general people, but also India being a very patriarchal society. There are students who are undergoing or have reported domestic violence within homes, or aggravation of mental health issues within homes. And in my capacity in the past as the chair of the Disability Support Committee, and also as an ordinary faculty member in the university, I've always made an effort to refer students to the in-house counseling services, which has continued during the pandemic. And also in Jindal, we have the Your Dost app, and also which the students are being referred to. And also we had some small group work on assertiveness and also communication skills. So we did work with students on assertiveness and communicating effectively with parents and siblings, rather than getting aggressive as well. And also we tried to make sure that students had some kind of support systems in terms of peer support. So if they were going through violence at home, so we did try to informally reach out in the past to the parents and saying that, maybe this is not the best thing, and these are not good times, and these are tough times for everyone. So what has really worked has been communication and also developing skills in students to report. And we have been, because also as a university, we are aware of mental health issues and we are aware of domestic violence issues. I think students also have self-knowledge and awareness. Why the awareness is relatively better, so they do report at early stages when things can be mitigated and addressed in more constructive fashions. So we did do work on this, and also and we do try to refer students to helplines, wider helplines, if they are undergoing domestic violence or mental health abuse. And this is true of students of both genders or even beyond. It's not just female students who are going through a difficult time, but also male students. So we do understand the ecological context that India is a patriarchal society, and there has been an aggravation of domestic violence and also unpaid work, and especially students who come from homes where parents are working in the police or working in healthcare institutions. That has been a real challenge because they have taken up responsibilities of unpaid work within families and also taking care of siblings and younger siblings and all of those complications. So yeah, it is. We have been aware of it, and I think also the leadership in our university has been aware of it and has demonstrated sensitivity, but also has made an effort to keep the services available, the mental health services available to students available even during the pandemic. And I say this because also India being a low and middle income country, we don't necessarily have the best of the mental health services. And Professor Sahani will agree with me that mental health is a fairly sophisticated area of public health, and we do have a scarcity. And for a university to keep going with the mental health services and trying to work on it is it's quite something. And I hope the students recognize and appreciate it. And there have been students who have demonstrated excellent academic results even in the pandemic because of the support they've got during the whole process. So yeah, that is what
Great. Great. Thank you, Kirti. And I'll come to you something related question a little later. And now to Professor Ade Mammon, you are the Dean of the Faculty of Law in your university in Indonesia. And I'm sure as the Dean, what kind of a leadership role you are playing to look after the emotional well-being of your students.
Okay, thank you, Professor Sani, and also all the speakers. I would like first to thanks to the GGU for inviting me here. Yes, I think the condition in Indonesia, overall, it's quite the same with other countries. I think in Indonesia, in India, and also in many countries. Particularly how to manage the student and also the student activity, because we lost the contact at the time to keep contact with the student is quite difficult, I think, because of we are applying the online teaching. So here I'm as the dean. Firstly, there is some difficulties as a public university. We have to reschedule and have to change many things, particularly in public budget, in the university budget. We have to switch the budget, yes, from the previous year and then to the existing condition today. So it's quite hard, I think, to adjust this policy, because we have to spend many fund budget to allocate for the students, particularly to provide the credit for the student to keep in contact and the connectivity to keep stable, because the primary needs for us today, I think we have to provide them such kind of credits to make contact with the connectivity. And in fact, that's the economic condition, the welfare level, all the students is totally different from the lowest, the middle, and until maybe the wealthy one. So it's quite hard to manage it. But I'm as the Dean of Faculty of Law, first I should follow the rector policy. Yes, because all the command, also the order from the rectors should be should be implemented in faculty level. That's the first one, because it's impossible. I'm as the dean can be against the rector. That's this point. And then maybe in Jindal as well, I think it's happened like that. Okay, and then to make a good condition and well-being for the student, I try to involve all the students in all faculty agendas, such as the previous a couple of days ago, I'm sorry, we involved and we invite them to join with the international conference that hosted by our faculty. That's a great success, I think, and they are very glad. They were very glad to join with the conference. So I think that's a good way to keep close with them and then involve them in faculty agendas like that. That's one strategy, I think, to get involved with them. And then one more that I always offer them, like outdoor sport, exercise, activity, as far as it can be manageable according to health protocol COVID-19. So I'm also as the lawn tennis player, so I like sport very much. So I try to invite the student to in extracurricular activity. So I think it's a good method to keep them in good health and good immune, I think, and keeps optimistic to see the future. And then also my policy I to keep closer with the students here. It's we always apply also, like the presenter from Professor Natalie as well from Australia as well, such kind of hybrid and blended teaching method. Yeah, in certain classes we apply kind of in-person learning, like face-to-face learning teaching. So in just a small number of students, we can manage it, I think. And then for the examination as well, at least maybe at the maximum number only, it's allowed only until less than 25 students. So we can arrange in offline learning like that. So I think.
Thank you very much, Professor Ede. You know, I just want to talk to you about the mental health issues which Kirti Nakre has raised. You know, there are two things: providing a psychological support or a mental health support to a person who needs it. One is the availability, and second is different countries have a different culture, but I just want to let you know, especially in the eastern part, there is a stigma attached with the word of psychology, and they don't want to visit a counselor. Because in India, you know, whenever somebody is visiting a counselor, either people would like to do it, you know, they don't want to disclose it to anyone. And now what we felt that they are not comfortable even going to the counselors of our own university. And now they demanded that these people are your employees and they may reveal the information to you. So they have a fear, which could be very right. So then, you know, just 2 weeks back, one very bright girl in a very, you know, famous college in Delhi, she committed a suicide. And the reason was that she was a poor person and she was not able to cope up with the online education because she was not able to afford the gadgets and other things. And she committed a suicide. But now, how to provide these kind of a counselor? Just to let you know about India, that we have only 0.07, less than 1 person against 1 million population, which is too less. And second is that either you get these kind of a support either from a counselor or from your peers, which is not available physically, and you can get it from your parents. So parents are also in stress. So it is not an easy thing to handle with. So I just want to go through again to all of you that how you are managing with your counselors, how you maintain the confidentiality. This may not be a big issue in Australia, because I know, because I've studied in US, people say very happily that, oh, so-and-so is my counselor, or so-and-so is my family therapist. But we have this kind of a problem, and how to overcome that particular issue. Over to Natalia, please. And we just have 3 minutes each, please.
Well, I would say that this is not such a big problem for Russian people, because maybe Russian people, they're not so stressful, they're calm usually, and we do not have such a practice of going to some outside professional therapist unless this is a very, very big psychological problem. So I would say that for most of people, it is not such a great stress, and they still use the means of communication to speak with their peers, to speak with their relatives, family members, and even with the professors. Because when I speak to my students, I don't usually do the formal class. We usually at the beginning of the class, we speak about different social things. So I think this issue is copable in Russia.
Okay, to Fauna, please.
Sorry, I've just had construction going on in the next room for some reason today. Thanks again for inviting me as well to the panel here. As you were already alluding to, Sunny, the privacy issues aren't a major concern in Australia. We have had counselling services all over campus. I think our biggest problem at the moment is necessarily identifying some of the students who could be on that little edge, and then making sure that they get the help that they need. So we actually have quite a few staff now who do what they call mental health first aid training here. And so they're sort of on the lookout for those students who might be at risk, even on the online environment, and then pointing them to our wellness officer, who could have individual sessions with them. And if they needed additional help, then direct them in the services on campus and off campus that are available. And there are quite a number of services. And the law students here definitely are well aware of the potential for mental health issues while they're studying law. And I think that also helps them be better at identifying when they should be trying to seek help. I think there are other parts of campus who are a lot more affected than the law area in some ways.
Great, thank you. Over to Kirti, please.
Thank you very much. So stigma is a serious issue in India, and that's why we need to kind of work beyond individual models of counseling in Indian context. And as Professor Roth also said, that you need people who can create some kind of peer support, and also faculty members and also wider administrative staff, whether in the library, recreation facilities, need to be aware. So we have worked in the past with the halls of residence. So even wardens and all do take, high-risk students on that, and they do get reported so that they are put on suicide watch. And it has been more difficult with COVID-19. And personally, when I have had students reporting feeling very low, I have referred them to counseling services. And, I tried to reaching out to create a network of support around the students. But in an Indian context, we do need to do more work in the familial family context as well, because we do have a good boy, bad boy culture, wherein if you're a good girl, if you get up at 7 in the morning and do yoga, and parents tend to have those kind of role models and have those kind of notions and which need to kind of be worked at. And that's where peer support becomes very important. And generally, there has been an improvement in also faculty members referring high-risk cases to counseling as well. So there have been improvements, but COVID-19 is a serious problem. And also the issues of privacy and confidentiality is something that we've worked on in terms of incorporating it even in the course manuals, where along with the helpline numbers, we do try to make an effort to say that, your conversations are confidential. But also app-based services like Your Dost are also preferred by students, some students, because of confidentiality, because they feel that there is an anonymous person on the other end and they feel comfortable talking more also. So there are like multifaceted issues to be addressed when it comes to stigma and issues around ethical concerns. Yes, thank you.
Yeah, quickly, and because we have got many questions from the audience, so we have to take those as well. So Ade, do you want to say something about this? Do you want to say about the counseling system you have in your university? Are you able to hear me? Am I audible to you?
Mr.
Professor Ed Memon?
Yes.
Oh,
yeah.
Would you please talk about your university on this, please?
Yes. I think the university teams doesn't work very well. I think about the counseling team, because we know that today is really very stressful condition, I think. So everybody doesn't want to meet with anybody. So even the counselor is like reluctant to serve the student, to come with them to have kind of to need kind of consultation. But in my faculty, I try to push them. First, we encourage them because we have academic counseling in our faculty. Yes, and also we also have a university team for counseling for the student. So we have to synergize both from university and from faculty level. We have to synergize two teams in how to anticipate for the student who get stressful in facing the pandemic time. So I think that's only that the policy from our university concerning the pandemic time for the student.
Great. Now there are many questions from the audience. So for the first two questions we have already addressed on the counseling. This question you just whosoever would like to answer this, please let me know. Is the pandemic has drained different sections of society financially. In such tough times, the well-being of the students and the faculty members of the institution is significantly dependent on their financial capabilities. Owing to such circumstances, what efforts can be put by the educational institutions to financially aid their students? What are some of the best practices adopted by you, the law schools, in this context? Who would like to take this question, please? Anyone? Fiona?
I'm happy to, I know what our university did. 3 very simple initiatives. One, they took all the laptops out of because the campus was closed, they took all the laptops out of the labs and set up a laptop loaner scheme to students who weren't able to have access to the technology that they may need to go online. That was one very quick initiative. Another one was they made sure that there was food hampers and other sorts of hampers, especially for students who were put into quarantine and didn't have access to family or support. And we also made sure that the libraries, as much as possible, got access to online learning materials for textbooks and things, so that students, again, weren't disadvantaged by those students that you talk about, weren't disadvantaged by moving online. They were 3 very quick things that they'd done in a week.
Okay. Anyone else? Ed, you would like to talk about it, the financial support to your students?
Yes, in my faculty, I invite all the alumni association. They try to collect kind of fundraising to help the student. So it's a very fruitful efforts, I think, for the student, because they can help the alumni, can help the student to pay kind of credits. Yes, it's because from the government budget, it's really relatively very limited number, I think. So it's my policy at the time, and it works well until now.
Great. So you want to comment, Kirti and Natalia, on this?
Yes, I would like to say again that in my region the situation is not so bad that in Western Russia, for example, and we have so-called light limitations of social distancing. Of course, we have all precautionary measures, and students and professors, they are wearing masks, but at the same time, for those students who do not have technological means or financial means to continue their studies, we also provide rooms in our computer classes, which the students may use, of course, with keeping the social distancing and access to the library. So everything works with precautionary measures.
Great. Kitty, you want to say, or may I move to the another question?
Move to other person.
Okay. Now is audience wants to be educated on one particular thing. They said that faculty reportedly have been struggling with engaging learners gainfully in the online mode of teaching and learning, assessing the learning outcomes, and keeping students safe in the cyberspace. While transition to online classes has not been easy for faculty, that can be done to ensure the quality of educational output. Do you think there is a need to adjust our expectations to meet the challenges of the pandemic with respect to the output of education? This is an important question where, none of us have been trained, then the pedagogical system, the assessment system, the span of attention, which is very important onto the online, and then on the top is the cyber issues. So this is causing a major issue to the faculty, and I would like to know from the experts that how do they handle this? Over to Kirti first.
Thank you. These are very serious issues. Personally, as a teacher, I engage the students with innovative approaches of assessment, such as writing blogs. And what has been interesting is also how students have reflected on some of the crises around them. And luckily, because I teach electives and courses which talk to the social realities, they have been talking about the migrant crisis or the cost of education in India. So they have been fairly reflective, and I do think usually I would have very rigorous standards, theoretical standards on assessments, but now I have become more open to reflective thing where students' own personal reflections on social reality are being expressed. But also educating students on cyber safety is very important, because these are very serious problems that young people in India are grappling with, because gender-based violence is now through the cyber means also. So students do need an education on cyber safety. And I think as universities, we do have an important role. We do talk about it and we do send information on the email. But I think students need to be engaged more actively on this. And also, I think reducing course load and also focusing on the core learning outcomes, that what do you really want to see at the end of the day from the students during a pandemic, is also important. So I have, as a teacher, focused on very, very core our learning outcomes, and also designed my curriculum in line with the current situation of the pandemic. So my assessments are also asking students to reflect on how the subject and matter is also related to the current realities. So I have designed that, and also I have been mindful of cyber safety. So whenever students have reached out to me, I have referred them to the appropriate support services around cyber safety. Thank you.
Okay, to Fiona, if you want to say something on this, because I'm sure this must be a cause of concern in your university as well.
Probably less of the cybersecurity side, because a lot of the students in our systems that went through major upgrades to improve the safety. We've had very few instances of people Zoom bombing into classes, etc. Outside of that, our students, I think, are fairly savvy, and there's probably not a lot of instances as in other countries. The one thing we are struggling with, and still struggling with, is getting them, that very first thing you said, getting them to engage in the online environment the same way that they do in the in-class environment. And I think there's a group who are really struggling with that. It's not being reflected necessarily in the assessment outcomes, because I think the students then knuckle down and do the work, but I think they're missing that interaction that they would normally get from an interactive seminar type in-class environment. And even if you try and do it with breakout rooms, it's just not the same.
Right.
And we haven't got an answer, but if someone has, I'd be grateful.
Excellent. And Natalia?
I would say we are the federal university. Federal university is the top universities, and we have a special cybersecurity system. And you probably know that Russian cybersecurity specialists are the best, or ones of the best, and Russian hackers are also ones of the best in the world. So no problem with that at all, even if I have not heard any.
Okay. I'm happy that you don't have a major issues. So yes, in Indonesia, what is the scenario?
Yes, in my university, firstly that we as the dean, we have 12 faculties. So the 12 deans here asked to the rector to strengthen the system, the IT system in our university, to ensure that the connectivity will be keep stable, and then also to make sure that the lecturers and then the faculty members can use and access all the facility, particularly from the IT facilities. So the key point here from the university policy, I think they should keep the connectivity keep well, I think, and stable. That's, I think, in my university the policy on that.
Since we have left with only like 10-12 minutes, so my last question to all of you, and where you can take 2 to 3 minutes each, is that what advice do you have for promoting health and emotional well-being of both the students and faculty, especially during the ongoing pandemic? Because all of us, we have learned from our experiences. Now it's been almost 8 months, over 8 months. And, now we need to know that how the faculty or the student can handle. So what kind of advice you have for faculty and students, please? So we start with Fiona, please.
It's a really interesting question, and I think it's something that we're only now starting to come to grips with. We thought it was only going to be a few months. Now it looks like it could be a few years, and we've concentrated a lot on student well-being. And I think now is this time where we're really starting to see our staff, I won't say at the end of the line, but they're actually exhausted. And one of the things we did yesterday was we had a strategy day here, and we actually changed one of the sessions to almost be we need to get out what the pain points still are in regards to staff, students, technology, education. Mental health was another one, and we're actually now going through that data and looking at what sort of, I won't say set courses, but sessions we can run at the beginning of next year. Not now, it's too late in the year and staff are too exhausted. But when they're coming back next year and it's going to be very much more of the same, how can we prepare them for those mental health challenges that they're going to be facing as staff? Because I think they're exhausted, and I think they're only now just starting to realise what issues they have, if that makes sense. They've sort of got through the year and now they're stopping and it's starting to hit them. Great. And the students are the same. Semester 1, they had one sort of mental health problem. Semester 2, they had slightly different ones. And now I think it's more, they're functioning, let me get to the end of the year, and I'm worried what's going to happen at the start of next year when it's another year that's like this.
Natalia, advice for students and for faculty.
Yes, my advice would be that we should see every situation as something positive, because every obstacle may be considered as an opportunity at the same time. And if we are told to carry out social distancing may not be deemed as a destructive act, but if you see it as something positive. For example, you are doing your personal sacrifice in order to save lives. You do not get out, you do not get in touch with people infected, you do not infect yourself, means a lot for the mental well-being. And if you cannot change the situation, make it best to accept the situation and turn it to the most positive and beneficial for you, for the law school, for students and faculty members. When I speak to my students, even now I am sitting in front of you and you see the university behind of me, but basically I'm sitting at my home, and my home now is, as I say, all in one. It's my office, it's my conference room, it's my sports hall, it's my musical studio, it's my kitchen, everything. And I try to adopt students to think of everything in positive and optimistic way.
Thank you, Natalia. Over to Kirti, please.
Of course, I do agree with Professor Natalia that we need to believe in hope, and our language should be mindful that, we are going to come back and be back in universities doing what we do the best. But also, I feel we will have to work very hard with the students and faculty members and also administrative staff in terms of consensus of what our core goals will be in terms of well-being, and creating support networks, also encouraging informal and formal groups amongst faculty, students, and administrative staff, also in terms of recognizing and forming these groups so that they can talk about it. And because this is a collective trauma, and what is struck me while talking to students is how moved they have been because of the crisis that India went through in terms of migration or reduce food security amongst the informal laborers. So this is something that has affected us collectively as a society, and it is a critical juncture for us as a society as well. So we do need to strengthen not only individualized responses, but also strengthen groups within the universities, both formal and informal groups, encourage communication about the trauma that people are going through, and look at it as a collective, put in collective efforts to work on it, and also create mentorship programs for students, for junior faculty members, and also for senior faculty members, and just work or just have one or two goals on well-being and work collectively towards it, and develop a culture of compassion and kindness, and understand that this is a difficult phase and we will all get through it together, and we are all in it together, and it's not the experience of one or two people, it is an experience of collectively as a society as well. Thank you.
Thank you, Kirti. Thank you. And over to Professor Ed.
Yes.
What kind of advice you would like to give it to the students and the faculty?
Yes, all the student and faculty member, I think they should maintain their health, and also should keep with the concern with the health protocol 19. And also, I think don't to scare with the pandemic, yes. But also we have to be alert with the pandemic, yes. So it's balance mentality between we don't need to scare too much, I think, about the pandemic. That's, I think, the point. Only that. Thank you.
Great. We still have 3-4 minutes, but I want to just summarize, because I didn't take time in the beginning. Being a student of the mental health, I would like to have some suggestions for the students and for the faculty. As Natalia very rightly said, that, the positive approach. But as the Jindal Institute of Behavioral Sciences have conducted so far over 225 webinars for students, for parents, and for teachers, so that they can pass on these kind of things. So we developed a system where we try to say, because all of us, we are at home, and earlier during the lockdown time, we were not even stepping out. So there is some word called in psychology is called catharsis, because when we accumulated more energy in our body, and we don't drain out, and in that causes a lot of stress, anxiety, tension, depression, phobia, and so on. So it is necessary for us to do the physical activity that is the utmost important. The second, we put a lot of stress on food, because if you are taking a lot of spicy food, oily food, the red meat and so on, because that can also causes certain issues in your body and can cause some anxiety in your body. So small things like, take care of your hydration, take care of your health in terms of not only the physical health, but emotional health, how you can be connected, and if we can develop the social support system whenever the people have any kind of issues, they can go and talk to them. And in this little free time, if we can develop a gratitude journal, what I'm trying to say is how we can make these students occupied, rather than if they're spending like 3, 4, 5 hours on internet, they should not spend watching another 3, 4 hours while watching a movie. So spending like 10, 11 hours in front of a screen is not a healthy sign. So my first thing is, I really like when Natalia and Fiona talked about the hybrid model, and I just want to let you know that Jindal is probably, once the government has banned all the institutions, once government will say, yes, we are definitely going to go on the hybrid model, because all the classrooms are fitted with the video cameras so that 50% students can be on campus and 50% students can be at home and they can learn from, and then we can shift them. Because we feel, as a psychologist, I personally feel it is important that students must come on campus because of their mental health issues. It is not easy while sitting at home and dealing only with the parents and siblings that can help them. So it is, I know that Russia and to certain part of Australia, you are lucky that there is not a big issue and you can start these kind of models easily at your place. But in India, where we have a lot of population, where 450 people stays in 1 square kilometer, so we cannot do, so we are waiting for the government to give us approval. But mental health issues cannot be ignored. Mental health issues is not their individual problems. It is more a social issue. And as a society, we need to work out the models. We need to make students aware that if you feel these kind of, or if you have these kind of symptoms, how you can be, help yourself, or how the counseling services can also be provided to you. So that's it from my side. And thank you very much for giving an opportunity. And I must tell, as I said in the beginning, that I have not seen that in 3 days, over 30 sessions, and with the top people, the eminent people, the distinguished people, the accomplished people like you, in such a short time, and collecting so many people all over the world, I could see, although it is in the name of the law school, but I think it is a general, the higher educational institution issues which we are discussing. And thank you very much, Professor Rajkumar, for giving me an opportunity to be a part of this panel.
Thank you very much, Dr. Sani, for so wonderfully moderating this panel and also bringing to bear your vast experience as a psychologist and a behavioral scientist. I deeply appreciate the contribution of Professor Natalia Priskina, Professor Aid Maman Suherman, Professor Fiona Rode, and of course my distinguished colleague, Professor Kirti Nakre. In fact, this particular thematic session was important not only because of the fact that it has assumed significance during COVID and potentially post-COVID, but this ought to be a matter of serious concern independent of COVID, and just that COVID-19 has brought this issue of health and well-being of students and faculty on campuses to a sharper focus. I share many of the perspectives that has been brought into this session, and I once again thank you for your time and your presence and participation in this thematic session. We will take a short break and we'll quickly move into the 24th thematic session of this conference on the theme Law School Leadership, Institutional Resilience, and Policy Innovations shortly. Thank you very much.
Thank you.
Good morning from India, good afternoon to our friends in Southeast Asia, and good evening to our friends in Australia and New Zealand. It is indeed my proud privilege to welcome all of you to the third day of this global virtual conference on reimagining and transforming the future of law schools and legal education. It is indeed my proud privilege to also welcome you to the 24th thematic session of this conference on the theme Law School Leadership, Institutional Resilience, and Policy Innovations. We have with us a very distinguished group of individuals, truly transformative leaders in their own right, contributing to institution building efforts in many parts of the world. Let me begin by formally welcoming Professor Dr. Penelope Ellis Matthew, Dean of the Faculty of Law, the University of Auckland, New Zealand. Professor Brian Horrigan, Professor and Dean, Faculty of Law, Monash University in Australia. Professor Dr. Robert Cunningham, Dean Head, Curtin Law School, Curtin University. Professor Mark Miller, Dean of the Faculty of Law at the University of Arizona in the United States. And of course, Professor Krishna Deva Rao, Vice Chancellor of the National Law University in Delhi, here in India. I also want to formally welcome and thank my own colleague, Professor Dr. Matthew John, Professor at Jindal Global Law School of OP Jindal Global University. In fact, this issue of leadership and indeed the ability of leadership to respond to the challenge that we are facing together was part of the larger effort that we have undergone in this institution, but also, I'm sure, in other institutions. To what extent institutions are capable of responding to this challenge, as well as developing institutional resilience and also promote policy innovations, has been the kind of social expectations that has been generated. With those words, I'm going to formally hand over this panel to my colleague, Professor Matthew John, to take forward the proceedings of this session. Thank you.
Yeah, thank you very much, Raj. And thanks to all our distinguished speakers from various parts of the world for joining us on this session. We've been discussing over the last few days various aspects of legal education in this vastly changing landscape. And it is indeed a pleasure to have this very distinguished panel joining us today to deal with this particular facet that we'll be talking about today, issues around institutional leadership, institutional governance, and the ways in which we might respond collectively through positions of leadership to this unprecedented challenge that we've been faced with over the last almost a year now. There are various aspects of this problem that we might want to talk about. So I was wondering if we could all start with a small 2 or 3 minute introductory remark on what have been our biggest challenges and perhaps our successes as leaders. And all of you are leaders. I'm not quite the leader that all of you are in your respective institutions. But I was wondering if you could respond, starting with Professor Matthew, and then we could go from there, Professor Rao, Professor Miller, Professor Cunningham, and on to Professor Horrigan. So if you could start with a few introductory comments on what you have perceived to be challenges and successes, and then we could take it on from there.
Sure, delighted. So I suspect some of the challenges have been exactly the same for all of us, and then some of them quite different. So from the context of New Zealand, and I have to admit I'm not a proud Kiwi, I'm actually an Australian, masquerading as a New Zealander, leading the nation's leading law school. But we have not had great experience of pandemics like SARS and so on before. So I think there were actually some countries that had been through something similar. So I think one of the big challenges was psychological. It was just getting used to the idea that liberty would be restricted and that you couldn't do things in the way that you'd been used to doing it. Fortunately, in New Zealand, we had from the very top magnificent leadership by Prime Minister Jacinda Ardern. And I think people were really able to take their cue from her leadership. So people have been kind to each other and recognised that it has been a stressful time, and people have been sometimes not cautious enough and at other times overly cautious. So, you know, New Zealand has moved between levels. We're currently in level 1 and coming back into level 1 where things were safe again, people were actually sometimes overly cautious. They'd gotten used to staying at home in their bubble. So I think psychologically there was a big challenge. Certainly for mental health of our younger generation of students. I mean, this is the age where mental health problems tend to surface anyway. I don't think we can underestimate the impact on them of having the social supports, of being in classroom, being able to be on campus. That has been very difficult. There were also issues of inequality exposed quite brutally. So the digital divide, some students without devices, without even connections to the internet. On technology, I think our university and our law school did very, very well. So we provided students who needed digital devices with those devices. We provided internet connection. I think my colleagues did a fantastic job of pivoting to online, you know, emergency remote teaching over a week. I've never seen a bunch of more focused people at the sessions on how to transform your teaching into a digital format. And I think what I observed there was, you know, we often say that leading academics is like herding cats. Actually, I thought I saw distributed leadership in action, and we were like a flock of migrating birds moving to the digital world, and colleagues were kind of cheering each other on and helping each other out and taking the lead. And I think that's why the institution has been so resilient and been able to keep ongoing. I think I'll leave it there. I've probably said quite a lot there.
Dean Matthew has explained and illustrated how the pandemic has impacted all over the world. I think the similar impact we have seen in India. It had an impact on social, cultural, political life, economic life, and we are, all of us all over the world are struggling how we should come out and develop a sustainable environment, sustainable economy, politics, civil liberties, including the legal education. In the context of the Indian legal education, I was just looking at earlier, our perception of infrastructure was more and more on physical infrastructure, investing into buildings, intellectual infrastructure, hiring of faculty, motivating the faculty. But the pandemic has really brought to us the issue of how much we have invested into the information technology infrastructure, how much we have invested in the emotional infrastructure. I would also underscore that pandemic for the first time has really celebrated, which we have all been missing, sense of interrelatedness, sense of togetherness, staying at home. In fact, the faculty, students, symbiotic relationships. Of course, we disagree. We agree, we disagree. But there's an amazing mixed feeling I would see. And as somebody who, like a National Law University Delhi, we are fortunate enough to start thinking much ahead, like the India is a robust information technology infrastructure in India. So therefore, we already started invested, starting from 2014. That came as a really, I think something is a positive engagement with the information technology infrastructure and the emotional infrastructure. But I think as a leader or as a collective teamwork, the sense of belongingness, sense of empathy is still missing. I think somewhere we have to seriously think about the other two types of the infrastructures. I think these are my comments. Yes, John.
Right, if I could move on to Professor Miller.
Yeah, the question of leadership through
this era is an interesting one. For us, it's been less a question of leadership at my law school than at the university, in our community in Tucson, throughout the state, and of course throughout the United States. And I think the record at those larger levels, at least, is mixed. I mean, think of the fundamental question for universities, and it's been mentioned by others already. Do you open at all? And if so, to whom? And if you provide educational and other services digitally, how do you deal with inequities and burdens that are imposed by COVID and that pre-existed? I mean, in some ways, for US law schools, the challenge of adapting, of modifying what we do has been around for a decade. We saw a massive decline in demand for our traditional programs after 2008, 2010. And so I don't mean to suggest it was similar before last March, but the adaptability and change was there. 75% of our students and about 65 to 70% of our revenues are different now than they were 4 years ago. And we've been undergoing dramatic change at the law school. But those larger issues, in the sense that, in fact, we're part of a much bigger community, the decisions about opening were made with the other colleges and with university leadership and with health leadership in Tucson, which is a 1 million person metropolitan area, and within guidelines and limits imposed by the state, and to a much lesser extent here, the federal government. So the leadership challenges here were interesting because of the extent to which they were similar and we could build on strengths, and the extent to which they were utterly unlike anything we'd seen before. The last point I'd make about leadership and the community more broadly is, I thought right away in March, and I think even more to this day, that what we're experiencing is a world historical event. It is not simply advanced education and the challenges we face by 3 to 5 years and maybe more, but the world will look different at the tail end of this, no matter what the effectiveness and distribution of the vaccines is, and how low cost testing gets, and how much we can all mirror the admirable successes in New Zealand and Australia and some other locations. So I think this conversation, the larger conference that Jindal Global University has put on, but the challenge we all face is to try and be ahead of, look around the corner. It's very hard to do, but I do think the world will be fundamentally different 1 year and 3 years from now. And that's the challenge of leadership in the end that we face.
Professor Cunningham, if I could invite you to come in.
Well, thank you, and thank you for the organisers, and it's nice to be here. I think what I found interesting is that it makes us think about first principles. This whole pandemic, in terms of what are we actually doing as legal educators. So in that sense, there's an existential dimension to the pandemic. I've been thinking a lot about what is it that we actually do at a university? What is it that we do when we teach? And a lot of the time you can break it down into pretty simple things. I mean, from an academic point of view, we basically, as far as the putting aside research and so forth, and just focusing on learning and teaching, we basically deliver content. We try and get students to engage with that content, and then we assess them. And so in a way, it's a pretty simple thing that we are actually doing, but yet we all have our different ways of going about doing that. And I guess, trying to marry up the human dimension of what education is all about with the tech is one of the real challenges that I see in the future, because technology, let's face it, it doesn't always work. I mean, it's working now and it's great, but it's not always the case. And it tends to make it more difficult to have deeper cultural experiences, deeper experiences on the emotional intelligence level. And they're the sorts of things that actually make an institution unique. So I guess one of the challenges has been, to actually clarify why it is that we as Curtin Law School actually exist, and why it is that we do what we do. One of the successes that's come out of it, from my point of view, is that, in fact, academics are quite conservative in terms of the way in which they go about their business, I think, even though there's a sort of a myth that academics are actually radicals. It's often not the case in practice. And it's quite difficult to get academics to do things differently. And of course, the pandemic has forced academics into that situation. So one of the things that I've enjoyed about leading the law school during this time is to invite colleagues to experiment and to actually do things differently, even when things might fail. And not everyone has taken up that invitation, but for those that have, it's been quite interesting. And I guess one of the initiatives that I'm most proud of during the pandemic period was a legal tech pop-up course that we ran along the way, which essentially created a competition for students to create some legal bots that would service the clinic activities that we run within the law school. And so that for me was a really successful and interesting initiative. We, because it was a pop-up course, we advertised it with very short notice, only about 1 week notice, but got a really good, strong turnout to that competition that ran over a month. And I was part of the judging panel at the end of that process to evaluate the quality of the different projects that had been produced in that 1 month. And it just blew my mind. It was just really exciting, really interesting work that had come out, and in a very short period of time. And I just don't think that we would have been able to successfully do that if it wasn't for the pandemic. In a sense, it created the foundation or the springboard for that particular initiative. So I'll leave it there, and perhaps we can flesh out some of the things as we go. Thank you.
Thank you so much, Professor. Professor Horrigan, if I could ask you to come in as well, please.
Thank you, Matthew. And can I join my colleagues in welcoming everyone and thanking Jindal and Vice Chancellor Raj for arranging this fantastic and timely opportunity for us to come together. Some of the leadership challenges we all face are universal. So I think we all realise, and certainly we're planning on the basis that we're not simply looking to reactivate by going back to the normalities of how things were in late 2019. And that is easy to say, but in getting academics and professional staff and students to understand what that really means is another thing. So that's one thing we could probably agree is a universal challenge. The second one is that COVID's at least a 3-year thing. And the challenges in each of 2020, 2021 and 2022 in managing COVID and reactivating are going to be different in terms of staff travel, student travel, impact on finances, job losses, arrangements. As when people come back from workplace relations matters or occupational health and safety matters or from illnesses, we already, across our various institutions, take a lot of care and steps to make sure that a transition back from a period away is happening in the right way. Well, we've got a whole heap of people who have normalised for 9 months being at home. So there's a lot of universal challenges there. Some of the other challenges are going to be relative to, for each of our law schools, relative to location, scale of operations, and particular governmental and health authority requirements. Melbourne was in lockdown longer than most cities of the world, complete stage 4 lockdown, staying at home, not being able to travel, no one on campus, moving virtually in our operations. And now we're out of it. But we're not out of it in terms of there may be a return and so on, and we all have to manage that in 2021. In terms of scale of operations, I manage a law school that has 3,500 students, hundreds of staff, 7 locations on 3 continents, including 3 community legal centres. I had to make a decision in 24 hours to close our 3-month operations and sending students and teaching with other international law schools in both Prato, where we have a campus, and in Malaysia. I had to move most of our clinical operations across 3 sites to virtual, where the staff were servicing our clients and the students for one clinical period didn't, and now we're coming back. We moved to being a virtual law school when the Victorian government and health authorities closed us down. So not everybody will face those sorts of difficulties, but there are some similarities there relative to what your local government health authorities and what your own operations are. The successes, I echo the comments of my colleagues on the panel that the desire of staff and students and the ways in which we've been able to find ways technologically and otherwise to create enhanced interactivity, and the desire of students and staff for connectivity by the technological means has been tremendous to watch. And there are some lessons there that will transform how we do business. So from the student side, I know from talking to my colleagues and talking to students, they are absolutely crying out for connection. Many of them do want to return to campus, but it's the connection when they can't be on campus that they're valuing, and the staff are being innovative and finding ways to do that. If I'd walked into it, and like Penelope, my staff have been magnificent, professional academic staff. If I'd walked into a staff meeting at the end of 2019 and said, I'm going to give you 2 weeks notice and I want everything online, I wouldn't be dean anymore. There would have been an uproar and there would have been a delegation to the Vice-Chancellor. So when we had to do it, and we had to do it quickly, and when we all had to do it en masse, it meant that the world changed forever because everybody did it. And now it's a question of we can do better than that, and we're not going back to how it was. And how do we handle, as has been said, the emotional infrastructure to match the physical infrastructure, to match the digital infrastructure, in curing the divides and the gaps and the inequities, and all in human terms that we're now discovering. So there have been some interim successes on that, but the challenges are ahead.
Right. Well, Professor Horrigan, you brought to the forefront the fact that this problem is so much more, so it continues to be an ongoing problem. I mean, it's when we started off with Professor Matthew, she said that we got used to it all too quickly. I mean, that was the sentiment that I drew from her at one level. And then the challenges that flow from it. But Professor Horrigan, you have brought home the fact that this is not something that we have come out of. We are not in a post-pandemic phase at all. And I think that more than one of you has said that, it may be, it may be a 1, 2, 3 year problem that we're going to be confronting. And I was wondering if I could start, with that particular thought and ask you about how you've been able to manage the expectations, demands, anxieties and so on of various stakeholders, from students to faculty to administrative staff, and perhaps even administrative and regulatory authorities.
Any particular order?
No, I thought we start with Professor Horrigan because he brought it out most clearly, and then and then we could take it from there.
On the accreditation side, the Victorian accrediting bodies for our degrees moved early, and they moved in a way which all the law schools were thankful for. They basically said, we understand what COVID's done to you. We'll maintain your existing accreditation. As things start to normalise, tell us what you've done to maintain the quality of the courses. So having an understanding accreditor and talking to the accreditor has been an important factor in the success of managing it this year, and talking to other law schools in the jurisdiction regulated by the accreditor. But I give credit to the Victorian accrediting body who moved early and moved in a way which was smart. In terms of students, we have had some difficulties. So in the first half of the year, managing student expectations, we were putting students into online assessment, still doing exams to mirror some practice conditions, and having remote invigilation. There are the usual, and there was new technology to do that. So I would say the first half of the year raised all of the angst of students and social media agitation and other things that were creating a lot of noise and not necessarily much illumination. And it's radically changed in the second half of the year. So the student reaction in suddenly being confronted with, how will we cope with our results? How will it be different if it's done in a virtual mode? How will we get through exams while also working from home, managing care and responsibilities? How do we deal with the technology? All of that had subsided by the end of the year. And we did our own checking and found that our students from last year, this year, have transitioned from face-to-face exams to remote learning and virtual learning and remote exams with remote invigilation. And most of them have done the same or better. So students themselves have been remarkably adaptable. And once they worked out that they were actually doing pretty well, their reactions started to modulate as well. For staff, it's one of the transitions has been, it's very easy to suddenly get things online, but then you've got to start working out, how do I manage the student cohort day by day, week by week, who want contact? The staff have had and I suspect it's the same everywhere, the staff have wanted clear indications from us about if we're having to spend a lot more time looking after anxieties of students and we can't do as much because we're working from home with family responsibilities, including under lockdown here where parents with young children or parents with school-age children who weren't, late teenagers had to basically be 24/7 looking after them, including their schooling needs. And that has impacted differently upon different family members and different staff. So there's an equity issue there as well. But the single thing that we did that was most important was that a lot of the academic staff were saying, well, we need some clarity about how will our performance be assessed? All law schools want their staff to be productive, and everybody has some form of, you need to be meeting these sorts of standards in both teaching and research. We're spending more time in suddenly putting things online and dealing with student anxieties. How will that be taken into account? So we moved very early through a series of consultations to create a relative to opportunity document about what it would mean for law and what that would mean for the standards and expectations during this year of COVID when it came to research productivity, and what it would mean next year. So there's just a couple of things on accreditation side, student reaction side, and managing staff and their reactions and needs, which have been the things that have made a difference in this transition in 2020.
Thank you, Professor Horrigan. Professor Matthew, very closely related to Professor Horrigan's comments is the issue of mental health and anxieties that people have in responding to this moment. You had brought it up in your introductory comments, and I was wondering if you could come in with how it figured in your in your interactions with staff and the way in which it came up as part of institutional negotiations and conversations.
Yeah, so I think what was important to do was to communicate very clearly to try and provide some certainty, and you needed a single source of truth from the centre about how people were meant to behave and what they were meant to be doing at particular levels. New Zealand went in and out, and particularly in Auckland, we went to level 2.5 at one point, and so there was some unclarity about exactly what might be permitted and what might not be. So clear communication was certainly part of it. For staff, providing a sense of community. So I'm sure lots of other people on this panel had endless rounds of Zoom drinks on Friday nights and things like that to try and provide a sense of community and, making sure that you checked in on staff on a more regular basis than you would otherwise. For students, it was a matter of putting on some additional counselling. And we've been very lucky in that our supporters, firms, barristers' chambers, other donors have been very generous. And so we were able to put on additional counselling services in addition to the ones offered by the university. But, going forward, I think people need to develop more resilience, and perhaps this will be a good thing going forward, that this generation has had to grapple with something pretty serious and destabilising and uncertain early on in life. And I always say to them, I hope that's actually going to stand you in good stead.
Right. Thank you, Professor Matthew. Professor Rao, you had also alluded to this in terms of this being an emotionally affirming moment where people came together and felt a sense of oneness and community. And again, there were others also who came in on that point. I was wondering whether you could say a little bit more to that.
Unlike Professor Brian and Professor Matthew, there's a huge, large campuses and a large number of students. I think that was the challenge for them. But whereas when I look at small national law universities, there's like a what we call as a single faculty departments, like only law faculty, and we have to deal with around 400 to 500 students. And so that was a relatively very easy task for us. And what happened is, since 2014, we have developed for the first time in India e-learning courses. And then later on, we have also developed the massive open online courses. So we have oriented the faculty and some students. We have set up e-learning studios. So that says slightly, I think we are in a better position to deal with a small number of students. Second, about the accreditation or management issues, again, because there's a small university which is autonomous, so therefore we were able to, there are no bureaucratic hassles, so we were able to immediately implement whatever a small group of the faculty have decided, we are able to implement it. But emotional, I think the sense of empathy with the student, it's still, we were able to do something and much more. It's a robust policy is missing. No, these are all ad hoc. Like a good teacher, it's more empathetic. Like Professor Robert Cunningham has said, he's that absolutely, we need to seriously look at the human dimension of the pandemic. I know that's a larger question. I think we all have to deal, but it always depends upon empathetic faculty, empathetic colleague, empathetic peer group, empathetic staff, but there are less in number. What we need is a more creating that emotional, robust culture of a sense of empathy. I'll just leave with one idea. I think this is Professor Brian and Matthew have said, and Robert also, all the colleagues in the panel, what have said is, this we need to share. I think this is a right opportune time. All of us share how large faculties were able to respond, how small institutions can learn from them. And particularly maybe in the panel, we will come back. I would like to know more about the legal tech prop-up course, which the clinical activity, Professor Robert Cunningham said. We also have a very robust Article 39A access to justice program in India, where we have now web-based access to justice system, and we are looking at how also to bring it to the grassroots. Thank you, John.
Thank you, Professor Rao. Actually, I was going to move on to Professor Cunningham. I noticed that there's a chessboard behind you, and I was wondering whether you, whether you looked at the pandemic as a kind of chess strategy game that you had to work your next move towards. But on a more serious note, or perhaps perhaps there is something to chess and how one responds to the pandemic. But you had mentioned the issue of content and delivery and the challenges that that arose in relation to that, and there was also a pop-up course that you mentioned. I was wondering, but you went over those comments rather briefly, and I was wondering whether you could come back to the question of content delivery technology and the challenges that that confront us in the future, in this pandemic and post-pandemic world. And I think you also mentioned that this cannot go on forever. This is clearly not sustainable. So what exactly works in this mode and what perhaps doesn't could be something that we could think about. And how do we think about it as administrators, as leaders?
Thanks very much. And I'm really immensely enjoying this conversation. I mean, I've had lots of these conversations over the last 6 months or so, but it's really nice to be part of an international forum with these different perspectives. The chessboard is relevant because I guess in any leadership position, there's strategy to contemplate. But one of the challenges that I've found throughout this process is balancing out crisis management on the one hand, which tends to be reactionary and devoid of strategy for the most part, and then being able to step out and actually work out strategically what are the gaps that need to be filled as part of this process. And as other panelists have suggested, one thing that has become very clear is that we don't have the infrastructure that's actually required to do what we all know we need to do. We might not have a clear idea about precisely what it looks like in terms of hybridized education that includes both online and physical interactions. But I think most of us have a sense of where we would like to go, but we're constrained by things like the technological infrastructure. At least in my university, for example, one of the big gaps is the ability to connect physical meetings with online meetings. It tends to work okay when we're all online or when we're all in a physical space, but when you try and blend those things, it tends to fail in my experience. And that's largely, well, it's partly because we don't have the technology, but also there are some cultural deficiencies there. We don't necessarily know how to interact. And, I'm sure that many other academics have experienced in recent times that students tend to not want to put on their cameras when they come into an online class. Now, there's some sort of cultural dimensions to that we would need to sort of flesh out, you know, so that we understand why it is that we need to connect and to look into each other's eyes, or to understand what's being said at the emotional level as well as at the substantive level. So, you know, a big part of all of this is generating place, perspective, and, you know, I think we could go two ways with this as it all pans out. I mean, on the one hand, education could become more homogenous and we could all end up doing very similar things, or we could find sort of international collaborations and find the commonalities at that international level, but then at the local level become much more diversified and maybe driven by competition at the local level. So I think the perfect model, if there is such a thing in the future, is to be able to collaborate internationally but compete locally. And the reason the competition would be good at the local level is to encourage diversification, encourage us to do different things suited to our particular communities, our particular cultural settings. So, you know, to some extent, that was what the pop-up course that I alluded to was all about. It was something that was unique to our institution, not to say that, you know, many other institutions didn't do similar things, but the way in which that particular initiative evolved, it evolved through a relationship that we had with an intellectual property firm by the name of Raise, and also a serendipitous connection with a legal tech outfit in Melbourne, actually, called Joseph. And we just started having conversations through Zoom about how we might bring together what Raise wanted as an intellectual property firm, what Joseph had to offer as a legal tech outfit, and what we were trying to do as a Curtin Law School. So it was a classic collaboration between three different parties, and we sort of found a commonality of interest where we could all get involved with this project, and we were all getting something out of it. So so lots more I could say about that, but I'll leave it at that, Matthew.
Yeah, thanks so much, Professor Cunningham. What you just said, you know, I found the international local connection that you were drawing quite fascinating. You know, collaborate internationally, compete locally, and that perhaps has some bearing on what Professor Miller was saying in terms of the nature of the changing legal education market in Arizona. You mentioned that 60 to 70% of your model had been, was well, I don't think you used the word upended, but you said
different. 70% of the revenue and the students, and almost as much of the revenue didn't exist 4 years ago.
And that's again a crucial problem going forward. You know, how is it all going to come together? And whether this has, whether this pandemic, whether and how this pandemic is going to impinge on our ability to continue to do the things that we've been doing for all of these years. And that experience that you've had at your law school might help us speak to some of the challenges that lie ahead. So I was wondering if you could come in on that point a little more and tell us a little bit more about that.
I will. Let me use a regulatory barrier, the temporary adjustment, and the permanent direction I think things are heading as a way of expanding on precisely that. So in the US, the US accreditor of law schools is the American Bar Association section on legal education. And it's late at night here, so I have to make sure that I maintain an entirely professional and respectful demeanor in speaking about that accreditor in this context. But I think it is fair to say that few would use the word innovation, and many would use a word that is the opposite of innovation in describing that regulator's activity over time. As an example, only recently did they expand the not generous limit of online credits for a JD degree in the US. It was at 15 units out of 88 or 90, and they went up to 30 of an entire potential year of online delivery and allowed 10% of the first year JD experience to be online. There is no logical, justifiable, sound reason, in my view, why a JD cannot be delivered beautifully online. That was true before COVID. But right now, the JD is being delivered online by most of those US law schools. Harvard is staying fully online for the full year. Many of us have done it in mixed mode. Others have preferred simply staying in the digital path. I don't think at the end of this year that council can, with a straight face, maintain that limit. I think students will expect something else. For many, they do miss that in-person interaction. Some do not learn as well. The stresses, I mean, we can talk about the variety of things that the digital interface does and doesn't provide. But for some, this has actually answered not only the short-term problem, but a longer-term issue in terms of employment, family, and other obligations, their ability to be in their home cities, work at a distance, take externships that lead to pathways that are also educationally highly valuable, and yet complete with the same professors and the same content, the degree. So I expect that barrier to fall. And by the way, over some period of time, right now we cannot deliver the JD outside the US. So you talk about global partnerships, we can't deliver the degree that allows a lawyer to sit for any US bar outside of the US. And it's absurd. There is no logical reason. I could go on with the history, but we're trying to maintain our comments more in brief. The programs I described before include the first BA in law in the US. Again, from a global perspective, an Indian perspective, an Australian perspective is a little more complex here, but that's sort of funny. What do you mean that you're delivering an undergraduate degree in law? Well, the US has had a professionalized or graduate doctoral model for a long time. The demand for that has been huge. It's allowed us to partner around the world. We think we've created a whole new category of legal professional. There's a parallel master's degree for non-lawyers, has more than 300 students in it and had more students enter it than in our JD program this past fall with multiple entry points. And those are the degrees I was talking about that are 70% of the students we didn't have before. But they're illustrative of the ways when your core degree or traditional degree is highly regulated of where you can move. And part of what COVID is doing is brought into doubt, and again, it's late at night, so I'm going to avoid the term ridicule, some of the former limitations on the ways we deliver the JD.
Right. Thank you, Professor Miller. One other issue to move on to another issue. To move on to another issue that's come up is the issue of equity. And one would have thought that a country like India would be faced with the questions of equity more centrally than many other locations. But both Professor Horrigan and Professor Matthew brought up the issue of equity. And I was wondering if you could speak to that and what that means in your locations. And we in India would be interested to hear from you and learn from how you have confronted and responded to those problems.
Brian, do you want to go first?
I was going to defer to you, Dean Matthew, but I'm happy to take the invitation. So again, the equity issue is relative to cohort and relative to what we're talking about, whether it's research or education. There's clearly an equity issue for all law schools in the differential impact of COVID on staff if they have to work from home in isolation and their different family responsibilities. So as I've said previously, we've had to, and then you have to track it through in terms of how am I going to look at the performance as well as the support of someone who's got 4 children at home, is an ambitious academic, whose research productivity has been affected, and they're 24/7 managing that. How do we manage versus an individual without caring responsibilities in a home environment which is much more receptive to them doing work. So there's an equity issue there for staff. There's an equity issue for students in terms of if I'm going to, and we have to face this, if I'm going to say that we're going to have exams online and with remote invigilation, then you have to have the technological means, and that means every student has to be provided, if they don't already have it, with the technological means to do assessment and to then be remotely invigilated for the purpose of maintaining the integrity of the accreditation. And that creates equity issues for students in terms of access to the technology. It creates equity issues for staff in terms of making sure that if they're having to mark from home, they've got it. In the delivery of clinics to all the community service clients, because remember the nature of most of the clinics that most law schools do is providing services to those who don't have enough money for a lawyer, who are in trouble somehow or need assistance, including with regulatory authorities and government services, not just facing criminal or civil problems with the courts. They don't get qualified for publicly funded legal aid, so they have nowhere else to go except a community legal centre, law school based or otherwise. Now, there are tremendous aggravations of equity issues, the rise of family violence, and that's an issue in Australia, it's an issue in the region, I imagine it's an issue everywhere in terms of COVID and being at home. So there are huge equity issues arising in an access to justice space, whether dealt with by clinics or not. And then a few of us have mentioned the digital justice aspect and the digital divide. Now, that creates its own problems in terms of equity. So it depends on how you cut the equity issue and the parity issue and the injustice issue, but it cuts a number of ways for different cohorts that are part of the constituencies for law schools.
I'd just add to that I think in some ways COVID has just highlighted underlying inequities. And so in New Zealand, we're really having a big debate about the need for more diversity in the judiciary and the legal profession. We've done very well on women, as have most, I think, Western law schools. So you'd commonly find 60 to even 65% of the law school student body being female, for example. But what about lower socioeconomic status students? What about students from a refugee background? In New Zealand, of course, we have our Maori population. We also have a huge Pacifica population. And we try to actively recruit those students into law school to make sure that we are producing great Maori and Pacifica legal professionals and judges. But often it's those students that sort of intersects with lower socioeconomic status. It's people living in multi-generational households without a quiet space to study. They might be more likely not to have access to the digital devices as well. So I think COVID's just really highlighted underlying equity issues that we've been, trying to grapple with for a long time.
I'll just add to what the two panelists have mentioned. The first, let me just mention about the global engagement and the content and delivery, which Robert has said, then I'll come to the equity issues. I think we have been offering the copyright course offered by Professor Fisher, William Fisher of Harvard Law School for the last 3 years. This year, we have now made into an online course. Earlier, it was offered only to our students in the law school. Now he has agreed. Next year, we are coming out with the South Asian students. I think this is what the COVID positive engagement of the global engagement I would like to underline. Next issue is about equity, parity, justice. I think Professor Brian is very right. I think all of us, we have to face, and this is a real challenge. First, within the equity, parity, justice issue is a fee issue, students' fees. I know all of us we are facing. We have been hearing about the suits filed in the United States by the students, and I think these are the issues also have come up in India. What we have done in majority of the law schools, we have reduced the students' fee, maybe 25%, 30%. So it is an individual law school has taken a decision. This is one. Second is access to technology. As I said, we are generally the elite law school. People in India call NLUs law school, National Law Universities are elite law school. So the students, those who come are upper middle class. So therefore, I think that was not a major issue of access to technology for the student. But students, those who are unable to get an access, so we have provided, the university has sponsored, given the laptops and other for the students and staff. The major impact is in the clinical legal education. I agree with Professor Brian, Professor Robert, and Matthew have said, because the clinical legal education, particularly in India, all of you are aware, it has originated from the legal aid for last more than 3 decades. So that has a strong root of public service. It's like a physical service. and those who are unable to cater. So that's a massive, in fact, that's another innovation in the Indian clinical legal education is not only having a standalone legal services clinics which work in the community outreach, but also a mandatory clinical courses within the law. I think that has a major impact it has. I don't know how do we come out of that. But one positive things the Indian law school, some of us we have done, you have all seen the migrant workers walking in India, and that was of late the Indian Supreme Court has realized and started responding to that. But the law schools are the first one to respond. The clinics of the national law schools have come together and started providing the reliefs to the migrant worker. But that's a long struggle we have to do. I think somewhere we were able to do. I think a little we have done, and a vast has to be done in the coming years. Thank you.
Thank you, Professor Rao. Speaking of innovation, change, and adapting to the new world that is ahead of us, I have been totally pulled into this very absorbing conversation and almost, for a moment fooled myself into thinking that I was actually in a room with all of you, only to be reminded just now that, that this is an online conversation. There are many online viewers as well, and they have come in with a few questions. And I was, perhaps I would just, put the questions out there, and any one of you, I could invite any one of you who thinks you'd like to respond to these questions to come in. There are two related questions, one of which speaks of the problem of reopening. Many of us, I'm assuming, have been under various kinds of lockdown, if we have not already reopened, that is. What are the challenges of reopening? And this is especially a problem in India where the demand for education is particularly pressing. I mean, the problem might be different in your context, but what do you anticipate the challenge of reopening to be? Is the question that one question that was posed. The second question, and these are the two questions that I think are different from the ones that we've already discussed. The second question that was posed is, how does one pull in a first-year law student into this new and changing landscape of legal education? Right? We have, I think, about 10 minutes left. So, if one of you could, if all of you could come in on one or both of these questions, that would be great.
So I'll come in on both, and I'll do them in reverse. We've got two cohorts, all of us, of first-year students next year. We've got first-year students who are starting in 2021, and second-year students or returning students who, in some jurisdictions, have not set foot in the place in 2020 once COVID hit. And so they might be second-year students, but they are effectively first years in some ways. So there's a two-level cohort. And that relates to what does reactivation look like, the first question. Well, first thing is it has to be safe. Again, we face different circumstances. We're not through COVID until there is immunisation, a vaccine and mass immunisation, and travel, given the nature of international academic communities, domestic international travel that is not going to create extra problems. So we're nowhere near that, even by middle of next year. So you have to return safely for staff and students, probably in a phased return and subject to local government and health requirements. In terms of teaching, we're preparing, and I suspect most people have to prepare for a hybrid mode or mixed mode, where you might have physically distanced face-to-face with reduced numbers. You might have to swap cohorts. You have some material online. You have some live synchronous virtual interaction because the students are craving that. So you're in hybrid mode, and we'll have to be in hybrid mode. And if there's an outbreak, you have to be able to return to complete virtual mode. So that's how reactivation looks like. Reactivation will not be, as many of us have emphasised, will not be to what it was like in late 2019. Reactivation will be to something different. But the health, the safety, the phased nature of it, the different cohorts, and then education being managed in hybrid mode are part of the reactivation plan.
Can I just add, perhaps on trying to draw in first years or even just students generally, having programs like study buddies or, encouraging them to be able to interact with each other online or with a more senior student or some kind of mentoring arrangement. I mean, that can be done online, and I think that's probably important. I really feel terribly sorry for first year students who've missed out on having this rite of passage and a fabulous time at university. It's meant to be an opening up, becoming an adult, being free, and they've had quite the reverse. So I think we need to be innovative and try and think of ways we can support them while continuing online. And I totally agree with Brian about the dangers of opening up. I mean, New Zealand's kind of been in that situation. We've been able to reopen, and then poor old Auckland, because we are the largest city, we ended up going back into what we called level 2.5. And in fact, just in the last exam period, we were quite happily holding exams in person. And then there was a CBD case that we thought might be, serious, and so had to watch it again. So it is very challenging. You have to be prepared to pivot back into a fully online space at the drop of a hat, really.
Professor Cunningham, would you like to go next?
Yes, look, I guess I would start answering this question where I began the whole session by going back to the existential perspective of why we exist. I mean, whether it is how we go about reopening or whether it is how we bring in first year law students, the question is really the same, which is why do people turn up? Why do they actually want to come and get a legal education? And it's now incumbent upon each of us to be very crystal clear about how we answer that question. And I assume that we'll all answer it in different ways. In fact, I hope we do answer it in different ways, but we do need to be crystal clear about what it is that we're actually trying to achieve. So, I think it's around that engagement story. How do we get students to engage with the content? Which is where it's so important, I think, to have, where possible, the physical interactions, because a lot of employers, the consumers of the legal education, if you like, the firms, they will often point to the soft skills that are required to be a lawyer, and so that's the emotional intelligence, that's the communication, that's the critical analysis, and those sorts of things I think remain better absorbed in the physical environment. It's sidestepping the central question a little bit, but getting back to an equity-related question, which is who's paying for the legal education? And I think that's a really interesting question, because in all different countries and all different law schools, it's going to be a combination of private and public. I'm assuming in the United States it will be more privately funded, and elsewhere perhaps more publicly funded, but without becoming too Australia-centric, there has been changes recently that essentially make legal education more privately funded, in the sense the students will be picking up most of the bill for their education. And why do I raise that? I think it's really important because legal education must be a combination of private and public dimensions. And if we move to a position where legal education is principally a private enterprise, then we risk losing the public dimension to the law, whether that's the clinical education activities that have been referred to, or the infrastructure of our democracy, the rule of law and these types of things, which can fall away or become less important, I think, when students are essentially what is essentially a private education. So I think getting that balance right between who's actually resourcing education, the private and public mix, is one that will become increasingly important as we move further into the digital domain. So there's just some comments.
Oh, thanks very much. That was an extremely important additional intervention that you made over and above the question that was put to you. Thanks so much for that. Professor Miller?
Well, so first, a quick response to Robert's last comment, which is what he raises is a profound and important question that was answered and settled here more than a decade ago, and we are on the other side of that line in the US. So as an example, the percentage of the higher education budget in Arizona that are state direct funds is now about 11 to 12%. It has been dropping and will continue probably to drop. So I actually would take on a lot of the conclusions you draw from that. I don't share where you went, but I understand and live with that challenge every day. Arizona is not unique in this respect. In the US, public education or higher education is now to a much lesser extent seen as a public function. And so the privatization of higher ed has taken place. On the two questions that were posed, so very quickly on the first year, remember we teach both undergraduates and graduates. The graduates have found an easier time. They still miss the chance to get to know their classmates well, but we have a small law school and we've done lots of things, and students have as well to support them. They knew what they were getting coming in. Professor Rao referred to the lawsuits in the US. Those have had no traction whatsoever. I don't mean to sound unsympathetic to them. It's a complex setting. And if students were here last year and their circumstances changed, that is a different claim than someone who chooses to come now and knowing what the tuition and at least having a broad sense of what the circumstances are. I thought the comments of others on the challenges of reopening were good and right. And look, University of Arizona is 45,000 students normally. It's a pretty big university. We've had about 5,000 on campus throughout the summer, and the rates in the US and in Arizona and at times in Tucson have been quite high, if you follow these things. There's now about 8,000 students on campus on an average day in labs and in classes up to 50 for those who want it. It's a complex alignment that respects staff and faculty and student preferences. We deliver through multiple strands. There has not been not a single case of transmission in a lab or class setting. The positivity rates here on tests have been under or around 1% for a while. Testing is widely and readily available. And there's been some innovations that protect now where I'm talking about the most immediate community, this question of reopening. So we have wastewater testing on all of our dorms. And right as the campus opened, literally 2 days after students moved in, they had to get a test before moving in. They moved in, one of the dorms lit up. It's a test with a sensitivity of 1 person in 10,000. The entire dorm was then tested. There was 1 additional person found who was positive. Those 2 students were isolated and supported. 3 days later, there was another test that stayed 0. And so instead of having an asymptomatic student who spread and put others at risk, we could both support the students who were positive and limit the spread. So in terms of reopening, I'm proud to be at a university that chose to move down the path toward reopening. It's been cautious. At times we've had to backtrack. I'm less proud of the larger US scientific and social response. But I do think that general path will continue as described by others thoughtfully. I think we wrestle with similar frameworks in that regard.
Professor Rao, last word to you on this or any other topic that you think that we've missed out.
3 observations. Firstly, about problem of reopening. I don't think middle of maybe July, August 2021, there's no question of reopening. The next semester will be completely online in India. Second, first year students, I think when we look at the next batch, which is coming from July, August 2021, I think we need to now innovate in developing a hybrid mode of learning methodology. I think there, the massive open online courses paradigm and methodology will be very useful, because we all know the receptivity of the students, particularly online classes, is very less. You can't have more than 5 minutes of receptivity of the student. So therefore, small videos, even the teachers developing the small videos and the content, and also exploring and acknowledging the videos which are available in the public domain, along with much more innovative, maybe discussions and others that's required. That's a challenge for a legal education administrator, how we all have to come together, reorient ourselves with the students and take the help of pedagogy and others, those who are involved in it. That's so much more. Last observation is about finance. I think in the coming year, the same situation like in United States and maybe Australia and India, I think more and more the governments, we have seen in the pandemic, governments have spent. I think they are right. You need to spend on the public health first. So higher education later. I think there's a challenge. Now we need to think about what are the new ways of generation of finance. In fact, the concept of fundraising is unknown to India, except Jindal and other. So now we are learning. We need to look at seriously develop what an aggressive fundraising. And one method is online courses. Online courses where we all have to come together. Maybe we could develop with all of you in where are our strength core area. We can come together, develop something which is a professional. It takes more than a year. We know we are all involved passionately in curriculum development, methodology and pedagogy, particularly online is one of the best method because I'm familiar. I started a distance education law school first time in Indira Gandhi National Open University in India way back about 10 years ago. So I am familiar and that's what one of my positive strengths, but this is the future direction. Future direction like the online international courses. Future direction is online student exchanges. Future direction is online faculty coming together. Peer group. I think that's what some of the panelists said. I think Professor Matthew has said. Another innovation we need to do is how the peer group can mentor the juniors, those who are coming. Because the teacher has his own limitations. And again, teacher also has to reorient because of the receptivity is very less in the online teaching. I think these are my comments. Thank you, John.
Thank you, Professor Rao. You've done a wonderful job of pulling together the threads of this, this at times roving conversation. But I think it's a pleasure. It's been a pleasure to have had this conversation with all of you. Thank you all so much for joining. Unfortunately, there are many loose ends to this conversation that we'll probably have to come back to with many, many more future.
I appreciate John Matthew. Wonderful, your comparing and then moderation. Thanks, Matthew.
Thanks. So thank you, Professor Rao. So thanks once again to all of you. I'm really, really delighted that I had the chance to speak with all of you today. And I hope we will keep this conversation going and that we can have many more opportunities and chances to come back to some of the issues that we raised today. Thank you on behalf of Jindal, and I pass it on to the admin at Jindal to take over from here. Thanks once again to all of you.
Thank you.
Great job, Matthew John. Thank you so much. You demonstrated you're a great leader as part of the moderation process, which you downplayed your leadership qualities at the beginning, but that was not true. Well done.
Thanks.
I'm proud to say I have taught Matthew. In fact, we have learned many things from Matthew John. Yes.
Yeah, Professor Rao was my first teacher at law school when I joined as a first-year student.
Christopher will join us shortly, but we will move as per schedule and we'll start.
So we are going live in a few seconds, so just be ready.
Good morning from India. Good afternoon for our friends in Southeast Asia. Good evening to our friends in Australia and New Zealand. It is indeed a proud privilege to welcome all of you to this third day of the Global Virtual Conference on Reimagining and Transforming the Future of Law Schools and Legal Education. It is also my proud privilege to welcome all of you to the 25th thematic session of this conference on the theme, The Webinar Revolution in Legal Education and Legal Profession. We have with us a very distinguished set of individuals, institution builders, who have themselves provided leadership in advancing the cause of what we are discussing today. I have great pleasure in particularly welcoming Professor Judith McNamara, Head of the School of Law, Queensland University of Technology in Australia, Ms. Payal Chatterjee, Senior Member of Nishi Desai Associates, one of the leading Indian law firms, Professor Rashmi Raman, Associate Professor at Jindal Global Law School, my own colleague at OP Jindal Global University. We are shortly expecting Professor Dr. Christopher Mabizira, Principal of the School of Law, Makerere University in Uganda. I also want to particularly thank my colleague, Professor Dr. Jasmeet Gulati, Associate Dean, Academic Affairs of Jindal Global Law School at OP Jindal Global University, for accepting to moderate the session. I just want to quickly say that the reason for calling this as a revolution was very conscious. Little did we know that the pandemic will create an extraordinary opportunity for us to do what we are doing today. In fact, this conference is an example of what is possible when we can connect the entire world. Over 35 plus countries and 150 plus deans of law schools around the world, including professors, vice chancellors, judges, lawyers, as well as others, have come together for the last 2 days, and this is into the third day, and we are all discussing and debating issues surrounding the future of legal education. This has been possible due to the webinar revolution. It also means that we are also contributing to the democratization of knowledge and creating a more inclusive experience for people who simply could not have participated in these conversations hitherto. So this session is in many ways one of the more critical sessions of the conference, when we are going to discuss and debate about the future of webinars as a framework for interaction as we have today. I'm going to hand this panel to Professor Jasmeet Gulati, and I'll see you in 55 minutes. Thank you very much.
Thank you, Professor Raj. Thank you very much. I welcome one and all to the thematic session, the Webinar Revolution in Legal Education and Legal Profession. Joyce Meyer, an American author, once said, "Teachers can change lives with just the right mix of chalk and challenges." We've had chalks, but this year we are having our share of challenges. This will have its impact on the lives of not only the taught, but also the teachers. The impact of the pandemic has prompted educators like us all over the world to think of innovative ways to continue teaching and learning. What started as a modest ambition to sustain education has in fact revolutionized the higher education sector. Well, thanks to the imaginations of the educators all over the world. While video conferencing applications such as MS Teams, Zoom, Cisco WebEx, they have become the lifeline for the higher education institutions by making remote learning possible. They have also triggered a learning revolution outside the classrooms through webinars or online seminars. The ongoing webinar revolution has provided dynamism to academic and educational activities. Webinars help academics around the world to transcend the physical borders and speak to their global audience. Webinars made many voices to be heard globally, helping people get representation for their voices and receive recognition to their ideas. Webinars to a large extent made communication non-hierarchical. The publicly available webinars have bridged the information gap by allowing students from the remotest and the most marginalized spaces to become part of the knowledge network. webinars in that sense have been an empowering process by bringing knowledge to everyone. The digital spaces are the new agoras for people around the world to gather and share ideas. Legal education in particular has tremendously gained from the webinar revolution. Online colloquiums have seen gathering of members from different parts of the world. In fact, it also included law firms, in-house legal counsels, members of the judiciary, and law school leadership like you all present here today, and the faculty to come together to discuss the response of law schools and the legal profession to the ongoing pandemic. It has given a quick and easy connect between the legal industry and the students, easing out the various apprehensions created for students in times of uncertainty. While webinars have revolutionized the world, they are not free of concerns and challenges. The webinars have led to an information overload, fatiguing the portals and IT systems. Although concerns continue to prevail, ways are also being employed to address them. This new revolution has indeed set the groundwork for further use of deep tech and advanced digital technology in bringing about innovative solutions to long-standing socioeconomic problems. It has given an opportunity to make room for a virtual collaboration amongst law academicians, students, legal industry professionals, and enhance the experience of legal education in these difficult times. Therefore, this thematic session is an important platform to discuss the webinar revolution in legal education. I have a few questions for my panelists here today. I would invite for that, I would want to invite Professor Judith, since we know that the start of the pandemic, webinars have been utilized for a diverse set of industry and academic initiatives. So according to you, Professor Judith, in what ways have the webinars contributed generally and particularly to legal education?
Thank you. I guess maybe just to put a little bit of context behind some of my comments. Here at QUT, we've been teaching law to students who have been learning remotely for 30 years. We are a small state in Australia, in Queensland, and we're fairly diversified. So we have people living in regions that aren't very heavily populated. And for that reason, QUT Law School was established partly to meet the needs of people who lived in more remote places in the state, so that they could have a pathway to being admitted as lawyers. So we've been teaching remotely for a very long time, but that goes back to the days where we did that largely through what we called study guides, so large books that we produced or booklets that we produced to supplement textbooks and other materials, as well as audio recordings of our lectures. So we already had those remote learners. Now our practices had evolved enormously over that 30-year period, and we were a lot more sophisticated than audio tapes, cassette tapes, and paper-based study guides with a pretty well-used learning management system. But that meant we were pretty well placed to transition online fairly quickly. In Australia, we moved to a lockdown in the very early stages of the pandemic, which meant we had to sort of pivot from our usual approach within a week. So we went from teaching face-to-face and remotely to teaching fully online in a week. So I think that means that it's really clear to see how the use of online seminars for our teaching has really enhanced the experience of those students, particularly those who were already learning remotely. And the feedback that we've had from those students is that actually it's a lot better for them. They feel part of the community of students at QUT. They feel much more connected to us. They felt supported through the pandemic with our ability to provide them with information. And the opportunity for them to engage with each other in online seminars and to engage with the internal students has improved their experience enormously. We have tried to have webinars for classes previously, but it's been difficult to create enough engagement just by not being able to get the number of students in the room at the same time. But because we've mixed those cohorts now, we've been able to provide a lot more engaging experiences. So that's been one huge advantage. I think some of the other things will be unpacked a little bit more in some of the rest of the questions, but our ability to do things like this when we are so far away from a lot of the rest of the world, it takes a long time normally for us to be able to go and participate in a global conference like this. So, and to be able to bring those opportunities to students as well has been incredibly valuable. It's not without its challenges, and I know we'll get into those more as we work through the seminar, but I might leave it at that for the moment to give other people an opportunity to talk as well.
Thank you. Thank you, Judith. Payal, in your views, has the online space been oversaturated with that information overload? No, it leads to the right content not reaching the intended audience. Some have even referred to it as webinar pandemic, rather than the pandemic that we are already going through. So how relevant is this observation in the context of legal education? Even in the world of law, where information is a vital currency, how much information can be too much information? How can we effectively engage in webinars and collaborate to create a balance between knowledge creation and curation?
Thank you, Dr. Gulati. I think I agree with that statement, actually. Having been part of several webinars myself and my inboxes being spammed to some extent, I would say, where you get an invite for a webinar on a daily basis, you actually start rationalizing which ones you want to attend or which ones you want to be part of and speak at, because it is an information overload, undoubtedly. But I think when it comes, there's a good side as well as a bad side. So there are pros and cons. Now, from a legal education perspective, I mean, speaking from my experience, the firm I work with, we started off with the concept of a continuing client education program, which was a very similar model which we already have in US in the CLE, but which we never had in India. Now, if you ask me, there are some sessions which are going to be very apt and appropriate for the law students, but not everything is meant for a law student. So I think it's very important to draw that bifurcation, that what is relevant from a student's point of view and what is meant only for maybe a client who wants to understand the commercial perspective to the law itself. So I think this is where the academicians or the faculties play a much bigger role, because if they are updated and they are keeping in pace with these kind of webinars, they know which one to guide their students, which is actually meant for them and their intake, and actually will help them understand how to move forward. But at the same time, I think students nowadays, at least from what we were back a decade back, as to we not having this kind of exposure at all. It was only maybe once in a few months when you have a faculty coming from some other jurisdiction and delivering lectures to you in your law school. Today, I feel the students are a lot more lucky and they have this access where every day at least they can at least attend one webinar where you have a viewpoint given not just from an Indian perspective, but it's a global viewpoint which has been shared with them. So which is a great. But at the same time, yes, there has to be certain checks and balances implemented as well. So as I mentioned earlier, I think it's for the law schools to come in and play a bigger role and guide the students itself. Okay, this is meant for you and this may not be appropriate for you. So I think it's the right balance. Otherwise, it will be a fatigue and students will no longer be interested in attending the webinars. And the last point I feel is interaction. Some webinars where you are not opening it up for Q&A and the students are attending it, or they feel that the questions which have been asked by the previous speakers are something which are of, in their view, something beyond them. It should not be thought in that manner at all. It should be open discussion so that students can also participate. I think one of the best ways was me as a working professional, having got the opportunity to interact with a lot of students And then we tailor make our presentations itself, which will be useful for the student community. So I think that tailor making of presentations and adapting to the right audience is very important so that there is no saturation.
Well, thank you for the very good inputs that you have given us. Yes, you're right there that it is important for us also. How do we deal with the class? Professor Rashmi, since she comes from the education and she is an academician and in law school, Rashmi, see, webinars and online seminars, they have for now taken up a large part of the legal education space. So do you think that the lack of intimacy and the face-to-face engagement would inhibit the exponential rise in online seminars after the pandemic? If not, what measures can be taken to increase the engagement in the online format, Rashmi?
Thanks for that question, Jasmeet, and thank you so much for having me. I think it's a really difficult and important question because it uses the word that we're all shy to talk about. What happens later if things return to normal? Are we going to have the same kind of interaction? And I like the use of the word engagement and intimacy, both of which feature in your question, because they are issues that I personally have struggled to address in the course of what has been a glut of webinars over the last 7 to 8 months. So while I have enjoyed hearing myself, and to a large extent, this is a very narcissistic process because you don't feed off of the energy of the others in the room. You are in a space by yourself. And that's, I think, partially the response to the question on intimacy. It allows people to focus much more on the content. And so I think that we are able to achieve a depth of engagement that in the past used to be quite elusive, because in a classroom, or in a real seminar, which we are slowly forgetting, in a real conference, the ones that we've been doing in our past lives, we used to feed off of the energy of others in the room. There were good panels, there were great panels. But today, every panel has the potential to be as good or as great as the speakers in it. And there isn't really, we've removed the arbitrability of feeding off of each other's energy. At the same time, I think while this is fantastic, it really takes away from the breadth of the discussion. So we've deepened it, but it's very difficult to engage everybody and have everyone participate in the conversation. And I think that's what you mean by the inequities of the system. Many people feel like they are outside of the discussion, and the othering that we so consciously avoid in legal education, in my discipline particularly, we're very conscious of the processes of othering that technology can create. And I think that inadvertently, we are tiptoeing around this landmine. And, I have a few other things to say about this, but I think preliminarily, this would be my response. And I'd love to, move forward and have a more significant engagement with my fellow panelists.
Thank you, Rashmi. So this comes, this takes me back to Payal, since she said that academicians at the law school, they can play a very important role here. So do you think, Payal, that the webinars and online seminars have brought the digital divide to the fore, as Rashmi also pointed out? How can a law school ensure that a certain section of students or teachers is not adversely affected by the lack of access to internet or, for that matter, technology?
Just me. Definitely, I think today we live in an era where it's not that it's an option to have technology, it's a must. I mean, that's something which I think the COVID-19 has made it very clear for everyone, no matter which profession you are in. Having said that, I think today's day and age, we are in a situation where all faculties as well as the students would be equipped to use the technology, but at the same time, there could be certain sessions which could be conducted within the legal, I would say the law schools itself, to making students more adept with the usage of technology itself and with the various platforms that are available these days. I mean, going from an example, like as a practicing lawyer, we have to appear before various high courts. Now, every high court has its own mechanism in place and a different platform. So we are also adapting with the same way, and I think it's the same applicable for the law students as well. And it goes back to even our judges as well as arbitrators who do not want to restrict themselves just because the courts are shut. You have to understand the usage of a technology like a video, which is there for Supreme Court, or the WebEx platform, Zoom, every platform available, and understand how to use it well and the various features. Because without understanding that, I don't think the law students are going to make the most of that. So obviously, it's a step towards the digital revolution as well. And I think it's the best time for every generation to adapt to it, to make the most of it.
Thank you. Thank you, Bhai. Professor Judith, webinars, see, they have provided opportunities for law school leadership like you to come together on a single platform to collectively innovate ways that we presently doing as well during the ongoing pandemic. How instrumental have webinars been in bringing about a positive collaboration between law schools to create discussions of actual impact to define the future of legal education in times of ongoing pandemic?
Thank you. Thank you. That's a terrific question. I mentioned before the opportunities that online seminars create for us to engage with people who are, very long distances away. So, ordinarily for me to visit pretty much anywhere else in the world, I need to set aside, at least a week, but probably a little bit more if I'm going to the Northern Hemisphere. So you tend to save up those sorts of connections for, sort of longer and bigger trips. But this year I've participating obviously in this panel, but, early on in the pandemic, met up with academics from law schools in the UK to talk about what they were doing in terms of their online learning, with a particular focus on their legal clinics and those sorts of opportunities. And we shared ideas about what was working and ways of approaching things, sort of unpacked what the issues were around things like confidentiality. And we've been able to keep that connection with those people going throughout the pandemic, so that we're supporting each other in that shared sort of experiences that we're having. On a research front, I do some research into legal education and took this opportunity to talk to students about their engagement in online learning, and was able to very quickly connect with some partners in the US and in the UK to sort of plan to work with them so that we can talk to their students as well, and again compare the experiences of students in other law schools in other countries. So those sorts of things have been able to happen very quickly. It's not, worrying about getting on a plane and setting aside time to travel. You can just schedule a time in your diary to meet up with people and have really quite in-depth discussions. And I think we're also used to, being in meetings and being in classrooms and engaging in this way that people feel relatively comfortable. Whereas 12 months ago, I might have said, Zoom, I'm not quite sure how to log on. It's easy. You just log in, you're there, you're talking to people all around the globe. So those sorts of opportunities are incredible. And it's also given us an opportunity to talk to our own students in different ways. So we've, as I mentioned, I'm doing a project talking to students about their experiences with online learning. And because we need to comply with our rules around social distancing, etc., we decided to do that online. So we used Zoom and Miro, which is an online whiteboard, to meet with students, to have more or less a focus group with students being able to collaborate in that way. And again, that's given me a much deeper insight into the experiences of a range of students across the law school that we can then build into our future teaching, whether that's, continuing to be doing a lot more teaching remotely next year, or as we start to return to something of normality. But the opportunities to really improve the way that we collaborate and the way that we teach have been enormous.
Yeah, thank you. This actually takes me back to the classrooms, you see. So these webinars, they have truly shrunken the world to computer and cell phone screens, rendering the world to come to fingertips. So everybody, we are looking into our computers, our cell phones, and we're attending classes, we are taking the classes online. So, but the online world also has the potential to provide multiple experiences to all, to the taught and the teachers. Rashmi, according to you, do you think these online engagements such as webinars, are they distracting and define the very philosophy of classrooms or lecture halls? Since, I mean, we coming back to the classrooms and lecture halls, what are their experiences? And don't you think that this is somewhere define the philosophy of old traditional classroom teaching?
So it's quite tempting to go down that rabbit hole, Jasmeet, of wondering whether there was an original purpose of the classroom and there's some sanctity about the lecture hall. But to be honest, I don't buy into it. I think that the pandemic has been a fantastic equalizer, and the opportunities that exist today of bringing anybody we want, I mean, of course, subject to their availability and agreement. It's just, it's as Judith was saying, you can be in 5 countries in one day, and the power of that is enormous from the perspective of the learner. Would they rather have the same professor every day just because she's available? Or wouldn't I would love to be a student right now because the kind of experiences students get today, it simply doesn't compare to what the traditional classroom model had to offer. I mean, just last week, actually earlier this week, we had a really senior practitioner from my former employer, the International Criminal Tribunal for Rwanda, who made a special guest lecture in my human rights class. And this person's schedule is so busy that I could never have contemplated having him come all the way to India in the middle of the semester on a day that's convenient to my class to deliver a lecture, right? So it would have to be part of a much bigger trip to India or something like that. This is what Judith was talking about. So we have to appreciate that technology in this respect has been a huge blessing. It's an equalizer also in another sense, because the exclusivity, and I speak from a limited perspective of my discipline. In international law, there tends to be little groups and exclusive little clubs of some academics in some parts of the world. But over the last 8 months, we've witnessed everybody taking to the blog space, because, and it's purely a contest of merit. So the blogs that are doing remarkably well are blogs like, for example, Afronomics, and they are hosting these virtual conferences that are just fantastic and bringing speakers from the developing world. And never before has the possibility of the global South taking a lead in legal scholarship been more real than it is today. And I think that's a big victory of the digital platform that I must acknowledge. So whatever the pitfalls, and I'm sure we will discuss those eventually, the sanctity of the real classroom and so forth, I embrace this change and I'm all for it.
Thank you for this, Rashmi. I do understand that. Professor Judith, the pandemic has opened up new avenues for communicating, teaching, and learning. This is particularly true in case of law schools, as you also say. So while hardly there are doubts about their effectiveness, the likelihood of the euphoria around webinars dying down is high once the world returns to its old normal, as we put it. So how do you envision the future of the present excitement around webinars? Since, I see Rashmi really very excited about the new normal and the webinar revolution. But how do you envision the future of the present excitement around webinars?
Look, I'm very optimistic. I'm very optimistic that we have all embraced such different ways of engaging with people around the world, with engaging with students, that's something that we will start to take as normal and natural and not something that's unusual. So, I mean, my vision for the future is that we are able to connect our students with each other a lot more flexibly. One of the, I think the most significant advantage that students saw in the current approach and the use of webinars for teaching is that they had the extra flexibility to study from home, to save themselves travel time, to not have that need to go on campus, and particularly if they had other issues like health issues or whether it be their physical or their mental well-being that they needed to look after, they were able to engage in their learning in ways that suited them. And that flexibility is something that students are very, very strongly asking to continue. We have undergone such a process of upskilling our academic staff. So again, it's not the benefits of webinars for teaching aren't necessarily uniform. The student experience is that sometimes it's worked incredibly well and sometimes it's not been so interesting. So where the people who are teaching have been able to use the technology well, where they've been able to engage with students. So one of the examples that students give is, well, sometimes in a face-to-face classroom, it's actually quite hard to put your hand up and ask a question or to participate in the discussion. And there are sometimes, classroom dynamics mean that a smaller group of students might dominate, and it's hard for them to feel that they have an opportunity, if they're still developing their confidence, to participate. But where those classes, online classes, are run skillfully, then students are given opportunities to participate that they might not otherwise have. They can use the chat function. They don't need to interrupt a conversation. They can put their questions in chat and the facilitator can come back to them later. They can use breakout rooms in Zoom to still replicate small group learning. And where that's done well, the student feedback is enormously positive, and that's something that they want to continue. But I think the key piece of feedback from students about what they're missing is that connection, the human connection and the human experience that they have on campus that they haven't been able to have online. And so that's particularly the case for students who have commenced this year and haven't really had an opportunity to form those connections. So the ability to form connections in the purely online space has been pretty challenging for a lot of people. But for those people who have already been studying for a year or two, they already have those connections and they've been able to maintain it a lot more readily. So I think one of the real challenges for the future, and something that we will need to turn our minds to if we are going to take advantage of the affordances of online teaching, is that we think about how we continue to create those communities where people don't already have the connections. And I was just reflecting on the comments earlier about sort of moving beyond existing, groups of researchers and the community connecting more broadly. And I'm wondering if there are some lessons we can learn from the way we've connected around research with other academics and with other professionals, and actually bring those into the student environment to help them to create connections where perhaps they haven't had a face-to-face experience to build upon. But there are certainly opportunities to reach out to students in different ways. So not trying to replicate the sorts of experiences that you have face-to-face, but give them different opportunities, like being able to participate in workshops, you know, using different sorts of tools and engage in different ways, different sorts of professional networking and different sorts of student activities that aren't trying to just redo what we did face-to-face and plonk it online, but actually think from scratch about, okay, well, how do we use the tools that we have to create really good, valuable experiences, whether that's for learning, whether it's for connecting with other law schools, rather than just trying to assume that you can do things the same way when you're moving online. So, I mean, those are some of my thoughts about the future. I think it's incredibly exciting, but we can't just assume we can keep doing things the way we already have and just move it online and it will work, because we need to do things quite differently for ourselves and for students to make that successful. And how we create communities in the online environment, I think, is the really critical piece that we need to think about.
Thank you, Judith. Thank you so much. Having a global perspective on conflict resolution is a very important aspect of legal education. So while how instrumental have webinars been in bringing such diverse perspectives from distinguished speakers across the globe for the law school students specifically, something which may not have been as easily accessible or even imaginable in a pre-pandemic era, as you have also rightly pointed out when you were talking about your times a decade ago. So have webinars indeed elevated the legal education experience?
My first response is yes, it has definitely done that.
Yeah.
And I think one of the best ways or examples of that is the webinars these days are not restricted to you giving a very domestic or a local view.
Mm-hmm.
Most webinars are structured in a manner where you first, I think prerequisite is it's a diverse panel.
Mm-hmm.
You have the panelists from different backgrounds and different kind of experiences.
Mm-hmm.
So that what they bring onto the table is something very different. When I am being taught by a faculty in a law school, as Rashmi pointed out, it's just one faculty who is available and is teaching you. But when you are attending maybe a short 1 hour or a 1.5 hour webinar, and you have 5 panelists from 5 different jurisdictions and who are sharing not just from a very legal point of view, but their practical experiences or what they have actually done in certain live matters, and bringing that into picture, I think it's very useful for a law student. Let me get an example, like as you said, conflict resolution itself. How a dispute is fought in India or resolved in India is very different from how it would be done when it comes to US or UK. So if you have a professional who are talking about maybe something like arbitration or an insolvency regime for that matter, in India, as we know, arbitration obviously has developed over the years, but insolvency is something which is at a very nascent stage. But when you have a panel which is talking about a cross-border implication or a cross-border view, which tells you how UK courts or Australian courts have dealt with it and how Indian courts, a law student goes back and suppose, I mean, if he or she is a final year student, is thinking of a dissertation or a thesis at that point in time, the pointers which you would have taken back from that webinar would be very useful for you writing and doing further research for your own paper to understand not just one point of view, but how it operates. And I think it's a great platform for students to learn and get that kind of exposure, which normally you would not be. And I think it also helps you for your further education. It gives you a broader oversight, I would say, exposure and capacity to think that maybe I am interested in this and let's know a little bit more about that jurisdiction, which can also be useful to imbibe in your own jurisdiction and studies and back in India.
Yeah, but
I think it's a great thing to have that cross-border mix.
So with this, the plethora of webinars happening online, do you believe somewhere down the line, the quality of the webinars is somewhat being compromised?
Yes, it is. I think it's very important that before we have a webinar, it is very important to understand whether it's a very broad overview or is it something very specific which you're addressing in the webinar itself, and who is your target audience? Because accordingly, you need to make your presentation so that they understand it. It is apt for them. If now suddenly I am addressing a set of students who are in their second year or third year, who have not yet studied the detailed subject or had those courses in their curriculum, and I start off with saying, okay, Supreme Court is doing this, Supreme Court is doing that, it's not going to work for them. They first need to understand what the basics are. Then you can go on to explaining them with examples and I think furthermore about other jurisdictions. But I think understanding your audience is very important, and then catering to them and depending on their requirements will be useful. Otherwise, it's after a point, you feel after half an hour of the webinar, I really didn't understand anything. It was not useful to me. Why did I waste half an hour? You don't want the students to go back with that feeling. You rather have a short webinar to the point so that it caters to them. I think having a preparation behind that webinar is very important before you address anything.
Okay, Payal, this takes me to another question regarding the legal education that we are imparting. Basically, the practical aspect of this. With discussions and debates, are the webinars equipped enough to guide the most significant concern, which is the practical skill of a legal professional? And this question has come from the viewers to me.
Whether the webinars are equipped, I think it again goes back to who is addressing it. Now, if I am on a panel, I am not an academician, so I might not be able to address a pure academic question. But if I'm asked as to how it actually plays out in the courtroom or how an arbitrator is going to look at that issue, I might be able to give a proper example saying this is how I have seen or I have dealt with the matter in the court and how the judges have reacted to it. So I think it's the mix of the academicians and working professionals who bring in that practical element that needs to be brought in. Only then can you address that bit. Otherwise, it might not be possible to actually show the practical aspects. Having said that, I think going forward, whether you can actually deal with these practical issues or not, though we are trying to do away with the physical boundaries through the webinar, but the point is, I think maybe the right way is a hybrid solution. There are some things which have to be done physically itself. You cannot just do away with it. I might share my experience, but a law student will understand or get a lot more when he or she practically attends a court hearing. What he or she will take back with them is going to be very different from my experience sharing. So I won't say that it actually replaces it or it will be able to do complete justice. But yes, considering the times we are in, we need to have a hybrid model and make the most of it.
Thank you, Pai, for this. Okay, Rashmi, since we know that many students are attending these webinars also to build up their CV, we know this is what is happening. So how do we tackle the practice of students choosing webinars only for the sake of boosting their CVs? So does that impact the objective of the webinars?
Yes, of course it does, Jasmeet. And I was thinking when my fellow panelists were discussing how much I miss the things in a conference that you cannot replicate online. For me, a conference was, yes, of course, it was about the content and it was about the paper, but it was also a networking opportunity. It was the coffee between the sessions. And that's why you arrived a few minutes late to the next session. It's not because you're tardy. It's because you're meeting friends. In the end, we are social beings. And isolating ourselves, some of us, we come to this pandemic in the middle of our careers. So we have all of those experiences. And we're using this time to recollect, to share with the students. But imagine how alienating it must be for a student that doesn't have those experiences. She's in the classroom for the first time and she's listening to people recounting their days of glory, networking with somebody and how that led to a job offer, etc. That's what makes a CV, right? Not listening to somebody talk about their careers. So I think that there's a human cost
to a webinar. But I think we all go into a webinar quite conscious of this cost. I don't think it's taken any of us by surprise that, oh, we can't really have networking event over coffee. And part of what's lost is also, the little discrete meetings that used to break out in conferences. And one of the things about a webinar that, everything's recorded. And so if you miss something, you can go back and listen to it. In a real conference, you never could. And so the one that took the most away was the one that was always there. So there's something to be said about all of those things of being diligent, of being on time, of being prepared, which are kind of dispensable now. They're optional now because you can go back and look at it later. You can be in your pajamas and join a webinar where the speaker may have prepared for a long time, but you're just a casual attender. So I think that, I'm not qualified to comment, but I guess psychologically there may be something to how mentally prepared you are to take away from a certain conversation the best that you possibly can. Or are you just superficially skimming it? And I think that's a sense of, self-awareness. But having said that, I think that these are extraordinary times. And we didn't really concoct this as an alternative to real life. This is how we adapted to real life, to the challenges that life threw at us. And so, of course, there's a cost to it. But moving forward, I think that students, when they attend seminars or conferences, for the sake of their CV, it's a bit, I don't really understand it. If it leads to something like, an internship maybe, that's something that's good for your CV. But attending a seminar in and of itself is something you do because you want to know more, or you have a curiosity about the speaker or the subject, and you want to explore that further. Law students by nature are competitive, and law schools, were never meant to be easy. If someone thinks that law school was meant to be an easy ride, well, they were misinformed. Law is a competitive profession, and we all got ahead of the group by the little bit that set us apart from our peers. So I think that if there is to be a hybrid model moving forward, it has to take into account the need for real human interaction. And also the depth that having a focused discussion can afford. So I think that, it's a great convenience because it shrinks the globe. But for a student and for a young academic or professional, whoever is attending, I think there has to be something more to the webinar experience than simply a line on one CV. And I don't understand how it could be otherwise. I don't see why anybody would want to attend any event just for a line on their CV.
What would be the significance of webinars in the post-COVID education system?
Well, I think that they will continue to be spaces where we can bring together a wide diversity of professionals, practitioners, academics, without the restrictive costs associated with preparing and planning those things in real time. But I also think that we have developed a sense of comfort with this medium, and that's going to make us stronger moving forward. This is no longer going to be so exceptional. We're all used to sitting in front of a camera. We understand the good things that it can do for us. And I believe that moving forward, we're all going to think of ways of how we can return to this sense of comfort, but also try and do things that are local in a sense. So the global and the local are going to coexist in our lives, as they have already done for many of us. And I think moving forward, the future of the webinar is that I don't think it will ever replace a conference.
But I think that it will enrich existing conference sessions by having people not treat the guy who's participating from Skype as an outlier, but as very much somebody in the room. Because in the past, we were used to, so many people used to gather in a room and there used to be one person on Skype. And then most of the time there would be AV problems and a lot of, oh, hello, can you hear me? And, oh, I can't hear you, I can't see you. But, now this is the rule, this is not the exception. So this learning, I believe, I hope very much that what we've learned is going to be helpful to us to be more functional professionals in our chosen fields.
That's right. So with no certainty around the end of this ongoing pandemic, webinars could continue to play an important role in creating discussions of importance. So Judith, how should the virtual space evolve for a better webinar experience for law school students?
Yeah, so I think there are a few things that we can do in terms of our experience. I think we need to think about what we can do differently and advantages we can get from the webinar that we might not be able to get from our face-to-face experience. So, and I think we need to learn a lot more about the technology that's available and how we can effectively use it. So we can have a seminar and one of the great advantages is you can go to things that you might not know a great deal about and maybe just listen and learn about things that you otherwise might not. And that, I don't think we should see that as a negative, that people might go to things that they otherwise wouldn't. But in terms of when you're wanting a deeper experience, I think as facilitators, we can always think about how we engage with the audience. I think one of my fellow panelists talked earlier about knowing your audience. And so ways of bringing the audience into the discussion, ways of connecting with them. I think we can think about how to do that. One of the advantages is that the webinar is recorded, so people can come back to it. They might want to revisit certain parts, think more deeply about aspects of the discussion. But we can also think about how we capture the webinar in a different way so that someone doesn't have to listen to the whole seminar, but can still get a sense of the experience and who they might connect with. So one of the things that some of my colleagues here have done from a classroom webinar recently, where we had legal professionals from a range of different sorts of backgrounds talking to students about entrepreneurship and innovation. At the end of the panel, it was recorded, students can listen to it again, but we also created, I don't know if you're familiar with the term sketch notes. So we had a visual artist draw the conversation. So there is an artifact there that you can quickly visualize in one page that captures the panel discussion. So you sort of, you've got a way into the discussion before you know whether there are parts you want to go and listen to. And I think there are all sorts of creative things we can do about, let's move beyond a video camera and a microphone and think about other supporting tools that we can really use to enhance the online experience. And then, there will always be those opportunities to connect face-to-face, but when we're connecting virtually, how do we get real value out of that? How do we get more out of the virtual experience or different things out of the virtual experience than we do out of the face-to-face? And they are different things, we get different things out of them. So I guess I really challenge us to think about this as an opportunity to get something different, but we have to think about creative ways of doing that.
Thank you very much for this point. Well, this takes me to the last question for you, Judith. So do you believe that an entire virtual institution can be established in future? Because we've been very positive about the webinars.
Yeah, look, I'd have to say yes to that. I wouldn't like to say no. I don't know how long that will take, but I certainly foresee that at some point in the future, and probably not too far away, that's possible. And the advantages would be enormous. One of the advantages in terms of law school collaboration that I didn't mention before is being able to connect our courses to courses offered by law schools somewhere else. So something that we don't teach, and allowing opportunities for our students to do that. So, maybe in an ideal world, it won't be a single virtual institution. Maybe it will be a web of virtual institutions, and it'll be a much more holistic view rather than sort of one virtual institution sort of covering the field. I'd like to see us create a network and a web of virtual institutions that connect together.
Thank you. That's a very positive note, Judith. So, John Dewey, an American philosopher, psychologist, and educational reformer once said, "If we teach today as we taught yesterday, we rob our children of tomorrow." So one needs to change with changing times and innovate new ways of teaching learning process. Thank you very much. It has been a very enriching discussion. And like me, I'm sure that our audience would have been enlightened with the talk. Thanks, everyone.
Thank you very much for so ably moderating this panel. It was a fascinating discussion, and I really believe that some of the ideas that were generated during the course of this discussion will inform our thinking as we look at the future when it comes to understanding this webinar revolution. Our university has, in the last, say, over 6 months, conducted over 1,000 webinars. And I have personally been part of over 250 or so. And one of the things I realize is that the time that gets devoted for an individual speaker is significantly lesser than what it would take when it comes to doing something like this physically. That also essentially means that the people who are contributing to these efforts, their time is valued, and indeed more number of people are able to join and participate. And of course, geography clearly becomes history when you bring this into the technological context. Of course, I, for one, do not believe that the brick and mortar campuses are a relic of the past, and I do believe that they will remain and will continue to play a very significant role, but it does create an extraordinary opportunity to explore as much. Of course, Payal belongs to a law firm which has been at the forefront of some of these innovations for a very long time. And we in academia, at least I will speak about our university, have been a little late in understanding the possibilities that technology can provide. So I'm grateful to Ms. Payal Chatterjee, Professor Judith McNamara, Professor Rashmi Raman, and of course, Professor Jasmine Gulati for being in this conversation. I'm sorry that we couldn't have Professor Christopher Mabazira. This also, of course, shows some of the limits of technology that all of us face when it comes to getting access as well. So thank you once again. We will be having a short break, and we will have the 26th panel thematic discussion on resource maximization through digital interlinking of law libraries, which I believe is a very critical issue that all of us will be addressing. So thank you once again, and thank you for being here. can start. Good afternoon from India. My name is Rajkumar. I'm the founding Vice Chancellor of OP Jindal Global University. Good evening to our friends in Australia and New Zealand. Good morning to other friends in different parts of the world. It's indeed my proud privilege to welcome all of you to the third day of this global virtual conference on reimagining and transforming the future of law schools and legal education. We are in the 26th thematic session of this conference on the theme Resource Maximization through Digital Interlinking of Law Libraries. I'm very delighted to welcome a distinguished set of individuals, institution builders, including senior library directors and those who have spent a good part of their life doing what they are doing to this particular panel. I would like to first of all begin by welcoming Professor Astrid Zay, Associate Professor, Faculty of Law, Sapienza University of Rome in Italy, Professor Dr. Achilles Emelianis, Dean of the School of Law, University of Nicosia in Cyprus, Dr. Jagdish Arora, former Director, Information and Library Network Center, Inflimnet University Grants Commission, India, Mr. Buddhi Prakash Chavan, Director, Global Library at OP Jindal Global University here in India. I'm particularly grateful to my colleague, Professor Dr. Deblina De, Associate Professor and Assistant Dean, Student Affairs of Jindal Global Law School, who has kindly agreed to moderate this session. I look forward to the valuable comments and perspectives that are expected to be shared in the course of the discussion. Over to you, Deblina.
Thank you so much, Professor Raj. On behalf of the university, it's my great privilege to extend a warm welcome to our distinguished panelists. Thank you all for joining. The importance of this theme, which is resource maximization through digital interlinking of law libraries, can hardly be missed. And as we know that the scientific and technological advancement has shrunken the world, opening numerous channels of knowledge. The dictum that knowledge is power has never been truer than it has been in current times. And as much as greater responsibility comes with greater power, societies that produce and possess knowledge have the larger onus to preserve and share knowledge. So today, as scientists all over the world are engaged in finding a vaccine for COVID-19, the importance of knowledge sharing and to be beneficial for sharing of expertise, experiences, and may open doors for shared purchase of licenses. While most developed and developing countries already have a system of inter-university resource exchange within their own jurisdiction, there is a definite need for envisaging models of international exchange of resources. The need is for conceiving interlibrary collaborations as part of the internationalization of law schools and universities. So we're, as a panel, going to reflect on this particular theme. And since there is a time limitation, and I also hope to be able to hear all your views on this, I will request the panelists to briefly share your views on a set of questions that I have with me. And many apologies right at the outset if I have to interrupt because of time limitations. So the first question that I have, and this is addressed to all the speakers, you could probably take about 2.5 to max 3 minutes for this. The first question, which kind of obviously comes to my mind, is that as the pandemic has restricted movement, rendering the physical use of library spaces impossible, libraries across the world have moved towards the digitization of existing resources. Since this move would facilitate interlinking of library resources, what can be the various models of interlibrary collaborations that law schools can adopt in order to maximize their resources and enhance access to knowledge and information in the post-pandemic world? So may I now first invite Dr. Arora to reflect on this question, followed by Professor Dr. Achilles, and then Professor Astrid Zay, and then Mr. Buddhi Prakash Chauhan. We'll follow that order. Over to you, Dr. Arora.
Thanks a lot, Deblina. Like you've already mentioned, the Library Consortium is a model where the libraries of similar interest come together and make a consortium. We already have an example in eShod Sindhu. Even law resources were included earlier there, but now they are not there. But that's a model which is kind of practice that is already established, and which is something that can be furthered. Like in our country, we have a lot of law colleges. They can come together and subscribe to e-resources. One thing very important about e-resources is what you sign with the publishers. So when you sign with the publisher, the conditions, terms and conditions, the accessibility, the access after subscription, all those things have to be looked into very carefully. Coming to, I would say that library cooperation should not only restrict to books and journals. It should go now beyond. Jindal Global University, I know, was a partner to EPG Pathshala, where you have developed courses in various subjects, and those courses are available through EPG Pathshala, and maybe some of them are available through Swayam platform also. So even that could be potentially a resource sharing thing. So the library doesn't stop to books and journals, it should go beyond to learning resources, and learning resources can also be part of it. Other very important aspect is digital repositories, institutional repositories. So institutional repository should also play its function. So library should be proactively collecting resources from within the institute, put it in their institutional repository and put it in a sharing mode. So the technologies like Shibboleth is now available, where you can define who your partners are and then share those resources. Of course, digitization is something that one can do, of course, selectively. One have to, respect IPR issues, and whatever is out of copyright, whatever is produced by your own, research community can be part of the institution repository. So in my opinion, library have to expand its, scope from journals and books beyond to e-resources, which could be e-learning objects, e-modules and other things, and then develop their institution repository, which could be, instrumental in sharing resources. Thank you, Dablina.
Thank you, Dr. Arora. May I invite Professor Achilles next? Thank you.
Thank you very much, and thank you for the invitation. It is great to be here. Now, a few comments on this issue. My personal view is that we can now see during the COVID era, as you rightly said, the need for more digitization, more collaboration amongst university libraries and amongst libraries in general, because we need to have more access to material. Law has been a unique field of study in the sense that it has always been perceived as more national rather than transnational or international, but I think it is clear that this trend is gradually changing. You cannot rightly do anything these days without comparative use of comparative law, without having cases dealing with transnational law. So we need definitely access to material. And there is now a very important initiative that has started many years ago with digitization of material, with consortia of libraries using this digitized material. And I think we are now facing what the next step would be. There are a number of issues that need to be solved. The main problem has to do with licensing, clearly, because licensing is way too expensive nowadays for any single university, for any single library. There are thousands of law journals, thousands of books, thousands of resources. No single university can deal with them. So there is a need for consortia of universities to be in a position to collectively negotiate with publishers in order to achieve deals that might be workable for them. So this is something that we need to consider more seriously, how to collaborate. We know in other fields that the reasoning of collective bargaining has been successful, and I think we need to do it. Now in Cyprus, we have a consortium between university libraries, but I think we need to go more global in this respect, not only national, because it is clear that main publishers are using their power in order to raise the prices, and we have seen the trend that even major universities can no longer get everything as they used to do because of the pricing. So because academics are actually publishing, are actually the ones giving the resources to publishers, I think we need to collectively negotiate, and this is the most important parameter that we need to take into account. So collaborative digitization and sharing presupposes collective bargaining. And the second point, we need more free-to-access material. I think the European Union, and I come from Europe, so that's why I'm mentioning the European Union, has taken a clear initiative in its agenda that we need to have open access material. Now, all the funding that the European Union gives presupposes access that is open for researchers, for the public. And I think this is something we need to insist upon, namely that funded research is made, has a precondition that it needs to be published in a way that is accessible, because otherwise we are clearly restricting both our students, our researchers, our academics, everywhere. So these are my two main points. Thank you.
Thank you. Thank you, Professor Kelis. May I now invite Professor Zaid to respond to this question?
Thank you very much for this invitation. I think that the pandemic is widening social and economic divisions, a self-reinforcing cycle that experts warn could have consequences for years to come. I think that this is true, and this is particularly true for academic research and for enhancing access to education in general. I think I am privileged since I'm teaching in the biggest university in Europe and one of the oldest in Italy. I'm aware of the old and sophisticated academic tradition for the studying of law in my country. Nevertheless, I am personally experiencing a dramatic lack of resources for research. Books are hardly available simply due to the politic of encouraging smart working and social distance at every level of administration. Simply, there is not enough space available into the libraries for scholars and for students, and there is a lack of personal resources for providing the books, for giving the books to the student and to the researcher. Academic research activities and even PhD work theses are made very difficult or almost impossible depending on the topic. In this perspective, enhancing digitalization of existing resources and the digital interlinking of existing digitalized objects and e-books and e-journal is more and more urgent. Nevertheless, there are differences among universities, differences among countries in providing extra resources for implementing the digitalization of libraries. For instance, 1 month ago, the German Federal Ministry for Culture provided 10 million euro for this scope for implementing, ameliorating digitalization of libraries. And further resources will be made available by the European Commission. I think there is a necessity of a legal framework, of a broader legal framework for negotiating compensations for the among university libraries for their contribute to a large university network of libraries. I think that without a legal framework putting some rule about compensations, how to compensate, how to balance, how to measure the contribute given by each and every library, the digital interlinking of law libraries will remain difficult.
Thank you. Thank you so much, Professor Zay. I invite Mr. Chauhan to share his thoughts.
Thank you, Edwina. I think most of the points that I wanted to make have been already said by my other panelists. But in any way, so I'd like to start by saying is that the digitization as such, started much before the pandemic. Okay, the early or the late last century and the early years of this century, big libraries in USA and elsewhere in Europe, also they started digitization of their archival material in print, Hathi Trust, for example, Internet Archives. In legal domain, making of modern law, it's a massive resource that is available, either in open access or even for a very small fee. So what pandemic has done basically, maybe I think it requires further momentum for digitization of the established old and big libraries for their archival material. So what I have done is I have identified certain areas, some of these already have been mentioned by other panelists. So let me start by, saying that the first initiative or the area of collaboration for various libraries could be identifying unique archival print resources that are available in old and established libraries, and that can be made available in open access. For example, if I take an example of parliamentary proceedings of Indian Parliament, so we don't have everything's digitized. So prior to 70s. So maybe similar things can be identified in all the libraries, and maybe we can digitize them and make them available in open access, so they are available to everybody. The second point that I would like to mention is that already is mentioned by the open access things. So I think we need to improve the discoverability of current resources available in open space. For example, because of the digitization of courts in India and elsewhere, a lot of material is available in digital form. So what we need to do is, in a collaborative manner, is that we should develop some discovering tools for them so that we can discover them, we can organize that information, the judgments of Supreme Court or High Courts available on their sites, which are freely available. We don't have to pay anything for that. Maybe by using some smart search engines or artificial intelligence that we can discover them, we can organize that information. We can add more information available digitally. For example, we still have very difficulty in accessing court submissions in India, which could be very useful material for research. So these kind of things can be identified, and we can collaborate to use discoverable tools for these people and organize this information. So even if we don't spend money on subscribing expensive databases, this resource can be used by smaller libraries or new libraries, so to say. The third aspect is the innovation in acquisition of digital resources. Dr. Arora mentioned, or even other panelists mentioned, the consortium of libraries to acquire digital material. Right now, what we do is basically we just negotiate the prices for member libraries of the consortium. We need to innovate that so that we can provide more inclusive, flexible, scalable access to the libraries, including the new institutions, small institutions who cannot afford very expensive databases. So how do we do that? So there is a need for some innovation in that. I would like to give an example of a new consortium, that I happen to be president of, consortium of private academic libraries in India called COPL. So if you see the acquisition model of the resources there, it requires, not only that the libraries are member of the consortium, but we wanted the publisher should also be member of that consortium. And we should work together to create a win-win situation for the libraries as well as publishers. The libraries, smaller or bigger, should get access to all the resources that they require. At the same time, publishers should get enough revenue, or they should increase their sales. So I think the model that COPL provides basically creates that kind of situation. Okay, of course there are bottlenecks in that, and it's this is still work in progress. So I hope someday people will realize that, and I think we will talk about this in next session also. Okay, so
thank you,
yes,
Mr. Chavan. Thank you. We'll move on to the next question, which I think is a very important, a very crucial question regarding what, according to all four of you, again, it's addressed to all four of you, what do you think are the major hurdles towards implementing digital interlinking of libraries, and what institutional mechanisms are required for interlinking of libraries? I think some of the questions have been in some way answered, reflected upon by some of you, but I'd like to invite Dr. Arora once again, to share his views. Dr. Arora, I think you're on mute.
Yeah, thank you, Deblina. Well, one of the most crucial problems with the consortium itself is that there are libraries or institutions that are larger, and there are ones that are very small, and their requirements are not equal. So what is expected from the larger libraries that they pay more in comparison to those who are smaller, and the usage is not that big, so they should pay smaller. So those are the kind of negotiation that becomes crucial. Likewise, the libraries that are larger can contribute much more than the smaller library. So there is a feeling that, for the larger library, that we end up giving more than what we receive in return. So those are the problems that are crucial, but that have to be negotiated. And it's not just a subscription cost when it comes to putting resources in institutional repository, when it comes to developing resources, when it comes to sharing what you have. Naturally, the larger institutions have much more to give. So that becomes a crucial point. The second important aspect is there is a lot of technology that are involved. And again, somebody has to play like a big brother, provide this technology, provide that platform, develop that platform. And naturally, the distribution of resources are not equal. So that becomes a crucial problem. But that is something that people must understand, must agree to some common minimum program and contribute to it. So
thank you, Dr. Arora. May I invite Professor Zay to address that question?
Yes, I agree. I deeply agree in the sense that what we are experiencing in legal research is that the different dotation of libraries in terms of personal resources, in terms of public contributions or even private contributions is very, very different. As a matter of fact, legal resources, legal books, digitalized objects on legal history are differently accessible depending on the structure which is conserving them. Again, I think that it will be necessary to provide a public legal framework, being from the European Union, being from each and every state, in order to regulate this form of collaboration. Otherwise, the inequality among the libraries will act as an obstacle for cooperation. And regarding the opportunity of an intervention by the European Union, I would like to stress that since 2005, the European Commission launched a very, very ambitious program whose aim is that of enhancing the digitalization of cultural resources within the European Union in order to make them easily accessible in all the European Union states. But although this European Union politics is important, at least from a symbolic point of view, the budget, the monetary resources which are made available are still not enough for this scope.
Thank you, Professor Zay. We move on to Professor Achilles. If you could share your views for about 1.5 minutes, that would be great.
Thank you. Yeah, as I mentioned in my initial intervention, in my view, the greatest hurdle right now is clearly the licenses limitations set by online content providers and publishers for the use of the online material by an organization. This is the major hurdle because, as already mentioned by previous speakers, not all libraries and not all universities are created equal. There are great discrepancies. Therefore, it is different to have agreements for sharing resources. Interloaning handles this a bit. We need to focus more on online content, but as I mentioned, I believe that a more European-wide, global-wide system of negotiating needs to be found in order to tackle this hurdle. I think right now, in the COVID era, we have seen within the current environment created by the global pandemic that the working procedure for libraries have altered significantly. We have seen how access to online material has become even more important, and how finding the proper academic sources is indispensable to our work.
Thank you so much, Professor. Mr. Chauhan, would you also like to quickly respond to the question?
Okay, I think the one aspect or a factor that we normally ignore, which impedes interlinking or sharing of library resources, the people factor. I think we normally talk about the licensing or copyrights and other issues, but I think, in my opinion, in my experience, the people factor is the most important, which impedes this progress. Human psychology of, sense of possessiveness of the resources, that it belongs to us. We should not impart with, others. We should not share with it, others. The lack of enthusiasm and willingness amongst the librarians, and even to some extent, the administrators also. So I think there is a need to address this issue to create awareness amongst the librarians, the students, and the faculty of the copyright issues, about the licensing issues, what is possible, what is not possible, what is permissible, what is not permissible. And not only that, I think these factors also are the factors for opportunities. We should also see an opportunity in that. For example, licensing, large number of publishers provide for interlibrary loan. So legitimately, and in most cases, we are not even aware of that. And we don't use such opportunities. Similarly, the copyright, they have a lot of provisions there, like Sections 52 of Indian Copyright Act, which provides a lot of power to public libraries and the researchers and the education institutions to avail those concessions, those protections. And I think we should be conscious about these things and utilize those and make these factors not only as an impediment but also as an opportunity. Okay, so similarly, technology is another part. We can use the technology innovatively, to deliver these resources. For example, in our own library, we are using MS Teams to help you guys, for live assistance. We are using MS Teams and other things, to play the videos that are not available digitally. So we play them, in the library, and you can use them in the classrooms. So these kind of technology innovations can be used. So these are the factors. So technology, for example, can be used for DRM also, digital rights management also, which is good for publishers. But we can use this also to innovatively to provide better access to the users. Thank you.
Thank you so much, Mr. Chauhan. I'll move on to the last question, after which we'll move on to the audience questions. And this next question is addressed to Professor Zey and Professor Achilles, which is that the interlibrary collaboration has the potential to facilitate, promote, and streamline the ongoing digitalization of classroom in the law school. What potential do you think such collaborations could have on the quality of legal education and research? So over to you, Professor Zey.
Mm-hmm. Thank you very much for the question. Of course, there is a huge potential in digital interlinking, particularly now during the COVID pandemic. I would like to stress that although the title of the conference is mentioning the COVID-19 pandemic, using the word and beyond, we are not yet at that point. At least we are not at the point in Europe, and we are not at that point in Italy. The COVID-19 pandemic is still dramatic. Distance learning and studying for university students are likely to accentuate the socioeconomic divide in educational attainment. Better off family students with access to adequate Wi-Fi connection and more space available are more likely to get learning activities that involve active engagement between professors and students or access to digital libraries than working students. We have a lot of working students in Italy, or students coming from most deprived families. I would like to stress that the difference between a service library, a service university library, in the sense of a library which is providing books and material for everyday studying of the students, and on the other side, conservative libraries, which are providing materials for researchers, for scholars, or for senior students who are preparing their PhD works or other publications. In my experience, I see that the digital interlinking of law libraries is more effective when we talk about service libraries, library providing materials, books, legal journal for everyday studying. On the contrary, on the other side, libraries which are conserving historical material, which are conserving books wrote by scholars, which are necessary for another kind of research activities, those libraries, they need so many resources in terms of personnel, in terms of money. And I see that those libraries today are experiencing a deep crisis in their services to the collective community of scholars.
Thank you so much, Professor Zay. Professor Achilles, would you like to reflect on this question?
Thank you. Very briefly, because I know the time constraints, we are living in an era where online education is on the rise. I think there is no doubt that we live in the era of the fourth industrial revolution. We now have millions of people who are studying online, especially during the COVID era. We have even the conventional students studying online. So online material becomes more and more important for students to be in a position, especially master students and PhD students, to be in a position to carry out their education. And the learning environment now becomes more digitalized than ever. We have online books rather than printed books. We have access and suggestions to students to study materials that can be found online, and this can be found in journals, in ebooks, and in major online content providers. So there is no doubt that the whole process of digitization of material and intersharing between libraries becomes more and more important for the teaching process, for the learning process. And I would like to add that even international conferences like the great one you are having now, these are also being used extensively nowadays as part of the learning process, because we are moving also further than even the online books and journals and moving towards podcasts and video podcasts as part of the learning material. So the content becomes more and more digitalized, and this is, I think, the future.
Thank you so much, Professor Achilles. Now we move on to the questions that I have received from the audience. And there are lots of questions actually, but I'm going to restrict myself to some of the questions which I find perhaps has not been really addressed so far. So the first question is that people take pride in having access to prestigious libraries, say for example, Oxford, Cambridge, Berkeley, and it comes with a price in the form of subscription. If the various libraries are to be interlinked, then how is this exactly going to function? Would there be a standard subscription fee? And what if the student whose college is not subscribed to this interlinked system cannot afford the same? What measures can be taken to make it sustainable and accessible to all? So can I ask Dr. Arora to address this question, followed by Mr. Chauhan?
Thanks, Shavina. Well, when you sign for e-resources, like I mentioned, that bigger library pay more and the smaller library pay less. Negotiation is something where these things can be addressed. The other thing is, like Dr. Chauhan has mentioned, the license agreement, IPR, they provide a lot of provisions that even if you are not subscriber to a resource, the library who's cooperating with you can download that article, pay to you. One thing which is very clearly mentioned, that not the library, but the other user can send the material. So if the library sends the same material, it may not be as per the agreement, but other users can send that material. The other thing that library can do is download, print, and send it. The other, of course, there are software that allows you to, scan things and send it, and that are legal also, and that can be linked to copyright issues where you pay a fraction of money for such kind of transactions. So yes, copyright and licenses allow interlibrary loan even in e-resources. So that is possible that you may not be a subscriber, but still can use, get the article downloaded and send it to me.
Yeah. Thank you, Dr. Arora. Mr. Chauhan?
Okay, ideally, there should not be any fee to access the resources of the library, any library for that matter, you know. So, but you can identify certain category of material, for example, open access material, which should be accessible to everyone, even if one is not a member of a library. Archival material, for example, available in the big libraries, Oxford University or Cambridge University or in Delhi University. And if they are digitized, you know, I would expect them to make them available in open access. So ideally, this, now coming to the current scholarship, which is basically requires a library to pay. So if you look at the consortium model, so rather than each library subscribing to different resources, I would recommend that in this model, consortium subscribes to a particular resource. And those resources are available irrespective of the size and the age of the institutions to all the institutions and their members. Okay, now coming back to how do we distribute cost? Okay, now in some cases this could be possible that a particular resource, a specialized resource, might be funded by a group of libraries, a small section of the members. Okay, but irrespective of that, it might be available to everyone. Okay, so that could be another model which may facilitate more inclusive access to the resources, and the new institutions, poor institutions, need not pay, you know, or just just be refused access to at all. You know, so what happens now is that because of the cost of the subscriptions, you know, either we say take it or leave it. There is no other option. Now in this model, even if you are not able to afford, you know, expensive databases, still, you know, you can have access to these databases.
Thank you, Mr. Chauhan. In fact, on the point about inclusivity of resources, I think there are two questions that I got from the audience. One is with respect to non-English resources, how will the digitalization process and the translation, how could it work out really? So again, I come back to Professor Achilles. Would you like to reflect on that?
Thank you. This is actually a very important question because most of the material that has been digitalized, of course, English-speaking material. I come from a country that speaks fluently English mostly, but still our legal system functions in Greek, which is not one of the major languages. So there is no doubt that it is more difficult to digitize the material, and yet you need this material. Now, the main problem here is that local content providers, local online content providers, because they have less population using the system than major English-speaking platforms or even Indian-speaking platforms, I might add, they might charge by the hour, which is clearly subscription by hourly use is clearly not functionable in the long run for university libraries because you cannot really control how the students will use the system, and therefore you cannot budget in advance what your cost will be. So there is little doubt that we need to use regional organizations like the European Union, for instance, but other regional organizations as well in order to fund initiatives to further digitalize and find ways to properly support the use of online material in languages other than Greek or those languages that have potentially several hundred millions of users and might be self-sustainable more easily.
Thank you so much. May I now invite Dr. Arora to respond to the same question?
Well, I'm not a language expert and I haven't come across such situations. But apparently life is much easier now with tools that are available like Google Translate. And so it should be comparatively easy now. And of course, governments like in India, we have this Swayam and EPG Pathshala. All the contents are being translated in multiple languages. And institutions, those who have taken this task, are using technological tools to do this translation. So I hope the life is much easier now with technology that is available.
All right, thank you, Dr. Arora. In fact, a related question that there is regarding, again, the theme of inclusivity of resources, that many library services across the world are designed to provide access to ebooks to those with special needs. How can we create special collaborations to facilitate interlinking of such libraries to serve a larger purpose, even in a post-pandemic era, to maximize the use of existing library resources to create a wider social impact for law and other students with special needs? Professor Zay, would you like to respond to that question?
I just would like to say that maybe by paradox, the COVID-19 crisis was acted as a booster for initiatives and programs whose aim is that of making cultural resources available for individuals with disabilities or with some kind of problem in mobility. Among cultural institutions, maybe libraries showed much resilience during the COVID-19 crisis, since they were able to shift from the physical to the digital mode and continue to be meeting users' needs. Knowledge and skills may be diffused by libraries in the form of informal learning, in lifelong learning of people of all ages. In its digital version, literacy is provided to targeted groups of people, including working students and also marginalized people. Social inclusion and participation is an objective explicitly addressed in all activities aiming to integrate large layers of population who are now excluded from the social life and political participation. There is no doubt that in a disaster plan scenario situation, a list of cultural and educational services deemed indispensable, necessary, and valuable in emergency times would include library material, both in digital and in traditional form.
Thank you, Professor Zay, for those thoughts. Mr. Chauhan, would you like to reflect on this question?
Yeah, this is very important, I think, aspect of library services. And I think one should be aware, as I said before, I think that this is the people factor which, deprives, many of the things that we can do. And this is one of the area where, we need to do a lot of work, You see, the providing accessible material or accessible libraries is one of the mandate, that is a must, for the libraries, particularly in India. So we have to do that. In fact, in our own university, we have created accessible library section, and which has been equipped, with the devices which can convert, text material, digital text to braille or digital braille, and so the visually handicapped people, can read those, using their device, and vice versa. These devices can also be used in writing examination seminar, for example. And the teacher, instructor, who is not aware of, braille, language, actually convert them into text material. So these kind of things we need to do. So I have 3 points, agenda for this. the library should ensure and the publisher should ensure that whatever products we buy, digital products, they should conform to accessibility standards. Okay, unfortunately, that might be a problem in some of the local language products, etc., where they don't conform. So I think through collective efforts, through consortium or something, these publishers could be sensitized to upgrade their products or conform to standards. Third thing is, I think in a collective manner, the libraries could also undertake conversion of print material or textual material to Braille or similar accessible formats, which are in more, particularly the learning material, course material. There is a lot of need for this kind of thing. Third thing is that we should ensure that whatever we provide, we should provide assistive technology. As I said, the devices, the software within the library by creating a separate section for people with special needs.
Yes. I'm really very tempted to ask this last question, and I think I could address this to Professor Achilles. If you could just very briefly, this particular question is addressed to you. The traditional law libraries have a sense of personal guidance from the librarians and the teachers who happen to be the experts in their field. Do you think with the digitization of libraries, can the same monitoring and tutoring be extended online?
This can definitely be done, and I think actually universities which started working with online education years ago, mine has been involved in distance learning education for 9 years now. We have worked really hard in trying to make this transition from conventional education and conventional use of resources to the online use of resources, and clearly the same rules apply. Namely, you need to have the expert academics working together with the legal librarians in order to be in a position to offer the best possible material to students and to researchers.
Thank you so much, Professor Achilles. So we conclude the session here. I thank all four of you for sharing your thoughts with us. I thank Professor Raj for giving me the opportunity to moderate the session. It was indeed an enriching and informative session for me. I hope the audience has also found it to be so. Over to you, Professor Raj.
Thank you very much, Deblina, for a fascinating session. Thank you for moderating it. I want to take this moment to thank Professor Astrid Zay, Professor Achilles Emiliandis, Dr. Jagdish Arora, Mr. Buddhi Prakash Chauhan, for really providing a thought-provoking set of reflections on a very important issue that all of us grapple in universities and law schools across the world, the issue relating to resource maximization through digital interlinking of law libraries. The heart of the digital interlinking of law libraries is about creating a democratization in relation to knowledge, but also access to knowledge and using those resources to provide opportunities for people who simply may not have that access. In fact, I'm reminded of what Professor David Langs, the American Library Association 2016 Ken Haycock Award for Promoting Librarianship recipient said, and I quote, "Bad libraries build collections, good libraries build services, great libraries build communities." So the question is, how do we build great libraries in the online context? To what extent interlinking of law libraries will help us build those learning communities? Those are some of the most important issues that all of you so kindly discussed during this panel discussion. I'm grateful to you for your time and indeed your presence and participation in this panel discussion. With this, we'll take a short break and we'll be back in 15 minutes for the 27th thematic session of the conference on the theme Placements and Recruitments Against Uncertain Industry Conditions. Thank you.
Thank you. Thank you, Raj. Thank you, everyone.
Thank you.
Good afternoon to all of you from India. My name is Rajkumar. I'm the founding Vice Chancellor of OP Jindal Global University. Good evening to our friends in Australia, as well as in New Zealand and others. Good morning for those of you watching us from North America and Canada. It is indeed my proud privilege to welcome all of you to the third day of the Global Virtual Conference on Reimagining and Transforming the Future of Law Schools and Legal Education. It's indeed my proud privilege to particularly welcome all of you to the 27th thematic session of this conference on the theme, Placements and Recruitments Against Uncertain Industry Conditions. I have with us a very distinguished group of individuals who are leaders in their own right, who have contributed to various aspects of institution building in different countries. We also have a young lawyer with us who will also share his own perspectives from the vantage point of an early entrant into the legal profession. Let me begin by warmly welcoming Professor Dr. Lisa Webley, Chair in Legal Education Research, Head Birmingham Law School at the University of Birmingham, United Kingdom. Professor Eric Vermeulen, Professor at the Tilburg Law School, Tilburg University at the Netherlands. Barrister Dr. Khalid Hamid Chowdhury, Head of the London College of Legal Studies in Bangladesh. Mr. Shreyash U. Lalit, Advocate in the Supreme Court of India. And of course, my own distinguished colleague, Professor Dr. Vasilin Popowski, Vice Dean of the Jindal Global Law School at OP Jindal Global University, India. The issue of placements, recruitments, internships, indeed career aspirations of bright law graduates across the country and around the world have been fundamentally shaken due to the COVID-19 crisis. We believe that this is one of the important issues that is worthy of discussions in a conference that focuses on legal education. And that was the reason for us to include this as a part of the panel discussion. I'm going to give this panel to Professor Popovsky. I'll be coming back shortly. Thank you very much.
Thank you, Vice Chancellor. My pleasure to chair this panel on such a crucial topic, as the Vice Chancellor said, the placement and recruitment in time of uncertainty of the legal profession. In fact, I must say the uncertainty was even before COVID-19. The profession has been already changing before that, and it was mostly due to the technological advance, to the artificial intelligence. If you remember, Yuval Harari in his book Homo Deus and 21st Lesson to 21st Century already signaled that the future of jobs will be very much different from what we had in the past. The nature of jobs is changing. The what he called even the useless class, some people will need to get to reskill in order to get employed again. And that has been very much the case also with the legal profession, which has been changing for the last, I must say, 15, 20 years already, due mostly to the technological changes and artificial intelligence. But the COVID-19 brought this into a kind of acceleration. We've seen, I saw recent numbers that 18% more unemployment in the United States, 14% more unemployment in Europe, 12% more unemployment in Asia. So the COVID-19 really cut jobs, but also presented with an opportunity, as I must say, to think about the future of jobs, and in particular in the legal profession. So how did the legal industry, but also the law schools responded, and what else they need to do to respond better? Many things has changed, but what did not change is the need for justice. So let's put it this way. The legal profession actually probably would become even more important because the idea of justice, the equality, the access to legal services, the legal empowerment of vulnerable groups of people will be even more demanding exactly because of the difficulties in which COVID-19 presented us. So because the need for justice is there, the need for profession is there, but how will the profession react? And what kind of new graduates we need to create in the law schools? And I'm speaking on behalf of Jindal Global Law School, which, by the way, undertook quite effective way of, for example, recruiting back some of our graduates. We offered graduate scholarships and teaching fellowships to many of our graduates, and they now work on the research projects with our faculty. So we have been quite dynamic and innovative in that way. We have an excellent panel, which the Vice Chancellor already introduced. And if you permit me, I will go by your first names, Khaled, Shriyash, Eric, and Lisa. That will be probably easy also for our audience. And to ask you first to tell us your overall impression of the impact of the pandemic on the legal industry and on the recruitment and placement in particular. Shall I go with the order we are given in the program, if you don't mind? So let's start with Dr. Khaled first, please.
First and foremost, I'm thankful to respected Professor Dr. Rajkumar, the founding Vice Chancellor, and his esteemed team at the OP Jindal Global University for arranging these magnificent sessions and of learning and sharing, and for inviting me to be a part of the same. Of course, it's a very pertinent issue. There is no doubt that every sphere of life has been impacted by COVID-19. The law schools, admissions, placements, and recruitments are no exception. Now, in Bangladesh, from our own perspective, I can tell you our story. In Bangladesh, the Supreme Court announced a holiday in all courts after the government imposed a lockdown way back in 26th of March to curb the spread of the virus, and virtual court proceedings only began on the 9th of May. And that was after an ordinance was passed, followed by an act of parliament. even then, a significant number of legal professionals who are not equipped or adept in using technology have been affected. Many of them also did not have the chambers or setup to make use of the online system promptly. As an aftermath, I think a good number of chambers were also closed, and some began working remotely, facing up the challenge. This meant loss of jobs, loss of income, and wage cuts in legal arena. The other traditional or additional problem for the young aspiring advocates in Bangladesh is that we have this examination for qualifying as an advocate in Bangladesh, which for one reason or the other has become less frequent, lengthier, and time-consuming. We have this rule where there should be 2 exams every year for the Bar Council intake, but unfortunately this has not happened frequently. It takes place in 3 phases like MCQ, written and Viva, and it has sometimes taken a couple of years to complete even one single process. So according to a private survey, we had 60,000 examinees appearing in the Bar Council exam in 2017, and the previous exams were only held in 2015. And only 7,200 students passed. And after that, many of them actually sat idle waiting for the written examination. Now, without having a license to practice independently, many graduates will have no choice but to work in chambers for a very low pay or no pay. They do not have the option to work as legal counsels, as many multinational enterprises or banks have a prerequisite that you must have a license to practice first before you join them. So in terms of student placement in overseas universities, I must say the situation is not that bleak, though. My institute, LCLS South, we are affiliated with many number of reputed universities. According to the statistics, we have actually seen some increase in enrollments and transfer applications. And one of the reasons is because, in Europe, they are now offering some post-study work opportunity for the graduates. So many people feel that after the Brexit, perhaps students from Bangladesh might be able to get better work opportunities in the UK and to recoup their expenses. And due to the unprecedented times and crises, of course, students are also in huge dilemma and they often get demotivated. We constantly try to engage our students via emails, calls, Facebook live sessions to guide them through the application and visa process. And we have international open days every year. Representatives from the universities would come and meet the students. We could not do one this year, but hope to do something virtually soon. To wrap up with a few of statistics, it's quite interesting that we have, 104 universities in Bangladesh, 33 or so public and 71 private. We currently have around 850,000 students seeking higher qualifications, and public universities would account for 450 and private universities around 400,000. What is interesting, and from my own experience as an adjunct professor of a number of other universities, I can tell that private universities more promptly adapted to the use of technology because, the students could afford to pay more. They have a more infrastructure or a budget. Unfortunately, public universities, due to their budget, lack of infrastructure, lack of technology, they suffered in a big way. And the academic proceedings came to a complete halt. Hence, many have argued that this has created an incoherence and somewhat discrimination among students, which is actually not their fault. You know what I mean? So obviously that was, many people thought it was pretty unwise to start online classes too promptly. And you have costly data packages, lack of digital devices, including smartphones and laptops. And many students had to go to remote area and they had no chance to avail themselves of those opportunities, despite the fact they were students of private universities. So this has been a major learning and a major challenge, which I hope we can recover and shape up post-pandemic in a good way. Thank you.
Thank you very much, Khaled, for this excellent, comprehensive tour de l'horizon, as the French say, in the situation, not only in Bangladesh, but generally about the certification of the legal profession and the expectations that are created on one side, but also the preparedness of the candidates to enter into the legal job. And actually, this is a good way to move now to Shreyas, who will speak next to tell us a little bit more about the Supreme Court of India and generally the legal profession in the Indian context. What has been the challenge over the last 9 months, and how did the profession, the legal industry, responded, and what are the expectations for the future? Please.
Right. Thank you, Professor Popovsky, Barrister Chaudhry, Professor Vermeulen, Professor Webley, and other dignitaries. I would say that legal professions, like other businesses and industries, are obviously facing novel and unfamiliar challenges. And we have been significantly affected by social restrictions, and many firms are receiving, or at least seeing, reduced client demand. And that has naturally been because of a variety of factors. Especially when we look at the Supreme Court of India. The Supreme Court of India has passed an order dated 15th March 2020. It's actually dated later, but the limitation starts from 15th March. What it has said in its order is that all filings that are to be done before the Honorable Supreme Court will stand extended insofar as the period of limitation is concerned. Now, that has a significant bearing insofar as filing before the Supreme Court is concerned. So what has really happened is clients have also, there is also a sense of lethargy that has set in clients. Over and above that, naturally, businesses have been hit. So on account of reduced profits, on account of reduced receivables, what we are really seeing in terms of legal advice that has been sought from lawyers is, say, for example, insofar as breach of fiduciary duties, a breach of contracts due to force majeure or frustration, or say, for example, disputes related to the relationship between creditors and debtors. That is, the fundamental issue here is that legal assistance is being sought to protect clients from deterioration of wealth and not towards generation of wealth. And as a result of that, what we are seeing is that there is, as you know, President Ronald Reagan put it once, there's a trickle-down economics of sorts. And because of this trickle-down effect, because businesses are not doing well, as a result of that, lawyers are also not doing well. And this is, at least when I speak about the civil or commercial side of litigation. When you look at the criminal side of litigation, what we see is the Supreme Court really stepping in and trying to protect liberty in as many cases as possible. There is, for example, a situation where several high courts across the country have, in fact, released these high-level committee orders. As under the high-level committee, what is supposed to happen is several judges in those high courts have sat together and they have decided, they have formulated certain parameters. Those parameters will guide as to when and how interim bail will be granted to under-trial prisoners. And that is also further accentuated and possibly exacerbated by the fact that you have now COVID-19 spreading through prisons itself. And we have so many under-trial prisoners who are packed, and there are prisons who are up to the brim. As a result of that, what is really happening is that the Honorable Supreme Court and several high courts across the country have really stepped in that arena and have tried to mitigate the problems faced by accused persons under trials as much as possible. So insofar as bail jurisprudence is concerned, suddenly we have seen a complete dynamic shift in how bail should be granted, should not be granted. Whenever, say, there are a couple of matters that have come to the Supreme Court where, although bails have not been granted in the high courts, but Supreme Court has stepped out of its way to grant those bails. So insofar as criminal side of litigation is concerned, that seems to be how the Supreme Court is, really taking the matters head on. Now, then there are several other issues to this, to the side of litigation. But when we talk about profession, when we talk about the legal profession, naturally it has had its downturns. And the reason for that, again, is because not a lot of lawyers have the infrastructural capacity. When you speak about the real legal profession, they are the people who are working on the ground, the people who are, say, for example, practicing in trial courts, right? Trials are not able to happen because, again, production warrants cannot be issued to the inmates. They cannot be produced before the court. Evidence cannot happen because then you cannot ask the prosecution witnesses to appear before the court. So trials are they have somehow hit a complete standstill across India. And as a result of that, naturally the concomitant effect is that obviously accused persons have been receiving bails left, right, center. But criminal justice system, if you look at that, criminal justice system has hit a roadblock. Because again, trials are not happening. And this again then affects the legal profession. The reason being that because again, work is not really happening in the trial courts. So then how is a layman supposed to, how is, even a person practicing in the trial court supposed to earn his salary? So this has had, there are effects that are coming across from several quarters. There are effects insofar as civil commercial litigation is concerned. There are effects insofar as criminal litigation is concerned. And we have all faced the brunt of this COVID pandemic. But if you look at the legal profession, there are several ways out of it. And we will talk about that as the topics come up.
Yes, thank you, Shreyash, for giving us this excellent insight of how within the profession different sectors will be affected in different manner. And also something interesting you kind of brought my mind into is the so-called legal fraternity. The idea that the profession is not a simple judgment, but also it includes a lot of emotional behavior and empathy to the various groups of people, to the vulnerable people, and even, as you mentioned, even the accused during the process, the criminal trials. The due process and the right of the accused are also important issues to bear in mind in such times. What COVID-19 is actually testing is also the human-human relationship, and it is very connected to the legal profession. And we see kind of good stories and bad stories in different countries in terms of approach to minorities, for example. But obviously in time of crisis, there is a need for solidarity and fraternity. Now let's move to Europe. We have two excellent speakers, one from Birmingham, Lisa, and one from Tilburg, Eric. To tell us a little bit more about how United Kingdom and Netherlands, or your own institutions, responded to the COVID-19 crisis, and what are the problems in terms of recruitment of law graduates, and how did your institution assisted your graduates? Please. Shall we start with Eric?
Yeah, sure. Thank you so much. And yeah, good afternoon, good evening, good morning, everybody, depending on where you are. So yeah, let me explain a bit about myself first. So yes, I'm a law professor at Tilburg University, but I'm also a practitioner. I work at a company called Signify, which was formerly known as Philips Lighting, the light bulbs and electronics company. So I'm both a practitioner and academic. And what happened was actually the following. It all started, so first university. So we had we started with a lockdown in March, and many of our students already got a job offer. And what happened was, and they had job offers at law firms and companies. What happened was that many of these job offers were, they disappeared. They could not hire them because of the pandemic. Companies, it was a lot of uncertainty. Companies had to make choices. Law firms had to make choices. And they said, well, sorry, we don't hire anybody right now in uncertainty. So that was a group of students that we had that graduated in May, June 2020. And that's a huge problem for them because they expected a job and all of a sudden there wasn't anything anymore. And it was too late for them to get an internship. So they struggle. We still help them. They come to me, let's say, weekly, trying to open doors for them. But it's extremely difficult. Then we all hoped that it would all disappear during the summer, but it didn't. And the university, well, we reacted fast. Everything was online. So that was good. Then we moved to August. The new year starts. Everything's still online. Pandemic still there. And what now happens is that the lawyers, they are extremely busy in Europe, at least in the Netherlands. It's busier than ever. Reason is we had to change the way we work. All of a sudden, everything is online. All the meetings are online. And this sounds weird, but it means that we are busier. We have more meetings now. We don't change rooms. We don't change buildings. So we just sit here and do basically back-to-back online Zoom meetings all day long as a practitioner, which is difficult. Then the courts, they moved more and more things online, but that was weird for them, so they had to adapt. So that made it busier. Then businesses, they need a lot of help because of the pandemic. There was a lot of uncertainty. Contracts could not be performed, so lots of work. We had new applications for testing and figuring out who was infected or not. All law firms, I know many lawyers who are involved in this. I work at Philips Lighting. We all of a sudden saw that there was a new opportunity, as you mentioned, because the pandemic also brought new opportunities. People wanted to have light bulbs that could disinfect. And that means that we all of a sudden have a new product, and lawyers within my company are extremely busy with making this happen because companies cannot wait anymore. So the legal profession, well, everything accelerated, but they don't hire. And that's a problem. It's a problem for universities because I am the director of an international business law program, and I cannot, all these people, they need to have jobs, but it's pretty difficult to find them. The good news is, though, that since October, so since last month, we see more and more internships again. So law firms and companies start to open up for internships, particularly internships, because of the uncertainty. They cannot offer them a job, not even a temporary job, but interns are very, very welcome. And this is very interesting because they understand now that they need lawyers with a different skill set. And that's where we universities come in. So I'm changing my program completely. I still focus on legal thinking, but I'm now incorporating creative thinking, critical thinking, digital thinking, collaborative thinking, community thinking, design thinking. Because believe it or not, this legal design, I know many companies that are now rethinking the way they communicate with consumers. So for instance, the general terms and conditions have to be rewritten. And what they need is they need lawyers that have a different skill set. And that's where the internships come in. So what I see now is that because I put my program in the market as something innovative. And what you see is that many of my students get internships because of the new skill set. So what I see happening, just as a summary, is that the legal profession changed. They understand it. They don't want to hire yet, but they open up for internships. But you see that they want to have lawyers with different skill set, and I think that's where law schools should come in. If we just continue to offer the same program to the students, but we can move it online, but that's not what we should do. We should really rethink, let's say, the legal programs, legal study, teach different skills, and then I think there will be a very bright future for lawyers, as you mentioned, because the world will change. It happened already, as you also mentioned, before the pandemic. We had a digital transformation, but that's kind of accelerating right now. So if law schools are really smart, they can actually define the future, the legal future for the students. And we can make sure that our students will get jobs because there's a lot of demand for a lawyer with a new skill set. And that's what we see. So I see a bright future. The only problem that I have is for the students that graduated last year. I still have to help them a lot, but we will figure it out. We do the same thing as you. we hire them, we offer them positions, assistant, teacher positions in order to get them going. But yeah, I think for them, it will be a bright future.
This is very encouraging to hear your positive approach and thinking that actually for the legal profession and for our graduates, there is a bright future. I fully agree. And also the way you describe how you change your teaching in order to prepare those future lawyers is quite impressive. We will come back to that in the future questions, definitely. Let's move to Birmingham. I know the University of Birmingham is one of the biggest not only in the United Kingdom, but in Europe. And it is also regarded as a city that will probably have a lot of employment coming from London and from the rest of England. It will be the central hub of jobs. A lot of big companies already moved from London to Birmingham, by the way. I've heard from my real estate agent who is pushing me to buy an apartment and say this is the best investment you can have in Birmingham, particularly after they build the bullet train, which will take Londoners to Birmingham and back for kind of 49 minutes. So I'm excited to hear how Birmingham and the university reacted to COVID, and how do you feel, Lisa, about the future of the recruitment and placement in the law school in particular, please.
Thank you very much, and thank you for the invitation to be here. I'm absolutely delighted and to be able to speak with such a great panel. Thank you. So I think on the whole, the position is not so dissimilar to the Netherlands, but perhaps slightly more positive in the context of recruitment, partly as a result of a national scheme that was put in place by the government called the furlough scheme, which supports salaries up to 80% if people need to be furloughed because of lockdown style conditions or restrictions, national restrictions placed on the ability for people to be able to work as normal. So I'll start with education and then I'll move through to the legal profession, if I may. So the University of Birmingham, in keeping, I think, with an awful lot of universities in the UK, I don't think our position was so dissimilar, had a 3-week scramble in March to move all of our activities online. Now, some universities in the UK were already extremely well set up to do a lot of what they did at a distance. They'd invested very heavily in technology, and they were ready. They'd already been doing a fair bit of that. My university had a good infrastructure for using technology, but it also had a culture of campus-based activity, and that's partly because our university's got a beautiful campus and we want to make full use of it. And so whilst all of our support mechanisms were accessible at a distance online, and we already had very well developed virtual learning environments, which most institutions in the UK and around Europe would have anyway, we were still pretty reliant on everybody turning up at campus for the in-person, face-to-face sessions. And in a 3-week period, I explain that I think the law school and the university went through 3 years worth of accelerated growth in terms of being able to move all of its activities online. So that wasn't just about the actual teaching going online, which we could do relatively straightforward. It certainly wasn't straightforward. It was very stressful for absolutely everybody concerned. It was stressful partly because it means you suddenly doing things a bit differently. We have a very international community in Birmingham Law School. So a third of our students are overseas, students from outside Europe, and we do have a good number of European students. And in that 3-week period, many of them took the opportunity to head home to family because of the uncertainty and not knowing how safe it would be to remain, and not knowing whether if they delayed, they would be able to go back to their home countries. It meant that we ended up with a community that had all been on the same time zone, because the UK has a single time zone, unlike I know many other countries in the world, to having a community that spanned from the furthest time zone in Canada through to Australia. And so all of a sudden we had a gathered community gathering electronically for classes across whole different time zones. And so we had some adjustments to make there, which were clunky. They weren't very elegant, which we managed to sort out in time for this academic year, where we now have most of our students making choices to study entirely online. So we can offer some on-campus teaching in very small groups for those who came to Birmingham, wanted to be in Birmingham, or who felt that they studied better with some face-to-face classes. So we can guarantee some of that. But many of our community have stayed in their home countries and are studying entirely remotely. So we managed to do that quite quickly. It wasn't very elegant to begin with. It has got much more robust since. But also all the extracurricular activities that we offer also got moved online. And so we've still managed to do our full mooting schedule. All of that's now online. We've still managed to do our pro bono work. We have 15 pro bono schemes at Birmingham Law School. We've managed to move all of that online. And over the course of the summer, we managed to do that. And it's a model which in some respects, for some activities, works a little better than our former model did. It's also meant that we've been able to integrate some of the digital skills work, which we probably needed to do more on anyway, into the experience of our law students, simply because we've needed to do that to support them and to support our faculty and the practitioners who come and provide some of the pro bono opportunities and the mooting and advocacy opportunities. We've managed to provide support for that too. Now, in terms of job opportunities, I think one of the things that we were really staggered by was that the law firm communities and the barristers' chambers that were also going through this digital transformation at the same time as us in their working lives didn't cancel the opportunities they'd offered to students, the unpaid opportunities, the placements in terms of, the work experience placements, the shadowing placements. They simply took all of those online too. And they did it straight away. It was just astonishing what they managed to achieve. And so larger numbers of students were given the opportunity to take part in virtual placements because they didn't have quite the same space constraints that they would have if they needed people physically to turn up. And so the legal profession in March in England and Wales particularly, but actually around the whole of the UK, just went online. Everybody stayed at home because we went into a national lockdown. By the time we'd reached April, law firms had worked out ways to be able to get law students and trainees to be able to work online. And so more placements were offered rather than fewer, which was just astonishing, utterly astonishing. And a lot of the law firms said that they were able to offer opportunities to people that they wouldn't, because it was so competitive, they wouldn't necessarily have been able to offer opportunities to, because they only had 10 spots available, and all of a sudden they could offer twice that. And many of the students have said, well, we wouldn't have had the opportunity to participate in this number of placements, and we've had multiple opportunities. I think coming to the legal profession itself, that one of the things that supported many aspects of professional life and other forms of business in the UK was a decision taken by the UK government to support salaries, to pay furlough payments if businesses kept their staff employed. So as long as law firms could continue to pay 20% of the salary of their staff, 80% would be paid up to a level, up to a certain maximum salary level, would be paid for all staff. And what those staff who were furloughed weren't allowed to do was to do fee earning work for their firms. That was a condition of the furlough. But what they could do is retraining. That was permissible. So they could spend their time on retraining. They could spend their time doing non-fee earning work, so doing outreach work. And so what we saw was law firms saying to their staff, if we furlough you, we would like you to use this time, rather than you sitting at home, because people were locked down for a long period of time, rather than you sitting at home, we would like you to, if you can, take up the opportunity of retraining, to be able to think through things we could do differently in our firms at a later date, think about how we can support the next generation of lawyers. And so a huge amount of time and energy, I think, has been put into reimagining how to do things. The trainees that were due to start in law firms were taken on as normal because they could be taken on and furloughed. As long as they had a contract of employment already set up, they could be taken into the firm. And law firms didn't, as long as they could pay 20% of the salary. Law firms didn't want to lose the opportunity of that talent, knowing that they could get them in. They couldn't use them for fee earning work. But of course, those trainee lawyers could offer something back somewhere else. And so in some ways, a series of decisions taken not by law schools, but by others has allowed, I think, some space. The furlough scheme has been extended. It's been changed a bit, but it's been extended till March next year. So a group of people have been supported. I think that the issue will come next year in 2021. Does that kind of support continue from the state? I mean, it will be tapered off, but will it just drop off a cliff? And that's when we may see the most problematic situations for the next group of graduates who at the moment are being still hired ready. So virtual law fairs are going ahead. Law firms are still recruiting. Barristers' chambers are still taking pupil barristers. The courts have switched to online proceedings, some of which are really problematic, some of which are working very effectively. So in some respects, we've seen an opportunity to accelerate changes that were probably going to take 5 to 10 years in quite a short period of time. Having said that, the psychological well-being of our law students is challenging because there is huge uncertainty, and huge uncertainty is very, very difficult to live with over a long period of time. And so whilst the future may appear bright to those of us who are employed and who are able to see some of the recent graduates progressing, those students who are still in education are understandably worried about what will happen in 2021, 2022. And I'll stop there.
Thank you. Excellent presentation, Lisa, and very happy to hear that indeed what we have been thinking and reading is already happening somewhere in Birmingham quite well. This flexibility and openness for innovation and reimagination of the job, this, what you mentioned, the recalibrating the skills into new skills, retraining students so that they are be able to face those challenges in terms of flexible jobs, in terms of working part-time somewhere, working in a hybrid model, helping a particular project in one firm, but remaining interning in another project. So all of this will definitely, as we see, be the future of the legal profession. It will be not simply 9 to 5, one office, commuting from home. It will involve all the possible flexibility, time flexibility, and so on. But also what is interesting in Birmingham is what you mentioned about the internationalization. A lot of students are coming from abroad, and will that be affected? So we will get back to that later. What I would like to go back to Khalid and Shreyash is to tell us a little bit more about how do you see the technology-driven legal profession, and how the legal profession will, what will the legal offices will expect from the graduates in time of COVID. I will assume, because we teach online and students study online, the jobs, a lot of them, as you mentioned before, are moving online. A lot of courts, a lot of judges will also operate online. So students being prepared in one mode probably will be also suitable to move to a similar mode, moving from a university to the legal profession. What do you think about it, Khaled?
Thank you. I think that the silver lining of the pandemic is that it has taught us, of course, some valuable lessons, as we see from the discussion. The functioning of the virtual courts, it has paved the way for access to justice, is one of the few blessings. And we all know Professor Richard Susskind of Oxford University, author of a number of bestsellers, who has been an ardent advocate for the dominance of artificial intelligence in the legal profession and for transformation of code based on technology for almost 40 years. And he has always stressed on how technology is needed to replace our practices in the past. and the present, of course. However, the need for digital or remote courts was only realized by us, I think, after the pandemic really hit us badly. And huge credit, I think, also goes to the efforts made by, I think, the Society of Computers and the Law. They have created a site of remote courts, which consolidates plans, ideas, policies, protocols, techniques, and safeguards to manage remote courts by different countries. And I believe we are all learning from each other's successes and failures to accelerate the development of innovative methods of access to justice that is ensured for all. Now, on that note, lawyers and judges in Bangladesh, of course, we are in dire need of technical support and training so the system may function more effectively. In addition to that, I think we could involve case managers who would have the role to identify the most suitable form of hearing at different stages of each case. Like a case management meeting might be held for an audio hearing, but when evidence is being heard, the video hearing might be deemed more preferable. It is also, I think, pertinent that we invest in research and development to find ways on how the online platforms could be improved or enhanced with a focus on functionality, usability, accessibility, and for all, be it for virtual courts or online dispute resolution. And I think the pandemic has given us this food for thought that court should not only be the forum to seek justice. We should also change our mindset. So when it comes to litigation and promote ADR, ODR to ensure better access to justice, as the problem relating to backlog of cases is here to remain. In fact, I think the word alternative is a misnomer, and I believe that ADR, ODR should be the preferred method to resolve disputes over traditional courts. And in Bangladesh, with the current population of 170 million, we have got like 4.5 million cases with Supreme Court only based in Dhaka, without any of its benches sitting elsewhere in the country. We are facing a monumental problem of access to justice becoming increasingly narrower. In our country, mediation was introduced in civil cases in 2003, but it is yet to be made mandatory. Arbitration is, of course, we all know it's complicated. Sometimes it's very expensive and costly, and it might lead to a lot of time. It's dominated by a few in the legal profession. So I would strongly advocate to promote an ADR, ODR culture. So it's imperative that we encourage young and experienced lawyers about ADR, ODR and provide them with the necessary training. Law schools, I think, will have a role to play here. We should start teaching our students early on that litigation should not be the preferred or promoted method of dispute resolution. At the undergrad level, I think they should be familiarized with the online dispute resolution and given the practical knowledge. And we at our institute, along with a few sets of chambers, we have created an online platform to not only train our students in all forms of ADR, ODR, but mediation, negotiation, arbitration, negotiation, all aspects are being taught with the finer aspects. We're also encouraging students to go for pro bono ADR services, which I think is very important. We have corporate partners with ADR, ODR International. We provide courses online, and at the same time, these courses are accredited by the CMC UK, CME Singapore, and also IMI. To sum it up, I think that the graduates should be trained and educated to become digital dispute management specialists, DDRS. I think that is where the future lies. We have to make them prepare not only for the how to survive now, but post-COVID-19 to think digitally and to sell what the clients would actually buy. Because the world is moving so fast elsewhere. Why the legal profession will slow down like this? This is actually an enigma to me. Thank you.
Thank you very much, Khalid. This is really interesting how much in Bangladesh, in the context of Bangladesh, things are moving into the right direction, as you said, and quickly responses, but also efficient responses are very valuable. Let me move back to Shreyash. He mentioned many things, but I want him to extrapolate on those as well and tell us a little bit more about the legal profession, the Supreme Court of India, other courts, how the technology helped to recruit in a more flexible way, as we're talking now. And what are the challenges in the next year, 2021? Please, Shreyash.
Yes, thank you so much. So I think in terms of how proceedings are being conducted in the Supreme Court as well as the High Court, we all know that they've all shifted to the online mode. They're all conducting online proceedings. Senior lawyers are appearing all across the country. And therefore, as a result of that, because everyone has slowly but surely shifted to the online mode, where conferences are being done online, files are being exchanged online, right? Everything is being done online. You have PDFs, now you have PDF readers, you are installing bookmarks on those PDFs instead of actually physically tagging those files when you're submitting it before the court. If, say, for example, if you were to take out a judgment, you just take it out from, say, Westlaw or any other journal, rather than printing it out and then physically submitting it before the court. So in terms of the legal profession, I personally love it. But when you look at the real ground reality, I think there are a lot of people who do not have the infrastructural facilities. Now, having said that, how exactly is a student supposed to get attuned to these kind of new developments? Now, I would say that as a university, like, say, for example, Jindal, would definitely have the infrastructural facilities to make that transition soon and make that transition quick. But if you look at other educational institutions, what you would need is in terms of infrastructure, for example, to help a student move towards an online system and move towards that in a better manner. I think what I would suggest is that in terms of infrastructure, they should really invest in, say, for example, what Barrister Chaudhry suggested, case management softwares, right? Or even if, say, for example, you were to look at OCR softwares, even something as simple as OCR, right? You have a PDF that's scanned, but it's all image. At the end of the day, you're unable to search through it unless you have those softwares available with you. These are very fundamental issues, but they hurt you so much. And say, for example, even if you were to look at other softwares like e-libraries, for example. Now, most often, whenever an intern used to go to a chamber and used to practice and used to start working there, the work that is expected of an intern is in assistance insofar as legal research is concerned, or in preparing notes, or just attending court proceedings and possibly giving minutes of what really happened in the court, right? This is what largely an intern is supposed to do when they are actually working in an office. Now, if you were to go back to these three things, 2 or 3 tasks that an intern has to do, attending court proceedings is fine because naturally you just have to do it online, so that's not an issue, right? Preparing notes, that's not an issue. Doing research, again, if you have access to those softwares, that's not an issue. But necessarily, people who did not have those infrastructural facilities available with them, or did not have that access to online research or online data, or those softwares that enable them to work online, obviously that's going to be a big roadblock for them. So therefore, the ability to switch will obviously be hindered. So insofar as these interns are concerned who are seeking to possibly seek internship opportunities, or even if, for example, you were to look at recruitment opportunities, I think the threshold will still be the same. At the end of the day, I think educational institutions really need to realize that somewhere down the line, the Supreme Court is understanding, and not just the Supreme Court, but several high courts across the country are also understanding that online filing is here to stay, right? Online proceedings are here to stay. And although I hate to say this, that COVID has been a big bane in everybody's life, but it definitely has fast-tracked that kind of progress and shift that we needed to do as a legal profession and as a legal community to switch from physical mode to the online mode, which was absolutely necessary. And as a result of that, now what has happened is that now, for example, you consider the High Court of Gujarat, for example. It's now started live stream proceedings. Never before in the history of the country did any High Court undertake live streamings, right? So now you have proceedings that are being live streamed. You have Supreme Court that has never considered online filing that has now adopted it and is very well taking it. You have judges who were completely, should I say, technologically challenged, they would see a computer and they would just tremble at the sight of dealing with a machine. And now you have those judges who are now dealing with those softwares, who are now reading their files online, who are reading their files on a computer as opposed to a hard copy in front of them. So what I would really say is that the real should I say, difficulty for any student or for any educational institution is only going to be to develop that infrastructure and to invest in that infrastructure, knowing that this is to stay and this is not something that will just go away in a few months.
Thank you, Shreyash. You reminded me how much conservative organizations have to deal with the crisis in a very, as you say, fast way. I remember I used to work in United Nations, and over 30 years, we were trying at least to reduce some bureaucracy, some paperwork in the Security Council, in the General Assembly. There were proposals to move things online, and it never worked because the member states always wanted to do it physically. But only for a few months, since March, they all moved online. So all those who are very much resisting the online and the digital had to do it anyway. So those crises are really interesting, that they give us the chance to accelerate what had to be accelerated anyway. And if we look back, the United Nations was created out of the biggest crisis of the Second World War. So COVID might be also an opportunity really to move fast and to create a better world, what they call green, build back better. Now, Eric, back to you. You mentioned how innovative Tilburg University and the law school has been already. So definitely, we should definitely advise our students to take postgraduate degrees in Netherlands and in Birmingham, obviously, because you are doing so well. Please tell us a little bit more. How do you think the future of jobs, the startups, the flexibility, the reskilling will go? What we also see a lot, and even before COVID, is this creation of startups, incubators, entrepreneurial cells. Students need to be prepared to self-employ themselves, to put it bluntly. They don't need simply to file applications and expect interviews. They have to do different things because of the flexibility and the hybridity of the future market. Do you think students will be able to do that? And what can we as faculty do to help them?
Oh, that's a very interesting question. Okay, yeah. So a bit of history, just 20 seconds history, and then I will answer your question. When I started as an in-house counsel, the only thing we did was legal work. Actually, the company I worked for, we had a library, a legal library, and we had 3 librarians within the legal department. They disappeared, I can tell you, they disappeared a while ago. But this was like the 2000s still, okay? And then the 2010s, all of a sudden things started to change. The lawyers, they were not viewed as in-house lawyers anymore. They became business partners. And all of a sudden we had to understand the business much better. So the questions that we received became more like business style questions. And this meant for me, because then I realized I was teaching my students that well, this is not what practice needs. So I had to make more lawyers, but with a business sense, right? Because we have this is an international business law program. So I had to explain business to them. That's why I started to introduce them to startups, as you mentioned. And I set up some collaborations with an incubator and an accelerator here in the Netherlands, where they can help. And some of the students actually, they build a legal accelerator using also legal students that I have to help startups. I think similar to what happened in kind of pro bono work that was mentioned, what happened in Birmingham. And that works really well because the students like this a lot. All of a sudden, they did not have to wear a suit. They could just go there with a hoodie and just give legal advice to them, which was kind of interesting. You saw the transformation. Now we are in the 2020s. And believe it or not, what I see now is that we are not only a business partner, we become actually a co-developer of innovation, which actually means that we should understand the technology much, much better. We should understand how technologists think. We should understand how programmers think. And all of a sudden, you see some of the students being involved in blockchain projects or artificial intelligence projects, because the companies, many startups in the Netherlands, they have an AI product. They go to the law firm and ask them, this is my new product. Does this comply with the law? But if a lawyer looks at the product and he has no clue what it does, he cannot answer. So what you see now is that a lot of students are very interested in the technology itself. Not that they have to become real technologists, but at least they have to think like a programmer. They have to understand the technology. And this means that we set up some hackathons, legal hackathons, where some of these startups come and present the problems to the students. And then the students come up with the solutions, legal solutions for these startups. It's brilliant, but it's something that needs some work, because what happened in the beginning, if you put a traditional lawyer with a young, let's say, entrepreneur together, the only thing you should do is record it and sell it to Netflix. It's the best show ever. The Office is nothing compared to the fun that you can see when you have a traditional lawyer and an technologist sitting together talking about things, but they cannot understand each other. So we now basically have to train the lawyer to become more like a digital savvy lawyer, which is extremely interesting. First, so I introduced coding for lawyers, artificial intelligence for lawyers. I even brought in a mathematician to teach them something, and that was not, okay, they didn't really accept it because most of the law students thought we went to law school to never, ever, ever see a mathematician in our lives again, and now you bring them in class. But it worked. It worked, and what you see is that lots of students are extremely interested in this new world and become a co-designer of the new world. And I think that's what law schools have to realize. So I don't say stop whatever we do and focus only on the technology, but there's a huge opportunity for law firms to offer I call it law and technology, but it's more than just privacy law. It's basically making the lawyer a real co-creator, a real partner for the technologists to help co-design the better future that you mentioned. And it works really well.
Very, very good to hear that. Wonderful. Lisa, you're the next to tell us a bit more. But before that, I received an interesting question for all of us to think about if you decide. And it brings exactly this kind of innovation and reimagination. Do you believe setting up an internship bank in collaboration with law firms and organizations will help build a stronger legal fraternity? And I wonder whether that could be the case. As you mentioned, we need to utilize the new technology, the blockchain, where the law firms can, instead of recruiting one-to-one to a particular candidate, they can open up, and law associations can help with that, to advertise to the whole of the industry, not to a specific firm, and to seek exactly that possibility of hybrid recruitment or flexible recruitment, working 20% in one firm and 70% in another firm and so on. Excellent idea, internship bank, where all firms advertise their opportunities, even projects, and they recruit this way. Lisa, you are the next. We have 5 minutes left, so bear in mind, I want to give a final word to everyone after that, so please be brief.
Okay, thank you. So I'll try and answer the question at the same time as dealing with the technology point, if I may. So I think one of the challenges for law schools everywhere in the world is that their law students have got different views of where they want to go after law school. And so you've got some students that will be wanting to go in-house as lawyers, particularly in Europe, where that is an increasing trend. So they'll be employed, whether as advocates or as transactional lawyers. You've got people who want to go into more traditional legal practice, some of whom will be looking in the direction of commercial practice, but some will be looking more at civil liberties, human rights, and personal law matters. And they're often going into small firms or NGOs, which don't have the same level of infrastructure or funding necessarily. So they they find it harder to be able to capitalize on the technological innovation because they just don't have the investment. Then you've got others who will go into non-law organisations but use their legal skills, and they may go into international organisations and others. And so you're trying to deal with all of those things at once. Now, if I pick up on Eric's point, if I may, about the technology side of things, it's certainly something that law schools in the UK have been looking at. And in Birmingham, we've set up an MSc, which will start in September. So it's a Master of Science, but it's run out of a law school in conjunction with the Computer Science School. And it's an MSc in Responsible Data Science. It's primarily aimed at lawyers, so people who've done undergraduate or JD degrees, who then want to learn more about technology and technological innovation, such that they are able to think through some of the ethical and legal issues, and to partner with, whether it's in-house, whether it's as a consultant, or whether it's in a law firm. And so to do that, they need to know a bit about computer science. They do a couple of modules on that. They need to do design thinking. They need to do entrepreneurship, because they need to understand the questions coming to them so that they can think through some of the things that those organisations won't necessarily have considered. And some of that might be about data privacy, but some of it's about ethics, some of it's about algorithms, some of it's about natural justice and explicable algorithms, so that people can challenge decisions that have been reached through algorithms, whether that's decisions made by private companies on things like mortgage applications or lending, or whether it's the state making use of things to be able to trigger benefits or disbenefits. And through that, the only real way to get that, proper understanding is through placements. And so we've been very lucky to partner with Accenture, which is a large consulting firm, which itself will offer placements to our students, but also their clients will offer placements to their students, to develop a bank of placements for students that come through that, so that they can do modules with us in computer science and maths. They're going to have to do compulsory maths, and also legal and technical and ethical modules with us also, as well as placements. Now, that's just one program. And of course, that's a niche program. It won't be of appeal to everybody by any means. But I think there are lots of things like this that are developing, which were already there, were being considered, were being set up. But the fact that COVID has profoundly changed the way in which we're all working has accelerated that. And on that, I'll stop to leave a bit of time.
Thank you very much, Lisa. We have briefly only 1 minute left. So I want each of you simply, and I know many students are listening this particular section because they are those who are in need of placement and recruitment. What is your final message, very briefly, 2 words? How should students prepare for the future of
Take 4 minutes, don't worry. Yeah.
Please, Khaled, very briefly.
They should be patient. They should not stop learning. The strategy will pass, will survive, but the thirst for knowledge should carry on, and they must be prepared for the future. As I told everyone, that we should think the DDRS method, the digital dispute resolution methodology, they should watch something that should be equipped for the future.
Thank you very much, Khaled. Shreyash, very briefly, final message to the students.
Right. I would say that educational institutions should adapt and evolve, and students should just be patient, because there's a lot in store. Yeah.
Thank you. Eric, what would you?
Okay, students, they should be curious and have an open mind, and try to create an online presence already, because that's what companies are looking more and more at.
Excellent. So patience, open-minded, curiosity. Lisa, what one last word?
Take any opportunity. There are opportunities out there. They look non-traditional. Don't worry that because it's not traditional, it won't be valued by future employers. Far from it. They will probably be able to ask you questions about the opportunity you took up and your curiosity.
Brilliant. My pleasure to give back the floor to Professor Rajkumar, the Vice Chancellor.
Thank you very much, Vaseline, for beautifully moderating this panel. And I want to thank all the panelists. What an extraordinary tour de force on the kind of opportunities that young lawyers and law graduates are going to have, from artificial intelligence to robotics to machine learning to entrepreneurship, going beyond the law. By the way, Professor Vermeulen, I have been running away from mathematics for the last over 25 years, since it finally caught up with me when I became the Vice Chancellor, when I had to look at budgets. So I know what you mean when that type of, in a way, the imagination that each one of you provided for the future of law graduates was truly remarkable. So I would like to particularly take this moment to thank Professor Lisa Webley, Professor Eric Vermeulen, Barrister Dr. Khalid Hamid Chowdhury, Mr. Sriyash Lalit, and of course, Vasilin Popovsky for being part of this thematic session. Many of us, not just the students, truly enjoyed the perspectives that you shared with us. We deeply appreciate the time that you've given in contributing to this thematic session. We will have a short break, and we'll have essentially the 28th thematic session of the conference on women leadership in legal profession and legal education. Thank you very much. Good afternoon from India. My name is Rajkumar. I'm the founding Vice Chancellor of OP Jindal Global University. Good evening to our friends in Australia and New Zealand. Good morning to our friends in North America and Canada. It is indeed my proud privilege to welcome all of you to the Global Virtual Conference on Reimagining and Transforming the Future of Legal Education and Law Schools. We are also here at the 28th thematic session of this conference on the theme Women Leadership in Legal Profession and Legal Education. We have with us a very distinguished set of individuals who have leaders in their own right and have contributed to different aspects of institution building, legal profession, as well as corporate lawyering. Let me take this opportunity to welcome Professor Sandhya Drew, Senior Lecturer and Assistant Dean, International Students and Exchanges, the City University of London from the United Kingdom. We have with us Professor Dr. Ved Kumari, former Dean and Head of the Department of the Faculty of Law, University of Delhi. Ms. Pratibha Jain, Partner and Head, New Delhi Office of the Nishit Desai Associates, and a distinguished graduate of Jindal Global Law School, Ms. Ravina Setia, Associate, Shardul Amarchand, Mangaldas, India. I'm also grateful to my colleague, Professor Deepika Jain, Vice Dean of Jindal Global Law School at OP Jindal Global University, who will be moderating this session. As we conceived the idea of this conference, we were very conscious of the fact that one of the most pressing issues in relation to both legal education, legal profession, and judiciary is the question of how do we diversify these institutions? To what extent women and leadership among women and by women is going to shape the future of legal education and legal profession. What can law schools do at a time when we are dealing with the pandemic, but also even beyond looking at the pandemic, to what extent law schools can contribute to both the intellectual discourse and indeed the policy level engagement in advancing the cause of diversifying the legal profession in all its forms and manifestations. While we know that many law schools, including law schools in India, at the time of entry, there are more than 50% women. But as we look at the legal profession itself, including judiciary and other aspects of legal profession, there are huge diversities, yet efforts have been made, but still the question of women playing a leadership role in legal education and legal profession is truly marginal. So with that, with those introductory words, I would like to hand this session to Professor Deepika Jain. I'll be back in 55 minutes. Thank you very much.
Thank you, Professor Rajkumar. Thank you so much for all of you. This is my pleasure to moderate this very distinguished panel. This is a topic that I deeply care about. What I'm going to do is we're going to do 2 rounds of questions. In the first set, I'm going to ask a common question and request each of you to respond. In the second round, I'll ask specific questions addressed to each one of you. So my first question, let me just launch into the question since Professor Rajkumar has set the stage. My first question is, the composition of this team panel may in itself suggest a representation of how glass ceiling has been shattered within legal academia and legal profession. What are your views on the evolution of women leadership in law schools, law firms, in-house councils, and the judiciary? I'll start with Professor Ved Kumari.
I don't think, I've been the dean and I've been a professor for a long time, but I don't think that is reflective of any systemic changes. I think my hard work plus a huge factor of my good luck has made me where I am. I do not find that in the institutional setup, there is any kind of, a systemic change there that we are not going to discriminate. And there are lots of factors for that which is happening. So I don't think that, we get into this whole idea because some woman has become a president, some woman has become a chief minister, and they're heading institutions and they're heading places. I don't think that is reflective of generally speaking, of women in India or elsewhere in the world. So things are changing, but it's much more an individual opportunities rather than a systemic change in my understanding. And for us, especially in India, when you look at the next generation, for 0 to 6 child ratio, we've got very few women being born. So we might be visible there, out there in positions and all, but the data is very, very alarming, especially for the graduate plus mothers who are graduate plus, they are showing a very less percentage of girls being born to them. So they are actually, the education to them has meant nothing, excepting continuing with the same norm of wanting to have sons.
Thank you, Professor Ved Kumari. I'd like to now move to Professor Drew, and we'd like to hear from you.
Thank you very much, Lithika. I'm going to set the clock for 4 minutes. To answer you, I think probably differently from most members of this panel, I don't think I've shattered any glass ceilings. I wasn't the first woman to go to university. I wasn't the first woman to go to the bar. I'm not the first woman to enter a senior position in a university. I'm not Kamala Harris. I'm not even Professor Sarah Gilbert, who has done what we call impact-making research. I've not overcome class barriers or disability. I'm a woman with education and with some ability who's had opportunities and taken them. And I'm also a woman at life's midway, as Dante would say. And I think those two things give me a big advantage. I think we need to move from the idea of shattering glass ceilings to looking at the trajectory of perhaps average or higher than average women and comparing it to the trajectory of average or higher than average men. This is the phase we should be aiming at, not at the exceptional individuals like Professor Kumari, who would probably make it under any circumstances. My contemporary university is now UK Prime Minister. I'm going to leave that point there diplomatically. I think we also need, and again, this is about being at life's midway. I increasingly think generationally, we need to think about the trajectory from being a young woman setting out to, being an older woman. And this is an issue of cross-generational understanding between women. In each stage of life, women face different hurdles. Almost all women have been eve-teased or sexually harassed or worse, been subjected to violence, which is intended to contain them. We've all had it, you constantly hit on as a younger woman. And this is a form of violence and containment of power. Then at the next stage, women face having to choose between long days at work or having children. Sometimes they'll move away from law, from the big city firms, precisely to have a family. I saw a judge's comment on online advocacy, and he said that, the problem with online advocacy is that children are a nuisance. He probably regards his own children, if he has any, as a nuisance too. Yeah, we've got to get past that, where women have to choose. And then we get to older women, and they face invisibility, and by then a lower standard of pay. And I think, I think those are the three stages, and we increasingly need to understand those intergenerational positions. And then I think there is an element sometimes of neurodiversity. Across, as ever, there is a range. But these are barriers which exceptional women break through at cost, but we shouldn't expect everyone to be able to break through them. And I just want to finish with 3 solutions, but before that, and an experience from my own practice. And I had a case which went right up to what was then the House of Lords. It was a woman, a science teacher, who was a lesbian and who had been bullied out of her workplace by students who had just constantly shouted abuse at her. And the school had done nothing because at the time, this was in the early 90s, it was unlawful for schools to promote homosexuality. And they thought by protecting her from bullying, they were promoting homosexuality. And as we lost at first instance, but with a very sympathetic court, we went increasingly up the appellate courts. And I had the experience of coming out of a court case and seeing a newspaper billboard with, headlines relating to my client's case splashed across the billboard. And increasingly, the 8 male appellate judges who heard us had no sense of what this was about. We were arguing for extension of the law to cover my client's case. The one exception was Lady Hale in the Court of Appeal. And I cannot describe for a young advocate what it was like to listen to a judge who had a sense of the wrong that had been done my client, and also the power that she exuded in the court was astonishing. Now, that's obviously an exceptional women. And as I said, we should be moving to the second stage of the average women like me. Sorry, that's my 4-minute time, so I'm going to be quick. But she was an exceptional president. She's retired now, but she extended court hearings to Northern Ireland, across the rail. She was an exceptional reformer in the role of reform. clearly different in her approach to law from the male judges who surrounded her. On her own word, she's not a radical. But I think there's also a sort of a different approach that women bring. And so the point I wanted to finish on, and I'll perhaps save my other comments for later, is it's not just about the evolution of women in the law. It's that by evolving, women change the law. And that, I think, is the key point. And I'll stop there.
Thank you so much, Professor Drew. So I think Professor Ved Kumari and Professor Drew have pointed to the same thing, which is that there are structural barriers. So it isn't about individual journeys, and those are significant, but there are also structural barriers. Let me move on to Pratibha, who's extremely inspiring, and she's heading one of the finest law firms in the country for a very long time, and her personal journey has been very inspiring. So Pratibha, and you're in a law firm, and the first two set of speakers were looking at this discourse from the academia. So we'd love to hear from you what your perspective or what your experience has been and what your thoughts are on these questions.
Thanks, Deepika. So it's very interesting to hear Professor Ved Kumari and Professor Drew, because, when you come to structural issues, right, I have practiced in various jurisdictions around the world. And by the time I came to India, I was already, quite senior. I'd already been in the profession for a decade. And I felt like, I had no glass ceiling in India compared to, the other jurisdictions that I practiced in, which I found very interesting because, we know the gender-related issues in our country. And I think I attribute that to various aspects. One, the structural issue that Professor Kumari and Professor Drew are talking about, like Raj mentioned in the introduction, 50% of graduates coming out of law school are women. So, what is the structural issue is in the institutions and in the society that we live in. However, corporate law is comparatively a nascent profession compared to the bar and the judiciary. And somehow, I think the way the Indian corporate profession is set up, it's set up by a few families. It started relatively later where there is more recognition of women coming into these professions. To start with, you had people like Zia, Pallavi, very senior women who were in the profession. And I think it just helped it grow a little more equally than what I have seen in the rest of the world. And that's why I think when I came here, I just felt clients I didn't have to break the glass ceiling. In Tokyo, believe it or not, in my 100-year-old firm, I was the first woman in the Tokyo office. Whereas in the Indian corporate legal profession, I already had all these female partners to look up to when, the clients had them, and to prove that, it doesn't matter what the gender is. That's not to say you don't have those issues. I remember when I was in-house at Goldman, so I'm the corporate counsel that the lawyer senior partner comes to pitch to. And he says, we just don't hire women because they get pregnant and then they leave. And I found it very interesting, especially because I was pregnant at that time. So obviously he never got my business. But, that thought process, even though it exists, I've just not felt it as hard as I felt it in New York, in Tokyo. Not so much in Hong Kong. Asia also is relatively good as far as at least our profession is concerned in that regard. What I feel the most about in India is the judiciary. The example Professor Drew was giving, if you have a judge in that position who understands even the kind of language that's sometimes used in Indian courts, would be less if we had even slightly better representation. I mean, only 3% of women in the Indian Supreme Court in India have been women. That's by any global standards abysmal. And so, to the extent we were talking about what needs to be done, I think at the law school levels itself, and, grade 3 professors are here, we need to be raising this issue and voicing this issue in this country at a much higher level, because it starts from the top at that level. And I think, till we fix that, the corporate law might be doing okay for now, but there is a trickle down effect. And if everything is not growing, and to me, it's all about volume. What I tell my associates, what I tell everybody is, just stick it out there, right? The women who came before us had a harder time. We have less harder time. We want to make sure, the next generation, it's much easier. And the only way is if there's volume out there, so that, you're not, I've gone from, and even today there are meetings, especially when it's government related projects, where I'll be the only woman. I have this really amazing photo where, there was the top level bankers from the public national banks, about 16 of them, all men, and me. And I was remembering Margaret Thatcher and her cabinet, which is all men. So, those kind of pictures need to kind of, start getting erased, and more women get there. And I think that has to start as soon as possible in the judiciary.
Absolutely. Thank you so much for that, Pratibha. Absolutely. And I think this issue is really, really global. Recently, we started researching on it at Jindal Global Law School, and it's quite interesting to see. So there was a survey in 2013 by National Association of Law Placement in the United States, which said that there were 47% associates in law firms, but only 20% leaders and partners. So I think they have a lot of these disparities in law firms. So moving on to Ravina, who's a recent grad and a younger corporate lawyer, and you work with another amazing law firm with a lot of women leaders. So it'd be great to share your perspective of how do you think women leadership is evolving or even changing, and how does that affect even younger people like you working in that profession?
Thank you. I think my views are partly aligned with what Professor Drew said and Pratibha ma'am said. I think at least as far as the Indian law firm setup is concerned, in the law firm that I work at, we have several female leaders and strong female leaders at that. But that being said, there is still a high imposter syndrome that women feel, where they feel inadequate or that they're not meant to be there at the table. And for centuries, we see women have just tried to get a seat at that table, knowing that their voices won't be heard as much. And that's slowly changing from at least my position, where I see my seniors voicing their opinions, making a point to voice concerns that are very female or very specific to their experiences, and expecting respect in return from their male colleagues and understanding, which I think is really helping towards developing that institution and making it more emotionally intelligent to consider the experiences of different kinds of people who work there. Today, we're moving to a situation where women want to, in fact, own their unique experiences and disrupt the stereotypical norms that are associated with this profession, and use their experiences to actually facilitate change, be it through running mental health seminars, which in my firm is run by a female partner, and which is really picked up, with male associates and female associates, highlighting a huge problem that law firms face in terms of burnout, or even in terms of sexual harassment at the workplace, which is also something largely spearheaded by female colleagues and female partners to bring about greater awareness on problems that women face. I think a great testament, at least to my generation, that things are changing, even though there is a long way to go, is that today when I'm in a room and there are other people, mostly again men, they will turn and they will ask me, what do you do? And when I say I'm a lawyer, nobody answers back and says, oh, is it temporary, or how long are you going to work for? So I think this itself shows things are changing, but there's still a long way to go. And as Professor Drew said, we need to start looking at, a larger set of women and not just the small anecdotal examples.
That was a positive note, the recognition that women can be lawyers and they're here to stay. I think Professor Ved Kumari wants to come back to some of the responses. So Professor, please go ahead.
Yeah, I just wanted to kind of refer to one comment which Pratibha started with, saying 50% of girls coming out from law colleges was President Rajkumar said so. But that's the figure which is more true for the National Law School and law universities rather than the general university. In my university, we still don't have even 30% of women in the law profession, in the education arena. That's kind of aside, that's just one other thing. But I think this whole question about the glass ceiling. And Professor Drew was saying she has not broken any. And I think I did break one at least. I was the first chairperson of a judicial academy in the country. But that's not something anybody introduced me with. That's completely ignored. There have been deans before me, but that is the designation I get introduced with, but not the one which actually was on merit. No, deanship is for us not an appointment. It is just by seniority. You happen to be the senior most at the right time, you get it. But that's how I get introduced, not with the real achievement I got. So, and when it comes to the glass ceiling, Pratibha and Ravina both are talking about that, we are finding place. But when it comes to the appointment as senior counsels, how many of the women have got appointments there? So you are well established in your institution, but that is your own individual firm. It is not straight recognition of your abilities. Lots of senior women, especially in Delhi, we got all these men getting appointments as senior counsels, and lots of them have to go out of the city to get them the designation of senior counsel. When it comes to appointment of judges from among these very senior, able women candidates, most of them are the men again getting to the High Court. So it is not that this whole space which is being now has become available. It's safe and it's kind of going to take you to a progression the way it would a man in the same position. And also when it comes to sexual harassment, means my students, so many of them face this when they come, because when they go to the profession, the first thing they face is the sexual harassment. Even at the internship that they've faced it, with the Supreme Court judges included. So the extent of sexual harassment with the law graduates face during internship and post-learn, I don't think that's kind of made a very comfortable place for them. So yes, some of us has made it, but I don't think that's reflecting of that India has created that space for women to be comfortable. And all of us who are here in our positions are here because our families, individual families were supportive, not as an institutional support. My family supported, my husband supported, my in-law supported, whatever that may be the situation. So without, that you don't have to, we didn't have to struggle. But those who are, they are working double time all the way. They have to look after their children. And also in my faculty, when I see, every time it is a woman's responsibility to educate children. So you might be, a very able lawyer, but you have to be able mother, you have to be a able granny, you have to be able homemaker, you have to be multiple able for you to find your space to breathe properly, which is not a struggle which my male colleagues find. So I certainly think that it's kind of good to be in spaces where we are comfortable, we can assert ourselves, but that's kind of me, us, we are in the panel. This panel is all women talking about our achievement. Where are the men? How do they see the women leadership? I think we needed to have a male person here, a panelist there, to respond to a claim that no, we are doing very well and we are all comfortably in our spaces. So that's a thought one can always postulate on. But I certainly think that it is important to recognize that yes, we have made some progress, but nothing which I would say in my understanding, and especially because our mindset hasn't changed. And in that sense, because I come from the academia, I certainly believe that education has failed us, not creating any spaces to talk about women. We have this optional paper called Gender Justice, which is opted by 40 students out of 2,000 we have in the law faculty. I mean, that's the interest we have in these other people to talk about. So I certainly think that just because, and I think we need to really open ourselves to see what's happening around us, to other people who are still struggling, who are still not finding. And why is it that if everything was hunky-dory in the legal profession, then we should have had by now so many judges and so many senior lawyers who are women. We're not there.
Right. So Professor Ved Kubari, actually my second question is related to what you just said. And I think it's true that it's still a struggle. But you've had so much experience in academia. In fact, you've been inspiration for many young academics like me. I just wanted to ask you, what role can law schools play in enabling more women leaders in the legal profession? Is there a role for law schools to enable some kind of women leadership in the legal profession?
No, for me, the first thing is to talk about discrimination. Law schools do not talk about discrimination anymore. We do not teach law and poverty. We do not teach gender as a compulsory subject. We do not even include a gender component in the other courses. So that's something, a taboo. Most of us, and we've had this so many times, a discussion about it. Every time there's a seminar, there will be work-life balance only for women. Men don't have to do any of that part of it. And I certainly believe that unless the education includes diversity as a necessary component of discussion, that diversity will be including women, but not only women. We certainly need to talk about disability, need to talk about this other, whoever that other is. There are lots of categorization of other. And unless we relook at our curricula to see how much discussion on other injustice we have. Mr. Bakshi asked this question many times. When we teach in the law faculty, in how many courses the teachers and the students heard or used the word justice as a goal of legal education or law. We always go to nitty-gritties, legal profession, blah, blah, but justice, and justice certainly is a concern for those who are disempowered by law. So that's not a component of conversation. Corporate law is one line, international law is another line, criminal law is another line. And there are ghettos there that you talk about this subject, but not the people who are getting affected by that. How does a policy affects different kinds of people? So when we are dealing with the company law, how does the company's profit or what we do is formation of company, winding up of company, partners, sleeping partner and working partners, and I don't know, all those kinds of things. But we do not work on that. What is the role they have or the manner in which they impact on the lives of the consumers of that company? So I certainly think that the legal education has to revamp itself. For creating leadership, one has to have leaders, thought leaders to start with. And thought leaders has to be inclusive in their approaches. Most of us have not experienced discrimination, and therefore we believe that discrimination doesn't exist. And unless we really hear our students speak to us, especially those who are discriminated, even in the national law schools, what I've heard, I've not been a part of national law school, so I do not know personally, but what I've heard from students who are doing researches or colleagues who are working there, that there is this whole chunk of students who are on fellowship. So they're trying to be inclusive in that sense. But within the student body, they are the excluded category. So I don't think, unless we do integration among our students itself, unless we are inclusive in the way we teach our classes, the studies have shown that in the classrooms, unless the teacher is sensitive to give spaces, special spaces for women to speak, women students pass out without speaking a word for 3 years. A lot of male students also do, but majority of the women students do. So I certainly think that the classes itself are so hierarchical, both from the teacher-taught category, but within the taught category itself also. As an administrator in the law faculty, whenever there was a rule to be employed, and certainly I had a notorious life as a dean, detaining students, that was the lot of agitations were there. And they will come and say, no, madam, you are like our mother. So which means that you don't have to be an administrator. You have to be mother, to include children, to pardon them, to love and give love and affection. Discipline is not the job of the mothers. So even if you're a dean, you should not cease to be a mother. And that's an argument I've not heard being made to the male deans in the past or future deans. So the moment it is a woman in the boss category, she is always should be functioning as a mother, care and love and affectionate, no discipline. Discipline is not your job. So I certainly think the way we conceive of the bosses, women bosses, is also an important discussion point. And maybe Rajkumar, we should call Rajkumar and say, what has been his experience with the women bosses, if he has ever had any?
Right. Yes, Professor Ved Kumari, I think these are all very important aspects that one must keep in mind as we are moving forward. And of course, these challenges are there in the law schools itself. Maybe I'm going to now move on to Professor Drew and just ask around, how do we make our law schools and organizations that we work in more diverse? What kind of policies do we need to make it diverse? And of course, Professor Ved Kumari pointed to the limitations of diversity, and then just diversity is not enough. You also need inclusion. And so how do we actually work towards such policies?
I suppose you have policies, and you have policies which include positive action. That seems to me the issue, and you comply with those policies. Those policies are living instruments, not theoretical and illusory. And like any form of soft law, they can be used. So in a way, I find that quite a hard question to answer, because it seems to me that, of course, you should have policies and you should use them to advance diversity, and diversity as a value is very helpful. Can I come back on this question of the triangle? And is that okay? Can I take the rest of my 4 minutes on that? Because I wanted to pick up the challenge that Professor Kumari and I think Ms. Jain, Pratibha Jain put up throughout, which is what's the role of the universities in creating a different world in the future. And of course, we all know that the triangle, there's no exceptionalism at the bottom of the triangle. I gave an online webinar yesterday to students in Paris, group of 27, 24 were young women. So, we know that something happens as you progress up the triangle. And we know that the children issue is massive as a disincentive. But I as a university worker, I tend to think you should give students two things: confidence and cunning, as they face the legal world. And someone just said, there's something going wrong because we have all these eager law students who leave as young women and then they dissipate. Why is that? And I think we should give them confidence. So in the words of the song, mutti mein hai takdir hamari, we should make them leave university feeling that. And so how do I do that in my work? Well, I, for example, did some films on advocacy models. I teach advocacy, and I made sure that there was a proper representation of young women across a diverse ethnic origins, so that when students were watching these videos, they just didn't get the same traditional white male, essentially. I think there is an issue about types of law. Certainly in my specialism, employment law, there are particular areas of employment law which men are briefed on. Transfer of undertakings, for example, and I think we are teachers, we should encourage students, if they're interested in intellectual property, and I'm sure Pratibha has points on this, but if there are particular areas that are seen as complex commercial issues, they shouldn't just be the preserve of men. If a young woman's interested in specialising in that, let her specialise in that. I direct exchanges, and I think exchanges are a massive way of students developing, good international practices. And so we're hoping to reintroduce actual exchanges, and maybe one way forward is virtual exchanges, and encouraging young women as young men to do that. And then I would also say, we had a UN report yesterday, didn't we, about how COVID, because women have had to do the bulk of the work during lockdown and so forth, academics, female academics article production has gone down. All women will say that they've just done more work at home. Teach our students to be cunning, teach our students to know that they will face challenges and a backlash, and equip them to deal with that, equip them to, make sure that they get their career and their children, make sure that how to deal with harassment. So that seemed to be the second thing that we need to be doing. So I'm sorry to trespass and not really answer the question, but I think there should be policies, and I think they can be effective to answer the question.
Thank you so much, Professor Drew. Let me move on to Pratibha. Pratibha, there was a research done by this very interesting journalist called Lalita Panikar in her study on legal profession. And in the study, I wanted to just suggest a few things she said, but let me just quote one, and I quote, "There is pressure for women to be better than male colleagues, and women lawyers or judges who fight to make their voices heard are often described as aggressive. This trait is seen as a virtue in male legal professionals, but not women." How challenging has it been to break stereotypes, to make the larger impact that you have in the world of law, both as student, you've done your postgrad from Oxford, Harvard, and then you worked in multiple jurisdictions, and then finally law, heading a very interesting law firm in the country. So we'd really like to hear from you on this. Oh, Pratibha, you're on mute.
Sorry. I was just saying that's a very interesting statement, because I remember my first review, my annual review in New York. My partner told me, you know what, Pratibha, it's a jungle out there. So you've got to be ready for it. And, you've got to, basically he was trying to tell me that I need to get more aggressive. And I wanted to ask him, how many of my male colleagues have you said that to? But that was like my first introduction to whether you're aggressive, whether you are conciliatory in your negotiations, whether you look old, whether you look young, whether you look whatever traits you might have, right? It's not about the traits, it's about your gender. Right. So if you're aggressive, it's a problem. If you're conciliatory, it's a problem. And how do you deal with it? You've just got to remember that the other side, there are unconscious biases. I think, if you want to ask me what universities need to do, they need to teach about unconscious biases. I think that's the most important thing, because most of the time the people I'm talking to, I was talking to this very senior BCG partner in one of our discussions, and he was like, why should you talk about it? The corporate law firm world doesn't even have biases. So it's not something that is even applicable to your profession. And I laughed because, there's just, they're all well-meaning people thinking, it's equal, law treats you equally, and hence, there is no bias. So what are you guys talking about? And let's just get out there, work equally hard, and you're going to get what you deserve. And no amount of statistics you throw at them is going to help you win the discussion. What's going to help you win the discussion is the unconscious bias discussion. There is a HPS study, I think, it's either HLS or HPS, where they take a very well-recognized leader and take out his name and give the study to two groups of students. To one, they present as a female, to the other as a male. And then come back and ask the group to talk about the leadership skills of this person. The group that thinks it's a female says that she's too aggressive, she turns off people on the wrong way, etc., etc. The group that thinks that this person is a male comes back and says, what an amazing leader. And this is well documented. So you just can't win, right, Deepika? I mean, how do you manage it? You just manage it by laughing and smiling and saying, okay, I recognize it's out there, and I just need to make it, let's say, easier for Ravina, and Ravina is going to make it easier for the next generation. And like I said, it's about volume. But yes, I would love it. Let's get Raj back in and ask him, why are they not teaching unconscious bias in every class in the university?
Right. Yeah, I think it's really interesting that there are also research recent research that is pointing to the fact that women are perhaps the better decision makers. They're the better leaders. When a woman is in the position, the pay scale is better, the negotiation is better, they're more compassionate. It could be pointing to some kind of gender stereotypical nature of like a caregiver woman being more compassionate, but there's also empirical evidence that things get better when women are in leadership. So coming to Ravina, I wanted to just get your view on this. What are the diverse and unique perspectives, experiences, and skills that women leaders bring to the table in the legal profession? Or even legal education, since you graduated so recently?
Yeah, I think drawing from what the other speakers have said so far, the fact that women are considered to be a certain way, or, they've always felt out of place at a table, or people have perceived them to be a certain way, or too much aggression or too much compassion, you don't know where you belong. I think the biggest role they can play is in terms of at least And if we start from legal educational institutions, is to sort of demystify and break these unconscious biases and, gender stereotypical norms. We need to sort of change our perceptions at a more fundamental level for men and women alike from a younger age, to sort of understand that it doesn't matter what your gender is. What matters is what you're able to do and achieve. And the opportunities need to be around for everybody in the same circumstance. But this is obviously a more grassroots change, which will take a lot of time. You were asking what educational institutions can do. And I think from a very recent student perspective, I can say that, something like a mentorship program or having strong female leaders have open discussions with younger students would really help them to become more comfortable in owning their opinion, their experiences, and being able to use that towards their benefit rather than thinking of it as a disincentive. I think secondly, the biggest thing that women can bring about is that they have diverse experiences, diverse responsibilities, and diverse roles as compared to men who usually have, 1 or 2 or 3 set roles. They don't multitask and they're not expected to multi-manage. As compared to that today, unfortunately, women are meant to multi-manage, and there is no solution where you can give up one thing and do another in the practical world today. Women have so many skills that they can use towards the benefit of the profession, which are usually regarded as weak points, but are actually not. One of these things is, for example, having a higher emotional intelligence and being able to understand, like Professor Vedkumari pointed out, who is the law impacting the most? Who are the people being affected the most, and what can I do for them? We have examples in India, like Justice Geeta Mittal, for instance, who, while she was in the Delhi High Court, helped establish special courtrooms and guidelines with respect to examining witnesses who were vulnerable. And her initiative was actually applauded by the Supreme Court judges in 2017, and other states were asked to follow suit. If you ask me, and I don't know her personally, but if you ask me, I think it was probably her position as a woman, where she probably saw that vulnerability. She saw what it feels like to be at a disadvantage, and how to tackle that and make the law more accessible to people who it really aids and seeks to help. And I think that is an example to go by, where women can actually use their inherent skills or abilities to make the world better, until the world realizes that those are just human nature skills. It doesn't matter what your gender really is. And as far as it comes to teaching, I think as a student at Jindal, I think we did have a lot of professors who in every class would bring about these stereotypes. I remember several classes having one lecture each at least, mostly driven by our female professors, where they did say, now I've taught you all of this is in the statute, this is the case, but let's look at it from a twale or third party or a women perspective, and let's understand how does it impact them. And I think I'm very grateful to have had that opportunity, because I know I don't have those biases, at least to the extent possible, thanks to that legal education. And I hope that is facilitated in the future as well.
Right. Thank you for that, Ravina. So at GLS, we do have 50%, we have a policy of 50% women hiring and 50% women in leadership. We have 55% women faculty right now. Obviously, we have those numbers on diversity. And Professor Rajkumar just messaged me saying that he's ready for any kind of interrogation, either through the chat or he can join us. So maybe we can invite Professor Rajkumar as well to join this conversation. And I think these biases are there. For example, I still remember as a young academic, I would, we had colleagues who would stop by every day. And I had a very harsh, because I was also in a position of leadership. You sometimes, just camouflage your personality to be a very harsh person, because you need to just be a no-nonsense person to deal with so many students and so many faculty. And I remember this colleague constantly telling me, beautiful sari you're wearing today. And I'm like, why do you have to stop every day and tell me what beautiful sari what research are you working on? That is the next question you will ask me. And just when I do that and I go back to my feminist discourses, it's really, really paradoxical, to be working in this kind of back and forth spectrum. So if Professor Rajkumar is joining us, we can have that conversation. But I also have a lot of questions from the audience. Clearly, there are a lot of people watching. So, Professor Rajkumar, would you like to join us?
And it's a very important conversation, and I want to say that I do agree with what Dr. Vedkumari and Sandhya were saying, but also equally I'm conscious of the kind of different lived experiences that both Pratibha and Ravina were talking about. I think the first thing which all of us need to recognize, and that's a very important recognition, is that these biases and prejudices are deeply institutionalized and ingrained in the minds of a number of people. And sometimes they're also deeply ingrained in the institutional imagination as well. And so, like so many struggles that society has gone through, be it, when it comes to discrimination against people on account of religion or caste or other types of discrimination, this struggle has to be continuous. And I do believe that a lot institutional leadership can do to create a more conducive environment. And I'll give a very simple example. A decade ago, when we would do these conferences and panels, we will obviously have conferences, and like all conferences in India and around the world, it's almost all panels are men. And men would be speakers, men would be chief guests, guests of honor, keynote addresses, and men will just be, dominating the entire discourse. And of course, then over the years, this was very conscious from our standpoint, because as Deepika mentioned, that was part of the ethos of our institution. And we consciously began to recognize the problem and then began to try to ensure that there is more diversity. And then time and again, I would have some of my colleagues tell, we don't have, competent women to be put in the panel. And I would get very exasperated whenever I heard that. And I remember a very interesting conversation I had with a bunch of High Court judges, and I don't want to name anybody, at the National Judicial Academy when I had been there for a lecture. And I would, lament about the fact that we don't have enough women judges. And these judges during the lunch would tell me, we don't have enough competent women judges. And this was very similar to what I would have heard from my colleagues. And then I said, you know what, since we have so many incompetent men judges, let's get some incompetent women judges as well. Let's make it far more fair and inclusive. Of course, they didn't like that comment. But the point is, this has to be a constant effort. And today, if you see, we have, and this may be a signaling effect, but it's a very conscious effort that in our panels, we have a policy now that at least say 30 to 40% of every panel should have women in it. And this will mean a lot more effort to reach out individuals. But in this conference itself, I'm happy to report that there are over 60 women leaders who are speaking in different panels. So in many ways, it also has a signaling impact on the mindset of students and others who are participating in these discussions.
Right.
Deepika, may I?
Yes, Pratibha, please go ahead.
So that's very heartening, especially, I remember about a couple of years ago, there was a HBS conference in India, and I noticed there was only one woman in the 4 panels that they had during the day. So definitely, I think globally, the universities need to take a cue from Jindal. And it was heartening also to hear Deepika talk about your faculty ratio. But I think you need to now go a step further and possibly, look at, that kind of a ratio among your deans also. So it needs to translate into the leadership level.
Right.
And also, I certainly think that, many women, many successful women, are successful because they are actually men. They behave like men, they think like men, they operate like men. So it's not that just because you're biologically a female makes you a woman leader. Margaret Thatcher was known as the only man in her cabinet. So for order to be successful, a lot of women want to be like men. They do not think that they can be successful and still remain their femininity. A lot of women leaders, I remember Madhukishwar. She was among the very big feminists, and now she's not a feminist. So even claiming yourself to be a feminist is seen like a negative. That and so therefore certainly this whole understanding that you got 50% women there, that's a good step, very major step forward. But how many of those women are really women? How many of them are female is what you can ensure. But how many of them think like Professor Bakshi always keeps on saying, I'm a woman? Because he said that it's not that the woman category is not a biological category. It's a socialization, it's an upbringing. So from female to woman is a transition. And how many of the women leaders in that sense are really thinking from the perspective or the life experiences of ordinary women? Because most of us who are in this higher position we have reached for different reasons, we cannot look at the world from my personal experience. No? As a group, we do say personal is political. But that personal cannot be my individual personal. Personal has to be as a group of people belonging to a certain sex. So certainly not questioning the very definition of who do we call as a woman leader. So a lot of women education has not, when you look at Pule, so a lot of education for women got started by male leaders. So it's not that women in positions of leadership always and have always will and always have been promoting women's issues. So certainly we have some, and Justice Geeta Mittal is certainly an example where she's taken it forward. But I was there at the academy in Karkarduma when she came for a session, and she just, because she does think with a heart, and she is a very sensitive judge. So we went to see the lockup in the place, and we found it was horrifying. Immediately she said, no, this has to change. But the in charge of that Kakarduma court at that time was a male judge, and he immediately took his own initiative to change the scenario. So I don't think it's so much the question of whether you are the male in that position or a female. I think it's your commitment to the issues of diversity, the commitment. Rajkumar is a male, but he is thinking in terms of promoting women, so says 50%. So it's not, so for me, this is very important to notice that merely because there is a woman in a position of leadership, but not a woman, a female in the position of leadership, necessarily she is working for women or vice versa is not true. That's not what I believe. Many years ago, we had for us the first woman professor in the law faculty in Delhi University was Professor Lotika Sarkar. So at some stage, I was asking her life experiences as the first woman professor, and she said no. She joined the 1956 law faculty, and she was given to teach criminal law, and rape was one of the topics. So the then dean told her that we're not going to teach this course because this is not something women talk about. But she said, I thought of myself as a professor and not as a woman professor. So she changed the sequence and taught it before the male professor could come and teach. And almost, 50 years later, at some stage, this subject got dropped because it was too sensitive to talk about. So women issues to the extent of rape was violent, offenses against women was rampant, and this was a huge national concern. Amendments were taking place, and we were not teaching the offense of rape or any offense against women. So we again had a discussion that no, we need to revamp. And one male colleague of mine said, no, I cannot teach this subject. It was too sensitive for him. And changing the tables, I said, okay, I'll come to your class and teach the topic, and I did. So after 50 years of what Professor Sarkar went through, we were in a completely different scenario where something as basic as rape law, one of my male colleagues refused to teach. And next semester, I said, no, I'm not going to teach in every semester. So you have to take it on. So they said, this is a self-study subject. So the resistance to talk about issues which are closer to women, even when they're introduced an institution, we have the colleague, and today, we have not only it's not limited to male, female colleague also, a lot of female colleagues feel very embarrassed to talk about this subject. So for them, and unless we can deal it in among the faculty which is teaching it, how do we expect our students to normalize that women's issues are human rights issues? We still do not talk about menstruation. We still do not talk about, there's so many taboo areas where we teachers, both men and women. So I'm not saying that only the men are not promoting. Women themselves are also don't think these are worthy. So I certainly think that we really need to think more deeply about when we look at women in leadership, what is the leadership they're leading? What are they leading? Are they leading women's causes always just because they happen to be women leaders? I don't think so.
Sure, Professor Ved Kumari. It's true that identity is not always emancipatory, but I think diversity is also very important. So Sarah Ahmed, in a very famous research on diversity, mentioned that there is always something missing in that diversity, and you become that diversity by filling in that gap. So I think it's really important, and I think it's really inspiring to see a set of all women panelists discussing these issues. And I think it's important to identify their expertise. Now, there are some pressing concerns and questions, and I'm going to take at least one of them because there are too many questions, and anyone can respond. Let me take the first one.
Given the importance of this panel, you will have 5 more minutes beyond the scheduled time.
We got 5 more minutes. Okay, thank you, Professor Rajkumar. So the first question is, what is the impact of maternity break on the career of women lawyers? Pratibha, would you like to take this, or Professor?
My favorite question on maternity leave always has been in my gender courses. Which article, Article 14 or Article 15, is maternity leave granted? And the moment we say it is special law for women, we have completely ignored that this is not 15.3, it is 14, because women are normal human beings and they do become pregnant. So unless we start asking that question itself, so if we treat them as a special category, so even if we treat them special category, then give them special retirement age, because maternity leave they will take 2 years of childcare leave. So instead of 65, they should retire at 67. So there should be a consequence there. And we certainly know that a lot of women lose their seniority, a lot of experiences in the profession, because they take a few years off to take their maternity leave. And we certainly think that we have done enough for women by granting them and by extending that leave, not realizing that how actually it works the other way around also beyond their essential time when they need a physical recovery. I certainly think that that's a very important question.
Right, thank you. We'd like to hear from you and Professor Drew as well.
It's a very tough question, Deepika. As a leader now in my own profession, this issue comes up, especially when we are discussing compensation all the time. And I'm very proud that as a country, we have a law now which is more progressive than a lot of other jurisdictions, and women are able to take advantage of it. Before that, definitely things in India were worse. So I think first is something like this does require state intervention. And after that, it becomes the institutional support, right? And there, in the corporate world is where things break down, because the bottom line is profit, and somebody is going to fill your space while you're gone, because you're going to be gone for a few months. I have personally witnessed it, and I continue to witness it as a leader in my firm. And I don't have an answer for it. Fact is that clients need to be serviced. So I am, whenever somebody comes back from maternity, we will ensure that, they get projects, but we cannot hold projects that were there. They might have built up those clients. They might have, done all the hard work to have maintained those clients in the firm. But the fact is they need to continue to be maintained. So it's a very, 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 very difficult balance to maintain. And I am talking now about nuances. What I'm talking about doesn't even get discussed in most of the institutions. We have very senior women partners in the firm. So, at least we have those discussions. I know for a fact, when I had 2 maternity leaves, this was not even a discussion in my previous firms. It was like, you come back and you find your own space. It's not our job to, see how you fit in, or, what do we do about it? So I think the more women get senior, it becomes their responsibility. And for the men, it's their responsibility to understand that it's a social necessity. I always break it down to economics. If you don't have women in workforce, India is not going to progress. One of the reasons why India's progress is stalled is because we don't have the 50% of the population that should be contributing to the GDP other than being a homemaker. It's not happening. So it's an institutional, and thankfully now we are getting pressures from corporates. We have to sign up to diversity policies of corporates. So the new gen companies, the tech companies, thankfully are taking leadership where they make us give disclosure as to our diversity policies and our ratios. So that's the other place where it's going to really help. So I think it requires state support, it requires institutional support, and individually, I know I was pressurized to come back, like to work from when I was on maternity leave. And I know a lot of women feel that pressure. It's upon us to be able to push back on it and exercise our rights, because those rights have been given to us.
I really want to come back on this one more time. Sorry for intervening again, but I certainly believe that the question about how do you calculate GDP? The moment you say if you're working, then your income will be counted towards GDP. Why would the unpaid work women do? That should also be quantified and say how much GDP is contributed by the women. If I take a worker in my household, then she contributes to the GDP. But when I do that work myself, it doesn't count to the GDP. So it's not a question that 50% of GDP, the women are not contributing to GDP. Their work is not recognized towards calculating GDP. So we need to question the way we calculate GDP rather than saying, push everybody to work. And work means not necessarily, should not be that, are you earning? I ask this class in my class all the time, how many of your mothers are working? And those whose mothers are earning, they say our mother is working. I said, then who does all the work? That who cooks for you, who washes you, who does everything? So that's not even considered work. So I think that's something we need to really relook at the way what we count as work. Why should, and at one point we say that we should have matrimonial property. So matrimonial property will be the one which has been bought together with the money by the two. But what about the unpaid work the women do? And certainly once we expect, and this whole thing about leave, maternity leave. So with maternity leave, that was absolutely essential for women to have because it's a biological necessity also. But when it came to childcare leave, what has the state done? Women only will take. So we are by state legislation saying, it is your responsibility to look after your children till the age of 18. The fathers have discharged their responsibility by taking 15 days of paternity leave. So they are through with their fatherly obligations toward bringing up the children, but it is by state. So for me, this is very questionable. And when you give all these quote unquote benefits to women, then certainly as an employer, why would I want to have a woman who will go on maternity leave and my project would suffer? I would want to have a continuity of the projects. So once Pratibha did recognize that the primary function of corporate is profit. So that is my starting point. Then why would I have women in my firm? But they are going to, and especially we had so many state laws. LIC had this policy of when you're filling up a form, you have to say, when was your last menstruation cycle? That are you not already pregnant before you take law? So we have been struggling with all those state laws, which are saying, oh, if you are pregnant, we had the air hostesses, you become pregnant and there's so many years. Also, the Supreme Court says that restriction on women after marriage not to have children for 4 years is going to help the population policy of the country. At that time, 800 plus women were there in the air hostesses. So if this 800 women will not produce children for 4 years, that will impact the national policy of national population policy. But the male persons at the same time can keep on producing children. That doesn't matter. So I certainly think we really need to rethink obligation of child rearing, because childbearing is an absolutely exclusively woman's responsibility. But child rearing, why it has to continue to be her exclusive responsibility? There has to be obligation. If you have a child, you have to take leave along with your wife. You cannot come to work. Unless we impose those kinds of restrictions, so the men can be free to do whatever they want to do without sharing any responsibilities. We were talking about pandemic. Certainly when a company hires a male, it gets 2 persons for the salary of one who is working and the woman who is supporting him to be on time, to be happy in that household, to do everything, to come late. She looks after everything in the household. So they get two persons to be working for them while they're paying salary for one. When a woman takes up a job, she takes up a ayah also. So she actually takes the money from the company and gives some money to the ayah. So and certainly the company is also saying, well, I'm only getting a half the woman because half the time she has to work on the home also. So women are not lucrative because of the biological category, the way we have set up the market, the way we have set up the norms for promotions, the way we have set up that being on time is essential for being a good worker. And women with these children, so small children who is becoming ill or something, they cannot be as regular. They might be working more, they might be working harder. But the way we have created our policies for their appointments, for promotions, for leadership positions are so anti-women.
Right, Professor Vedkumar, that's absolutely right. I think, Professor Drew, we'd like to hear from you as well. I'm afraid we're out of time, so we'd like to hear from you, and then maybe Ravina can have the last word.
Yes, I agree absolutely with what Professor Kumari has eloquently said. It's not just a problem of maternity leave, it's about the choice. There's a clash here between, at the bar it's a bit less of an issue, but for city firms, I know people who have left, long inflexible hours versus being the prime person in the household who's supposed to look after the children. In the words of that district judge, there's a nuisance. I think of one of my first cases where it was a pregnancy dismissal case. The judge was unwise enough to say in the judgment, the claimant should have thought of the consequences of her actions. So off we went to the appeal court. There's still that mindset, I fear. But I have nothing really to add. And it seems to me, Professor Kumari has said it all, that, this is another argument for moving from the exceptional individuals towards, as Professor Raj Kumar has said, the 50-50 balance. It just, tips the weight of all those people who have to make those choices and get moved away because they're thought not to commit to the firm and so forth.
Thank you so much. Ravina, would you like to come in?
Sorry, I don't have enough senior experience to talk about maternity leave, but what I can say is that I think the pandemic has brought us to a point where, on a general level, we are thinking about institutional changes, and we can actually think of meaningful structural and cultural changes that can benefit female lawyers and organizations where they work, be it law firms, be it academia, or even different sections of society. The problems highlighted are all pertinent, and some institutions have begun implementing them as well. But there's still a long way to go, and at least we're having discussions today, which is the right step forward. Thank you.
Thank you so much. It's really, really ironic that we live in a heteronormative society that rewards, socially and legally rewards reproduction, but then on the other hand, we also live in a society that penalizes reproductive choices. So I think it's a hard question, and it's really important for all of us to deliberate on this. I've had a really wonderful time having this wonderful conversation. Thank you to Professor Rajkumar for curating this wonderful panel. I look forward to having more such conversations. Thank you so much.
Thank you very much.
All right. Take this moment to thank each one of you for your time. I really appreciate Professor Vedkumari, Professor Sandhya, Deepika, Pratibha, and of course, Ravina. I want to say that as law schools and institutions, we should be doing at least 5 things, and I will quickly say that. First, we need to celebrate the achievements of women faculty and scholars and should consciously do so. Second, we need to constantly work towards diversifying the faculty with more stronger representation of women in the law schools, in teaching, research, and administration. Institutions need to dramatically change themselves with strong women leadership at all levels. Third, women law students need to be constantly reminded and empowered to be able to fulfill their fullest potential. They need to be told that they can achieve the pinnacle of their dreams and aspirations and overcome all the challenges through knowledge, expertise, and skills, which will form their foundation. Fourth, at least in India, we really need to overcome the national and global embarrassing situation that we are in with so few judges in the Supreme Court and the High Courts. For a country that has had both women assuming the offices of Prime Minister and President, we really need to have some future Chief Justices who happen to be women. Fifth, every occasion of discrimination need to be called out, and we should develop intolerance for any form of discrimination. This is my I Have a Dream speech, and I hope that we can work towards changing the situation that we are in. I know for sure that each one of you are contributing to the change, and I'm grateful to you for sharing some of your perspectives today.
I think Pratibha wants to say something. Yeah.
We added one practical one for you. You should be teaching unconscious bias in every class.
We'll have a pedagogical practice on that. Thank you so much.
Thank you.
Well, thank you so much. And we'll have a very short break and move to the 29th thematic session of the conference on financial stability and sustainability of law schools during the pandemic. Thank you.
Thank you.
Good evening from India. My name is Rajkumar. I'm the founding Vice Chancellor of OP Jindal Global University. I would like to extend a warm welcome to all of you to this global virtual conference on reimagining and transforming the future of law schools and legal education. We are, of course, sitting here to be part of the 29th thematic session of the conference on the theme Financial Stability and Sustainability of Law Schools During the Pandemic. I would like to extend a warm welcome to our distinguished panelists, Professor Vesna Klinik-Rotic, Dean of the Faculty of Law, University of Rijeka, Croatia, Professor Dr. Jan von Hein, Dean of the Faculty of Law, Albert Ludwig University Freiburg in Germany, Professor Dr. Robin Hickey, Head of the School of Law, Queen's University, Belfast, United Kingdom. We have with us Professor Anand Prakash Mishra, Director of Law Admissions and Associate Professor of Legal Practice and Associate Dean of Jindal Global Law School here at JGU in India. And of course, I'm grateful to our moderator, Professor Dr. Ashita Dower, Associate Professor of Jindal Global Law School. The issue of financial stability and sustainability of law schools and indeed universities has become a very critical issue during this pandemic. There are horror stories from different parts of the world which are emerging, in which universities are fundamentally challenged due to the COVID-19 pandemic. Universities and law schools, which were dependent on international students' revenue in particular, have been adversely affected more significantly. So during these difficult times, there could be no better way than all of us coming together in having this conversation. So with those words, I'm going to hand this panel over to Ashita to take this forward. And I look forward to seeing all of you in the next 55 minutes. Thank you.
Thank you, Professor Raj. I extend a warm welcome to all the panelists. It is a very crucial theme in our times because we had not expected this overnight striking of the pandemic, and we have been suddenly, there has to be transitions which have to be made. So certain thoughts that are there, as Professor Raj was also mentioning, that there have been adverse impacts on institutions, so much so that the institutions have gone into insolvency. The ones who have not gone into insolvency have merely survived and with declined net fixed assets. So also there has been a blanket shift from physical classes to online classes. So this blanket shift in online classes, it seems that they should be cheaper, just as an ebook is cheaper than a regular book. But what happens is that in online classes, the institutions have to suddenly develop a lot of infrastructure to support those online classes. So there is a flip side to it as well. However, if we look at the economy, especially the Indian economy, then we look at the previous year, and during the lockdown, what has happened is that 47% of private investment has gone down. Consumption expenditure has gone down by 27%. And the GDP of India has gone down by 24% from April to June 2020. This unfortunately has an impact on the disposable income of the people, and this reduces the propensity to spend on education by people. So institutions are at the receiving end of that because there is this demand which is there, but there is disposable income which is lesser. And institutions are running at very thin margins and have a lot of fixed costs. But what is interesting is that in these institutions, especially the domestic-based institutions, are facing a lot of domestic demand because of the restriction in the international mobility. So the institutions are also, the law schools have to take up this demand, fill their, cater to them, and that is a good thing. While it's a good thing, it puts a lot of pressure on the financial resources as well. But again, this pandemic can also serve as an opportunity. It can serve as an opportunity to develop infrastructure for the future, for not only the short term and the medium term, but the long term. I will like to ask all of you certain questions. And the first things that come to my mind, I will like all of you to address that. And that is, how are the law schools across the world confronting with this pandemic? What are the adjusting mechanisms? What is the immediate financial impact of this overnight transition to online classrooms? And were there any lessons which were learned from 2007-8 crisis, which could be replicated now suddenly when we faced this shock? So I will like first Professor Srinich Grotich, then Professor Fonhan, then Professor Hickey, and then Professor Mishra to address these questions. I will also request you to take 2 to 3 minutes for each answer. Thank you.
Thank you, Ashita. Thank you very much. And I would like, of course, to thank the organizers for inviting me to take part in this interesting conference. I am sorry that my first visit to India has to be virtual. I would rather, of course, visit you in person, but that will have to wait for some other times. I come from the city of Rijeka, which is one of the 4 biggest cities in Croatia. We are situated on the coast, and we have a university. We've had it for the last 45 years. So in respect, we are a younger university. We are state-run university, which means that we get all our financing from the state. And that also includes the scholarships for students. So the scholarship is paid by the government, and we receive financing per capita. So depending on the number of students that we enroll, this is our finance. We have actually faced a big drop in the number of students about 3 years ago, which was a bit of a surprise for everybody, but that was the result of a constant, I can call it propaganda if it's not too strong a word, by the government that students should not enroll in law and economy, because those 2 disciplines are the most popular, have been the most popular disciplines, and the government actually wanted to lower the number of students enrolling in these 2 disciplines. And that is why we faced a drop about 2 or 3 years ago for almost 40% of students. That have affected already our financing, and that already made us turn to alternative sources. Where do we find, and this is really something that is helping us now, because now we already have worked on the alternative resources. Where did we find them? We mostly find them in additional funding from the state. There was the last ministry actually had additional programs that they financed based on the excellence results, if I may call them. So the results in publications, results in student propensity through the dynamic through the school, and also the number of students that enroll with respect to the number of students that finish. So we managed to acquire some additional funds through these programmatic contracts. Furthermore, because we are a member state of the EU, we used the opportunity to get some of the EU-funded projects. So we are now running 2 big for us. I mean, it's about €500,000 euros, 2 projects that we are running. And what is now also paying off is the fact that one of those projects is really student-oriented, student practice-oriented. So we are now using this project to finance additional needs of our students for online studies. So, for example, we were able to finance through this project acquisition of what do you call them? Bases for digital bases like the Westlaw or BACS in the German language. So this helps our students and also our staff to be able to get to the digital resources that would otherwise be very difficult to get. And that is because we are able to fund this through this project. So in a way, unlucky and lucky, we were still lucky to to be able to be ready to answer to this digital era. I mean, this, of course, is traumatic in a way for everybody. And our students, although they are mostly able to join us online, but I can also say that they are not very happy about it. So I will perhaps add some more answers in the discussion. Thank you.
Professor von Hahn?
Yes, thank you very much. First, let me thank you for inviting me to this splendid and distinguished panel. The basic situation of the University of Freiburg is rather similar to what Professor Czerniec-Grotic said. We are also a state-run university. Germany is a federal country. We don't have universities that are run by the federal government, but all universities in Germany are run by the state governments and financed by the state governments. So it's a bit of an advantage if you're in the south, in Baden-Württemberg or Bavaria, because these are traditionally the more affluent German states. So universities are better financed than, say, universities in the northeastern part of the country, because everything depends on the financial resources of the state that runs these universities. So we were in a quite good situation to start with. We are not relying on, or basically not relying on, student fees for students from Germany and the European Union. There are no tuition fees. There are, however, tuition fees for third state nationals, for example, from India or China or Japan. But again, there are numerous waivers for these tuition fees anyway, if you have a partnership agreement with the other institutions, so that German students go there and others come to us, then there are usually no fees. It's a source of income, but only to a very modest degree. So that's not something that we're really relying on for our stability. And the third factor is that the University of Freiburg, in relation to its size, is rather strong on third-party funding, both from German sources and from European sources. Adjusted for its size, then we're one of the strongest universities in Germany in this regard, actually. So this is also a rather stable source of income. Nevertheless, there were additional costs associated with the pandemic, because before spring 2020, our universities and other universities in Germany as well were not so strong with regard to digital teaching and all forms of digitalization. So we had to spend some money on buying cameras and buying more laptops for staff who were sent to work in the home office, because we have rather strong data protection regulations in Europe, the general data protection regulation. And then it turned out that, for instance, staff working from the home office could not log into the university system by using their private laptops. And of course, before, not every staff member had their own university laptop. Not every secretary or assistant had this. So we had to really spend some money in the spring to make sure that they could work from home, but at the same time, data protection rules are observed. And we received additional funding for this from the state government. And on the other hand, or in addition, the university reduced in the spring the faculty's budget by 10%. So we suffered a 10% cut. This money was withheld to have a cushion, so to speak, to have some money in the bank if the costs turn out to be higher than expected. But just at the end of this month, now in November, it turned out that the financial, the budget plans were quite solid. And at the end of the day, those 10% were paid out to the faculties as well. So there has been some impact on the financial situation, but I think from a comparative view, we are still doing rather well at the moment. Thank you.
Thank you, Professor von Hahn. Professor Hickey?
Thank you very much, Ishita. And let me add my thanks to Professor Kumar and to all of you at Jindal for having us and for staging this wonderful event. I think it's a fantastic conference and something very positive to come from these very difficult circumstances. In Northern Ireland at Queen's, we started from a slightly different operating model to the one that my colleagues have identified. So we have three main sources of income. We do receive some state funding for tuition in respect of students from Northern Ireland, but even those students also bear the responsibility to pay some of their own tuition. They're not necessarily paying that directly themselves. They have access to a state-sponsored loans scheme to pay their tuition, but there's a substantial tuition fees liability for students from Northern Ireland or from somewhere else. And so we rely to a very great extent on tuition income for our stability. We also receive some money from the government through the excellence of our research and the scheme like the one Professor Greenwich-Protich described. So as we find ourselves reacting to the emergence of the pandemic in the spring, there were really two immediate pressures in terms of costs. And one of those was the operational costs that have already been identified in terms of getting people ready to work from home and getting the campus ready to deliver more virtual teaching. And then we also had the enormous staff costs in doing every other aspect of work remotely, whether that was getting examinations ready to be delivered online or through another means, whether that was offering student support services online, everything from ordinary pastoral interaction right through to support to access library resources and so on. We find enormous staff costs and staff time invested in managing the pandemic. And at the same time, because of that tuition position that I've described, we were immediately looking ahead to student recruitment for this year and thinking about how we could successfully support students to make a choice to come and study with us, and also to think about the content of the degree programs and how that would be affected in the longer run by the pandemic. So both of those things in their own way are about staff time and about the idea that in research intensive law schools, we have to devote an increasing proportion of our time to getting ready for teaching and recruitment. And I can say a little bit more about how we did that, of course, but those were the immediate thoughts in the aftermath of the pandemic.
Thanks, Professor Hickey. Professor Mishra?
Very good evening, everyone. Greetings from Sonipat, all the audience. I will like to give the Indian perspective. And unlike many other countries, India has a rather complex legal education system. We have different type of universities in both the public as well as in the private sector of higher education, and both have different issues. If I look at the public university system, the central universities set up by parliament or the state universities set up by state legislatures, their law departments or their affiliated law faculties are very little affected by this pandemic, frankly. What I learned from my colleagues in, say, University of Delhi or Banaras Hindu University or some other central and state university law faculties, that they're just losing their local travel allowance, which they get otherwise when they come to the campus as a part of their salary. So they are taking classes online from their homes. So they are losing a very, so it's not affecting the faculty members, the staff, and the institution as such. But the bulk of Indian higher education, almost 70% of Indian higher education is now in the private sector. And the deemed university and the private universities constitute all those institutions. So we have 1,650 law colleges in India. And out of that, there are only 45 central universities which are having law departments, and another 200-300 state universities having law departments. There is a system of affiliated colleges to state universities, where again they are self-financing and they are facing deep troubles within due to this pandemic within the state university system itself. But the maximum, I will say, crisis has been with many private universities and newly established private and deemed universities. We at Jindal Global Law School and OP Jindal Global University are rather fortunate and blessed in that sense that our university and particularly our leadership was visionary and foresighted enough to guard university against these crises well in advance. We were among the first institutions to do a lot of things to take care of the situation which was coming. Like our admission process was made online. We made our entrance exam, LSAT, an online test overnight. It has, for last 10 years, it was always paper pencil test. But one morning I received a call from my vice chancellor, and he said, in this situation, it's impossible that there could be a paper pencil test, Anand. And we have to talk to LSAC in the US, and we have to immediately get it done online. And thankfully, we were among the first law schools in the country to start classes on 1st of September with the full class in all our programs. So we have not been affected at all by the pandemic in that way, as our students and our faculty members are all, in the teaching learning process. And I will be very candid to tell this, that in our university, and as the university leadership has to be thanked for that not a single person from a university professor level to the lowest level staff has lost his or her job or any salary cut or any sort of, and we are handling it well. And I will particularly thank this to the leadership of Professor Rajkumar. But at the same time, I am fully aware that many of our universities are facing deep troubles. The professors are not getting salaries. There have been regular salary cuts since March 2020 in many of the universities. There have been no faculty appointments in many institutions. And there are many other issues being faced. Even the government universities, they could not develop the technical and technological support system. And the most premier of our central universities, they have not been able to start their classes even now, when our first semester is going to be over and exams are going to be announced in the month of December. Our apex institutions, some of the most important central universities, have not been able to start their first semester classes. Rather, they are yet to complete their admission process. So admission has not happened.
I'd like to come in now and pose another question, actually.
Yeah, sure.
And that is a question which I think you will be very interested in answering. Part of it you already did. And I will invite Professor Hickey also to address it. And that is regarding admissions. So basically, what are the challenges that you have faced in reaching out to the students during the pandemic? And related to this, there is a question from the audience which asks that has the pandemic affected admission of intake of students in the law degrees given the higher fees in law for the law department? So Professor Hickey and then Professor Mishra.
Well, thank you for both of those questions. I think in terms of admissions generally and bringing students into law school, of course, in lots of ways that relies on face-to-face contact and on getting to know the students, whether that's by visiting them in their schools and running sessions and awareness training about what it means to do a law degree, and more about them coming to visit the campus, of course, to get used to the facilities and to imagine what it might be like to be at law school. In the week when the lockdown was announced in the UK, I had been due to travel to South Asia to do a number of school visits and to do some recruitment fairs. And of course, immediately those things are cancelled. And happily, we're able to reproduce quite a lot of that in the online world. And suddenly I found myself very quickly doing a call with 200 or 300 students on Zoom, putting questions up in the chat and asking things about the university. And you could do quite a lot of the information transfer. You can make yourself visible. You could show that you're a happy and friendly person at the other side of the world, waiting to welcome somebody to law school. But I think it's difficult, isn't it? It's difficult to reproduce those sense of personal ties and commitment, and to give a really an accurate flavour of what a place is like in a virtual environment like this. And I'm sorry too that my first visit to Jindal Law School is a virtual one, and we feel the weight of that quite keenly. And so the work at that time went into trying to replicate that experience of visiting the campus as far as we possibly could for students. And I think the technology gets us some of the way, but it doesn't get us the whole of the way. And I think whatever happens in the future, campuses and spaces will remain important. In one of the panels yesterday, there was discussion about our buildings as equalizers and as places that lend themselves to social mobility and to inclusion and to support for students. And I think that will always remain the case. And I think that a big challenge of the current admission cycle has been trying to give the students some visibility of that. In terms of our student numbers this year, we haven't really seen an effect here. And I think, Ashita, that might link in part to the second part of your earlier question about lessons from the previous financial crisis. I mean, I think one of the things that we do seem to see in the context of worldwide downturns is that people turn their thoughts to education and to opportunities to move their skill set on and to think about new ways of contributing. And so I think that there is a bit of an opportunity for law schools to make that contribution and to offer it in a time of crisis. Interestingly for me, we have seen the enrollment on our core law programs, so that the different primary law degrees where we're teaching the foundations of legal knowledge subjects. And we've seen the recruitment on those grow across the board, and also really hold steady at the postgraduate side. And so for me, that's exciting. I don't know quite what it means yet, but I think that in the current circumstances, there's going to be an appetite for those kinds of very transferable, very valuable skills that a law degree can give anyone.
Professor Mishra, I'd specifically like to know that one of our audience wants to know that since law degrees are expensive, does that act as a deterrent for people accessing the education in the law school, especially during the pandemic?
So, Professor Ashita, in Indian scenario, we have different type of law schools. There are different varieties. If we have, say, a Jindal Global Law School, which could be an expensive institution from Indian standards, though if you compare it globally, it may not be. We also have multiple central and state universities which are offering legal education almost free, without any fee. And there is an option to study law for almost any desirous student in our country. Certainly the national law universities and private law schools are expensive for their own valid reasons. But then the central universities, state universities, and their law departments are available for those who are not able to afford the kind of cost. Now, if we look at this pandemic, certainly admissions outreach has been affected, because one of the most important thing for the admissions outreach people was to reach out to students in their place, to organize open house events, to interact with the students and parents in multiple cities. We are a large country, and as a part of our admission outreach system. We used to do open houses and town halls and a lot of even a small interactive sessions in different parts of the country in a physical way. And also, a lot of students and parents want to visit the university campus before investing their 3 years or 5 years of time and money. And that could not happen due to pandemic. So premier institutions like us are not affected as such our admission process. I have seen rather increase in applications in both our LLB and LLM programs. And a bit of, I found due to outreach issues, we were not able to reach out to many cities in physical way by traveling to those places. Certainly, our 5-year law program saw a little drop in the applications, and that is attributable to this pandemic. But overall, I believe the premier institutions attract a student from all over, and the students don't care whether it's a pandemic situation or whatever. They join, they study, they go for a premier institution in whichever part of the country, whichever part of the world.
Thank you, Professor Mishra. Professor Vonhan and Professor Slinish-Grotich, I'd like to ask you a specific question regarding the state funding. That because your universities are state funded, how does the state organize funds? As in, like, do they have enough funds, or is there something like an impact bond, which is used in India, which can be a social impact bond and not a development impact bond, so that the state gets its return as well? So otherwise, like, what is the state funding mechanism? How do they get their funds? Either is that only through taxes, or are there bonds like the way I'm mentioning?
Yeah, well, the state of Baden-Württemberg or other German states is financed by taxes, but also by other income sources when citizens use public facilities, for instance, and have to pay a fee and so on. So it's a very varied system, but the main income source is actually taxes. So I understand your question whether the funding is associated with certain social goals that we have to reach as a university. Well, there are certain laws that oblige us to take into account certain social goals as well. For instance, when it comes to appointments commission and the hiring process, we have to make sure that female applicants, for instance, are adequately considered, and we also have to make sure that we have to increase our male to female staff ratio. So far, we have, as in other countries, I think maybe the case as well, more male professors than female professors, which is something that should be adjusted to a near 50-50 level in the future. So we have to justify, for instance, things that you get certain extra premiums for certain decisions made by the appointments commission. For instance, when you have when you invite 5 people and 3 of them are women, then you get an extra premium. So the funding is attached with some social goals also relating to other diversity measures. So it's not that the state gives us the money and then we can do what we want. Of course, we are free in our scientific research, so the state does not prescribe us what kind of research we do and what we don't. But with regard to appointments commissions, the administrative process, and so on, there are some social goals that are associated with the funding, yes.
Yes, as I was saying, the system in Croatia is that the schools get funding based on the number of students they enroll. But then the state funds the full scholarship for students who are successful in their work. Because we have this credit system, ECTS, then students who do not fulfill a certain number of ECTS, they have to pay their own scholarship. So it depends on their success. So partly they have to bear costs of their own scholarship. It may come to you as a surprise, but actually it's cheaper to study law in Croatia than some other sciences, because the government, the system is based on the costs of studying. So social sciences and humanities are cheap, according to the government standard, because you only need a book, probably. But if you are in medicine, or if you are in technical sciences or computer sciences, then you need like equipment. So that costs more. So we are a relatively cheap faculty, and we try to attract students based on quality, because the price is the same wherever you go. In Croatia, we have only 4 law schools. They are all state-run. We don't have any private law schools yet, which is a bit surprising, because we have several private schools in economics, but not in law. So I don't know. I'm not sure quite why is it so. We have to say that we have not been affected by the crisis yet, but that is also partly because we are small. So, and we've had not just the crisis of 2007 and 8, we've had crisis of 90s, because we had the war in Croatia. So we have not fully recovered from that when the crisis of 2008 hit, and now we are in a new one. And if I can be sarcastic about it, I mean, if you are always in the crisis, you don't notice when the new one comes. So you are already adjusted to it in a way. And I think this is just one more of those, but this one I think is even worse. We are saving money, funny enough, on travel expenses. That was a huge bulk of our budget, was traveling expenses, because we try to encourage our staff and also help our students to attend conferences, international conferences, to participate in international moot court competitions. And all that now has gone online. And so we have no expenses in that part. And we are actually saving money on that we can spend on the costs that have occurred because of the pandemic, such as IT equipment, obviously, but also the equipment that you need for keeping the environment at the faculty still safe in a sanitary manner. Thank you.
Thank you, Professor. The next question that I have is essentially regarding equity. So in terms of staff, many of those who provide operational backbone of the campus, from janitors to food service workers, may lack financial cushion if they are laid off or go unpaid. How can law schools, having their own financial concerns, incorporate a sense of equity? I'd like Professor Mishra and Professor Hickey to address this. So Professor Mishra.
Professor Ashita, first of all, we need compassionate and university leaders who consider humanity as the most important element in running the university and institutions. So if we have the desire to help people, to help your own staff, your own, from the lowest level, the janitors, university drivers, to the highest level, our professors and deans, the universities may cut cost on other fronts and in other areas and manage to keep the flock together, to keep their staff, and because everybody is needed, the situation will not remain same. When the campuses are going to open, when the hostels are going to be filled with all the students, and when the classrooms are going to operate in the physical form, everybody is needed. So I think we have handled it very well at Jindal Global Law School and University. And I believe our other private universities in the country and deemed universities, if the management is sympathetic and compassionate and considerate, they can handle it. At the same time, I think because higher education is not just the universities the responsibility of, actually it's the responsibility of entire society, entire country, entire nation. The universities provide the workforce. And therefore, I believe for a situation like COVID-19 or a pandemic-like situation, there should be some COVID relief fund for universities, maybe set up by governments. We have, say, 1,000 universities in India. And if the government could create a fund, a COVID relief fund for universities, providing some money to universities, for COVID measures, that can take care of a lot of discomfort, and also that can save, that can protect jobs of the staff and faculty.
Thank you, Professor Mishra. Professor Hickey?
Well, I just entirely agree with everything that Professor Mishra has said. I think he's put it exceptionally well, and I don't think I can really add very much to it. Compassion is definitely the key word, and I think university leaderships do need to lead with that compassionate tone and response. I would add, I think that it makes a very powerful social impression when that happens. I mean, as Professor Mishra has said, universities play a key role as economic drivers in communities. And I think to be seen to take a compassionate tone with our own staff, to make sure good support arrangements are in place, to make sure good wage systems are in place, and that those articulate with the different responses from government to the circumstances of the pandemic, it's very important that universities do that well. And if universities do that well and are seen to be leaders in their communities, I think there is a more profound social benefit that comes from all of that.
Thank you, Professor Hickey. My next question is regarding financial aids to the students. So, I mean, since it's a pandemic, the institutions are facing losses. How is it that the financial aid is being managed? So I'd like Professor Fonhan and Professor Srinich to talk about this.
Yes, thank you very much. Yes, indeed, the pandemic has created financial difficulties for students, although law studies in Germany, except from our two private law schools in Hamburg and Wiesbaden, is free from tuition. The costs of living in German cities, especially in the larger cities such as Munich, may be quite high, and the pandemic has caused a loss of typical students' jobs. For instance, a lot of students work in restaurants as waiters or waitresses, and since restaurants are now completely closed, those student jobs are no longer affordable. So many students lack a source of income that they have put into their calculation when they took up their studies. And so different programs have been started at the federal level. First of all, the state-owned bank, the Kreditanstalt für Wiederaufbau, has put on a loan program for students. So students can apply for a loan which covers a sum of up to 650 euros per month. And this is a rather unbureaucratic procedure, which has been well received in practice. And for students who are in a situation of financial necessity, meaning students who have less than 500 euros on their bank account, there is a short and unbureaucratic possibility of receiving interim financial aid. So this is given out as a grant. It's non-refundable. The other source of income is the loan. So at the end of the day, students will have to repay it, but there's no interest on this loan. So it's still financially attractive. And then we have this other source of interim relief for situations of acute financial distress. And it's a situation of, or it's an indicator for the social situation, financial situation of students, that this interim financial aid has been applied for in now 155,000 cases. So that gives you an impression how important it is for students in Germany to receive this additional funding. Thank you.
Thank you, Professor. Professor Srinish.
Yes, in a way, the situation is similar in like in Germany in terms that students only pay for tuition. So that, and as I said, it's not a very big amount. But if you have students living in another city, then the costs of living are, of course, much higher. There is a system of student homes, like dormitories, that are heavily subsidized by the state. So the costs of living in those dormitories is really not that big. It's less than, well, about, I had my daughter living and studying in Zagreb, so I know a bit about it. It's about 50 to 60 euros per month for a 2-bed bedroom. And then the food is also subsidized by the government. So they pay very little, like 2 euros or less for a full meal. And in that respect, it's cheap. If you are a full-time student and if you fulfill your obligations regularly. However, if you lose this track, then you find yourself in a bit of a more difficult situation. And it's mostly parents who subsidize, who finance their children. We don't have a very well-developed system of student loans, and they are not very popular. My university has a system of student loans, but they are really not popular. Nobody likes to take it. But what our university, my university, has is a kind of financial aid for very poor or students who are in a social need. Then they get a certain funding for tuition and for the living costs. But then they have to prove that they really have no income and that their parents have no income. So you really have to be very poor to get this kind of assistance. And then my own school also has a small fund helping students to pay their tuition. So if they also have such a social status that they need this kind of support, we are as a school ready to help them. Thank you.
Thank you, Professor. I have a question for all of you from the audience. So the question is this, that in a country like India, students struggle financially to afford laptops or good Wi-Fi connection. In the given situation, what role does the college play in providing support to respective students along with their taking care of their own financial needs? So basically access to technology, especially during this pandemic, how is that provided by the college? So I would like to first go to Professor Srinish, then Professor Hickey, Professor Fonhan, and Professor Mishra.
Yes, that's a problem for certain for some students. During the first lockdown in the spring, we had a couple of students who needed help in equipment. So we borrowed, we gave them a laptop, and we helped them with paying the bill for the Wi-Fi, because that came so suddenly. I mean, nobody was expecting it. So we really thought that it's important for these students to receive some kind of assistance. Now we are in a second wave. So in the meantime, students had the chance to organize themselves and to find other resources. So now the demand is still there, but rather low. And we are ready to borrow the equipment and to help them with the financial aid. Of course, we are talking about very few students, so that is something that we can afford to do. If it were a bigger number, then of course we don't have special resources just for that, and that would be somewhat difficult. Thank you.
Professor Hickey?
Well, it's a very important question, isn't it? And our response was the same. We loaned laptops and other computer hardware to students. We made sure we had a system to manage that and to make sure that students had access to the support. I think that the second piece of the puzzle relates back to my earlier comment about our buildings as levelers and remaining important during these times. I mean, so in Northern Ireland today, we've begun another 2-week lockdown. As part of that, universities were asked to do as much of their teaching as was possible online. So face-to-face instruction is only happening where it's absolutely necessary. But we have been able to keep our buildings open. We've kept our libraries open, socially distanced with precautions in place. There are study spaces in the campus that students can access. And of course, the Wi-Fi is likely to be better quality on the campus. And I think it's really important that we retain that sense of the availability of the campus and the facilities of the campus, even in a world where lots of the instruction is happening in a virtual space. So just because the tutorial is on Zoom doesn't mean that the university is closed. And I think that the university retains that sort of social and teaching leveling function. The other thing that I'm reminded of is that had any of this happened even 5 or 10 years ago, it would have been much harder to keep going. I mean, Zoom is available on a phone. Teams is available on a phone. Almost all of us have smartphones these days, wherever we are in the world. And at least it is more possible than ever to interact with each other in a live and constructive way, just like we're doing at the moment. So thank goodness it's happening now in some respects.
Professor Vonha?
Yeah, well, the students bring their own laptops as they did before. I mean, Germany is still comparatively a fairly affluent country, so even before the pandemic, both students had their own laptops. I have to say that in many cases they have more modern MacBooks than I myself have at my disposal. But so this is not such a big problem. Of course, it may be a problem for students in a situation of financial distress. I recognize that fully, but in this regard, we have those programs that I already mentioned, the loan program by this federal state bank and the additional financial interim aid. And of course, this money cannot be spent only on rent or food, but requiring a new laptop to follow the courses may, of course, be another situation which creates a financial necessity. So you can pay then by these loans and interim financial aid for such purposes as well. So this is taken care of. We had originally tried in the fall term this year to offer a kind of hybrid learning environment for our first year students, because we had the intention of providing at least first year students with actual courses, seeing a living professor in front of them. But then when we started our term, the rate of infections in Germany had already reached such high levels that we have to give up those plans. So when we started the fall term, everything was back to complete online teaching as well. And in this regard, problem may occasionally be that the Wi-Fi transmission rate may not be sufficiently high enough for students to follow the courses, because they're at home as well. And if there are, for instance, 5 or 6 students living in a flat in Freiburg and they're sharing the same access point, and everyone at Monday on 10 has an online course to follow, this may occasionally be difficult. So this has also triggered a discussion in Germany that we need to improve our general standard of digitalization, because although Germany is a fairly affluent country, here we are still behind in many areas, behind other EU member states. Thank you.
Thank you. Professor Mishra?
See, in Indian context, I feel we can handle this issue from both university or college or higher education institution side, as well as from the government side. I strongly believe the way Uttar Pradesh government, one of our state governments, if you remember in past, they distributed laptops to almost every student who passed class 12 exam and went to a university. So in a similar way, I think the university students, whichever university they are studying in, those who come from economically weaker section, those who are having their below poverty line certificates which are issued by the government in our country, those students, the government should intervene and provide them technological support so that their studies are not discontinued, they are able to attend classes, they're able to take exams and all that. From university or college side, the best way is to enrich your computer center. I was in University of Delhi and it had a very rich Delhi University Computer Center with hundreds of terminals available for student use. So institutions can create public computer centers, and maintaining social distancing, students who are in the vicinity can use that facility if they do not own their own laptops for the time being. And also it's true, I mean, in today's time, almost every university student has a smartphone and the data is also not that expensive. So if you have a desire to learn, to attend classes, I don't think technology or the Wi-Fi and those things become an issue.
Okay, so thank you, Professor Mishra. And in fact, I'm going to take cue from you for my last question, last thoughts, which I'd like you to present in just under a minute. And what do you think should the role of the government be, especially considering the fact that the law schools are facing financial crunch, and on the other hand, the aggregate income of people is also going down. So what do you think the role of the government should be? Under a minute response from each one of you, that would be great. Professor Vonhan?
Yeah, well, I think that the government should support the law schools, because in a situation like this, in a time of pandemic, there are a lot of legal difficulties, and I think that we will need very good lawyers during the pandemic and also after the pandemic to sort out all the problems that the pandemic has caused for the fulfillment of contracts and other situations as well. So I think it would be very short-sighted to cut the funding of law schools precisely at this moment.
Professor Mishra?
Professor Ashita, I think what I told earlier, there should be a dedicated COVID fund for universities, which could be set up by government, by Ministry of HRD and Ministry of Education now. And even the state governments can do similar things for their own institutions. The other thing I feel, the CSR funds, the corporate social responsibility funds, which come from the corporates, some part of it should be reserved for universities and higher education institutions, not just law schools, but the entire higher education, because the higher education institutions provide the workforce, the manpower, the professionals who go and make profits for all these corporations. So the CSR funds, I feel universities have a genuine claim that at least 10% of, say, the CSR liability of a company should be going to universities, and whether it support financial aid for a student, whether it institutes scholarships, whatever fund. In India, we have 50,000 crores in CSR funds in previous years, and it has potential to rise up to 1 lakh crores. So out of 50,000 crores, even if 10% is given to higher education universities, you can get 5,000 crores. And every university can get 50 crores that way. If we have
These are very interesting thoughts, Professor Mishra. I'd like to go to Professor Srinesh Grotich and then Professor Hickey.
Yes, thank you. Well, as we are part of the public service body, then of course the government is going to take care of us for as long as they can. I mean, there will probably be some reductions in funding because obviously on the income side, the government is suffering great losses. But when I look at the private sector, what the government is trying to do is trying just to assist them with the paychecks, which of course affects our student body because their parents receive less money, and then of course they can't afford to study, and that will affect also us in the public sphere. But the government is claiming that they can't afford to do much more than that, so they will give a substitute or subsidize a pay for each employee. But that is not, I mean, it's just a money to survive, but not really a money to do much more. And that will affect us in the next phase, I think.
Professor Hickey, quick thoughts when left with no time.
Well, and I agree, of course, that government support matters. If I can answer the question the other way around, I think it also falls to us as university leaders to make the case to government. We know the economic benefits that follow from law degrees. We know the appetite for our courses at the minute. And I think there's a very important moment for us to sustain the future of law school education, university education generally, by taking every opportunity we can to convince government that research and development education, these things matter and are worth funding.
Thank you, everyone. It was a very interesting session. I learned a lot. I hope the audience also learned a lot. I'll give the platform to Professor Rajkumar.
Thank you so much, Ashita. And thank you, Professor Hayen, Professor Grotek, Professor Hickley, and Anand. It was a fascinating discussion because what each one of you brought to bear in this discussion is a very critical component of why should funding and financial stability of law schools need to be assured, and what are the ways by which we can secure the future of law schools by strengthening the financial governance of law schools in the pandemic and beyond. I'm grateful to you for your time and indeed your participation in this conference. Be well and take care. And we now will have a quick break and we'll move into the 30th thematic session of this conference on role of legal aid clinics during and after the pandemic. Thank you very much. Good evening from India. My name is Raj Kumar. I am the founding Vice Chancellor of OP Jindal Global University. It is indeed my proud privilege to welcome all of you to the third day of this global virtual conference on reimagining and transforming the future of law schools and legal education. We are, of course, entering into the 30th thematic session of this conference on the theme, role of legal aid clinics during and after the pandemic. We have with us a very distinguished set of educators, leaders in their own right who have contributed to many aspects of institution building. I have great pleasure in welcoming Professor Jenny Chapman, Executive Dean of the Nottingham Law School at Nottingham Trent University in the United Kingdom. We have with us Professor Dr. Avinash Govindji, Executive Dean of the Faculty of Law at the Nelson Mandela University in South Africa. We also have with us a very dear friend of mine, Professor N.S. Nigam, Dean of the School of Law, BML Munjal University in India. We also have with us Professor Ajay Kumar Pandey, my own colleague, who is a professor and executive director of clinical programs at Jindal Global Law School, OP Jindal Global University. I want to begin by saying that this pandemic has also reinforced the importance of pedagogies of learning. And one of the important pedagogies of learning that law schools have pioneered around the world is the need for emphasizing clinical legal education in various aspects of promoting experiential learning. Now, of course, the pandemic itself has provided with new opportunities, but also challenges as to how we can create opportunities to promote experiential learning during these times. With those words of introduction, I'm going to hand this panel over to my colleague, Professor Ajay Pandey, as he takes forward the moderating responsibility of this panel. Thank you very much.
Thank you very much, Professor Rajkumar. Welcome everyone, and I'm very glad that we have these three eminent panelists with us this evening to talk about the state of legal aid clinics and clinical legal education during the time of pandemic and beyond. What is the general thinking and how things are. So I think this is going to be a very useful session because many of us who do clinical legal education in India and elsewhere have been really grappling with many challenges and issues that we are facing, and we want to develop clinical legal education amidst these challenges and various difficult situations that we are faced with. The restrictions on mobility during the lockdown have incapacitated legal aid clinics that have been working closely with social communities. Legal aid clinics run by law schools consider clinical programs to be an integral part of their mission to educate. It is through clinical legal education that students learn social conditions, understand social problems, and contribute to community services. The continuing pandemic has necessitated the need for newer ways to reach out to the communities, providing clinical legal education and extending community services. Communities and its members now need support from the legal community more than before the pandemic. For instance, the lockdown period has witnessed a sharp increase in the number of cases of child abuse and domestic violence in many households, especially rural households. The distance, especially and technologically, the communities now have with members of nearby legal aid clinics rendered it difficult for them to have recourse to remedies, whatever remedies that could be provided by the law school clinics to these community members. Certainly, lawyers and law students have a moral obligation to alleviate the burdens upon many helpless individuals. What should be the new means and mechanisms to reach out to the communities and continue clinical legal education in law schools? Many law schools have shown the determination and resilience to continue clinical legal education and clinical services through alternative means and measures. They use online platforms with the support of local administration and law and order officials to connect with the communities. the transition of judicial and legal proceedings to online portals has to a larger extent helped to support the communities, especially in the filing and hearing of matters. On the pedagogical front, law schools have started using observational methods by showing recordings of earlier engagements with communities and things like that. Whatsoever, a reimagination is needed in imparting clinical legal education during the pandemic. Apart from finding new ways and means, consideration should also be given to clinical protocols and ethics when clinics are held online. The sensitivity with which community-related matters are handled cannot be negotiated, as legal aid clinics are not just means of knowledge production, but social production in itself. Therefore, this thematic session intends to assess the role of legal aid clinics during and after the pandemic and the way forward and such aspects. As far as various questions that we have for the panel, I think reimagining clinical legal education certainly prompts us to ask a few foundational questions. What are the primary objectives of legal aid clinics? How essential it is for students to learn community engagement by participation and immersion? What are the qualities clinical legal education can inculcate in students? Coupled with these questions, we also have questions like how the COVID-19 affected various law schools and basically the representation from the panelists as to how their law schools responded to this situation and what are the steps that they have taken to continue clinical legal education and how do they envision the future. So I would pose this bunch of questions to all of you. And to begin with, I may turn to Professor Jenny Chapman. So over to you, Professor Jenny Chapman.
Thank you, Professor Pandey, and thank you so much for inviting me here today to contribute. This topic's very close to my heart, and obviously I can offer the conference a UK perspective on clinical legal education in this session. It's probably worth me just telling you a little bit about the model that we run at Nottingham Law School because it's quite unique in the UK. So as part of our commitment to the delivery of transformational legal education and access to justice, we set up a fully regulated law firm, the Nottingham Law School Legal Advice Centre, in 2015. And this was a major milestone in the development of our pro bono advice clinic. So that had started in 2012 and had been run for a number of years. But in 2015, we decided to take it to a new level. So the centre is an exempt charity. It's a wholly owned subsidiary of the university, and it holds an alternative business structure licence from the UK Solicitors Regulation Authority. And we modelled our clinical model really on the teaching hospital model that you'd see in a medical school. So basically, we became first of our kind when we became regulated in 2015. And I think it's quite a unique model globally too. So our purpose is twofold, as with most university law clinics. Supporting access to justice for the community is absolutely critical, whilst providing outstanding opportunities for our students to engage in meaningful legal work with real clients. And we've got a variety of models. Our students can do short placements, long placements. They do work within the curriculum and outside the curriculum. We have 10 full-time staff that work in our centre, and they oversee over 400 student volunteers. And our model has had considerable impact. So in the last 5 years since becoming a law firm, we've actually recovered over £4.5 million in compensation and benefit for our clients. And we also have evidence that it really does help our students' employability and also their grades, their academic achievement too. So we know that the clinical model really has to show students how practice may differ from the academic experience of law. And we felt that by doing this through a law firm, we could really give them the most authentic experience.
All right, thank you for these remarks. I would now like to turn to Professor Govindji and ask him to pursue some of these questions. Professor Govindji, over to you.
Thank you very much, Professor Pandey, and thank you to Professor Rajkumar and to the institution for the invitation and to be part of this panel. And it's lovely to hear what is happening at other institutions. And our experience at Nelson Mandela University, really our Faculty of Law increasingly strives to integrate our learning and teaching with not only research, but with engagement activities in particular. And it's at that point that institutions like our University Law Clinic, our Street Law Program, our Labor Law Advice Office, all of those institutions need to play an increasingly crucial role in not only giving students the real experience. Our Refugee Rights Center is another good example of this, but in actually assisting communities in ways in which they require. Allowing communities to continue to set the agenda for the type of assistance that is required by institutions like our university, and then delivering on that. And I think, it's so good that we sit together and we discuss this, because I consulted with some of my colleagues who are working at the coalface at the law clinic in order to formulate some of these remarks. And the one thing that came through extremely strongly was collaboration, and how important that would be. One of my colleagues said that, in the past she would advise students that the success in a clinic case would be 99% perspiration and 1% inspiration, but it's changed now, and you need to include a big percentage for collaboration. So I think there's a deep sense that the collaboration, of course, happens not only with our formal legal systems, the courts, the Chapter 9 institutions that we have, like the Human Rights Commission, but very much with the profession. We're all tied into this together, as are we as law schools. So in order to achieve better outcomes, we need law clinic associations in the country, on the continent, and internationally, as well as faculty associations, law deans associations, and we need meaningful integration with the profession and the justice system in all our countries. And failing that, it's going to be very, very difficult for us to progress when it comes to tackling some of the really drastic challenges that we are now facing in the sector worldwide. So I look forward to exploring some of these themes and also discussing potential forms of collaboration in the time we have. Thanks.
Certainly, Professor Govindji, I think collaboration is a very important term, especially during these times. And we'll like to take some time during this panel discussion to talk about collaboration in various ways, how different law schools have collaborated. I would certainly like to now turn to Professor Nigam for his remarks to the first set of questions that I posed to all of us. Professor Nigam, over to you.
Thank you, Professor Pandey. Thank you, Professor Rajkumar, and a warm welcome to my fellow participants on the panel, Professor Chapman and Professor Govindji. I'm here actually partly to talk about legal aid clinics and partly to learn from the panel and from Professor Pandey. My law school is very young. In fact, we are in our second year. I'm the founding dean of the law school. We started this law school last year as part of a larger university. The BMN Munjal University is well known for its engineering and management education, and then it started this law school under with me as a head last year. So we are, in some ways, for us, any talk or any discussion about legal aid and legal services clinics are futuristic. We are looking to see how we should develop this program. I want to take this opportunity to state, in accordance with what Professor Pandey was saying as well, about the objectives and the way the Indian legal system has looked at education. So broadly speaking, all law schools in India have three objectives for when it comes to clinics. One is that we are looking at access to justice. So we're looking at this major issue in a developing country like India, which is that not everybody has access to justice. There are various parts, there are various members of the population who, because of some issues or the other relating to their finances or their position in life, are not able to access the justice system as others do. So that's one issue. And in a very interesting and I think quite a visionary manner, the Bar Council of India has always stressed on the point that students must get involved in these kind of issues right from the beginning, right? So that they are sensitized to the idea that there are parts of the population that don't have access to justice. Second issue, which is related to this, second objective, is to help vulnerable parts of the population. That's the reason why a lot of legal aid clinics in India focus on things like domestic violence, sexual violence against children, poverty-related crimes. So these are issues that are particularly serious for the vulnerable portions, parts of Indian society, and the legal aid clinics and legal services are meant to address those issues. And the third and third and kind of more overarching objective, which I'm sure my fellow panelists will agree with me, is that we need to develop a sense of empathy among our law students, right? I mean, it's sometimes law schools are a place where there is some kind of a gold rush towards lucrative positions and competition. And I think sometimes students just lose their idea of how to empathize with fellow human beings. And I think legal aid clinics and legal services are meant to bolster and to emphasize that aspect of the law that sometimes law students tend to forget. So it is really with these objectives that we have tried to begin our nascent and really kind of embryonic legal clinics program at my university. I'm sure we'll talk about that more as the discussion proceeds. Thank you.
Thank you. Thank you, Professor Nigam. Certainly, these terms are extremely important, access to justice, and I think that's a very important term, and that would surface again in the discussion. And people generally talk in terms of access to justice when it comes to clinical legal education. You've talked about help, empathy, etc., and we'll certainly take up some of those aspects. I would certainly now turn to the part on collaboration. I think the question would be: do you think that legal aid clinics of law schools should collaborate through clinical consortiums? A point that Professor Govindji stressed. During these times to upscale the benefits of pooling in resources. Has your law school taken such or similar measures? If yes, what benefits have such collaborations yielded, and what is the way forward? How would you see collaborations and their importance, and what are various points that you would want all of us to consider while considering collaboration and collaborative approaches? So I can quickly turn to Professor Govindji, since you mentioned a bit about collaboration. So we would like to hear from you, Professor Govindji. Over to you.
Thank you very much, Professor Pandey. And I think this really hits the nail on the head as far as we are concerned. And I think it's a deep type of collaboration that we are seeking. This is not the type of collaboration that can be achieved through a set of formal agreements or something imposed from a central authority. So the type of collaborations are those that come from the ground up. They are based in the first instance on the networks that the practitioners that are staffing the clinic have. It's based on their relationship with the courts in which they appear. It's based in their innovativeness in pursuing new ideas, such as increasing the role of mediation in dispute resolution. And it's really the people on the ground that set the tone in terms of the collaborative attitude that they instill and inspire not only in their staff, but in the students. that are then servicing the law clinics. So I think it starts from there. And in order to get to the next level, I also believe that there needs to be a very, very close collaboration with the faculty and the university, which is housing the clinic. In our case, Professor Nigam may be interested. Our law clinic is not located at the place where our core faculty of law is. It's located in the heart of the community, or one of the communities that has the biggest need for these services on our Mission Vale campus, some 20, 25 kilometers away from where the faculty of law is. So on the one hand, then, the type of collaboration that is required is also with the immediate community that is served by the clinic. On the other hand, you need big law firms. You need institutions with resources to come on board and to back the activities of what the faculty and the law clinic are trying to do in terms of enhancing the access to justice, again, that Professor Nigam spoke about. And there's one initiative that is uppermost in our minds at the moment, is an initiative called Law Lab that we are pioneering with one of the big law firms in South Africa. And in a nutshell, it involves bringing the type of technology that the big law firms are using in order to improve their case management and to digitalize their services to their clients. And it's based on the principle that that type of technology shouldn't be restricted only to big law firms operating out of Johannesburg. There's no reason why a law clinic located in Mission Vale in Port Elizabeth, South Africa, shouldn't have access to the same technology in order for students to be able to access and be comfortable with that technology in anticipation of their future role in practice, but more importantly, perhaps, for the clients that the law clinic is being served to have the benefit of enhanced and improved legal services as a result of the implementation of that technology. So that's an example of the type of collaborative approach, which of course needs some experimentation and some modeling in order to then be rolled out to other clinics. But that's the type of initiative I think that we would support and have in mind.
Thank you. Professor Chapman, do you have any advice on the question of collaboration? Any thoughts?
Yeah, absolutely. So I can offer another layer of that perspective. I absolutely agree that collaboration with law firms and enabling law firms to contribute to a pro bono activity in the community, we can be an important platform to enable that. But we have another layer of collaboration too, and that's with other charities and other advice agencies. So we work with some other UK charities, Personal Support Unit, which supports litigants in person at court, and also the Free Representation Unit that represents clients at tribunal. So our infrastructure includes those collaborations. So we enable our students to work with those organisations too, provide them with support, and also support and provide resource to those charities. We also work with local advice agencies, so other legal aid agencies, not university ones necessarily, in the region. And in fact, we've set up our services in a way that looks at what they can't offer. And so between us, we try and complete the whole of access to justice within the region. So we have referrals from those various citizen advice bureaus and advice agencies to us. And equally, we refer back when clients come to us that we can't help because that's not within our expertise. So we find that that network is incredibly important in supporting access to justice in a more holistic way within the community. So absolutely, you shouldn't work in a silo as a university legal aid service. You are part of that wider community. The last thing I would just add quickly is we also operate as a LawWorks clinic. So in the UK, LawWorks is a charity that encourages and is a network for pro bono lawyers. So we work as part of that network as well, work with their regional officer. And again, we find that an incredibly useful way of connecting with others across the UK in terms of a service where access to justice is needed.
All right, thank you, Professor Chapman. I would certainly like to talk about technology, and there are several questions related to technology as to how can legal aid clinics utilize technology to reach out to the communities during and after the pandemic. Some might say that we could imagine a virtual legal aid clinic which empanels lawyers on a pro bono basis to interact with the needy, to understand their issues and give advice. Is this viable? What can be done to realize this vision? Do you foresee the continued use of technology post the pandemic to scale the impact through virtual legal aid clinics? So, Professor Chapman, would you like to pursue this question?
Yes, thank you, Professor Pandey. So when COVID-19 hit in March this year, we just moved our services online. So previously, they had mainly been centered around clients coming into our center for face-to-face advice and meetings, and our outreach, which involved us physically going out into the community. The latter's been harder to replicate. So obviously for lots of reasons, and I'm sure the other panelists will have a perspective on this too, that outreach program has been more inhibited post-COVID. But our advice and representation service has continued. So we had a short gap where we moved very quickly online. But what we have found actually is that it's been more inclusive. So we've offered more one-off advice by telephone and online to clients. We've seen a big demand for that. And it has actually meant that clients that perhaps would struggle more to attend at our centre have been able to get advice that they need. Equally, our student volunteers, we found it more inclusive. So students with caring responsibilities, part-time jobs or commuting, who perhaps couldn't dedicate the time in the centre before because of those factors, actually have been able to become part of our student volunteer group because there's more flexibility in delivery online. So we always thought we would go online, and we've been talking about it for a while, and then we found that we would move very quickly to have to do it, and it's worked incredibly well. So we will carry on with it. We had to adjust some of our sort of security around that, obviously, with client confidentiality, and make sure our IT systems were really robust about how we did that. But we worked through that. That was fine. The only other angle I'll add just on technology too is that since COVID-19, a lot of our students have had their placements cancelled. So, they've gone out into work placements and those have been cancelled. So we set up a virtual internship project that we've run through the centre as well. So that allows students to do about a week's work of internship with us, all online. And that has been incredibly successful too. It's not the same as doing a week work placements in the office. I get that, but actually we've shown it has a lot of value. So it's a model that we are actually going to carry on with and enhance as we go through the coming months.
Thank you. Possibility or viability of a virtual legal aid clinic vis-a-vis community service or an outreach directly to the community and working with community members. So how does one go about it? Professor Govindji, you have any thoughts on some of these questions?
Thanks very much. I think our experience has been slightly different from Professor Chapman. We haven't been able to go completely online in the sense that we've turned the clinic into something that now operates completely and exclusively in the digital space. But what we have managed to do is to take core services online by modifying an approach so that clients who would have otherwise attended the law clinic and continue to do so, seeking assistance, can now be sent through and dealt with in a safe, COVID-safe way, and can then connect using a computer system that is on that particular campus of the university, and then be linked with the candidate legal practitioners that could be operating safely from their homes. So it's happened in that type of way up to now, and likewise the clinical legal education has been modified, not quite in the form of a virtual internship, but rather a full-on exposure to the type of pleadings, drafting of documents, presentation of opinions and cases. And technology has been instrumental in enabling that to happen together with the assessment. So the staff of the clinic would now upload a lecture explaining the basics, or a video explaining the basics of what would be required for a particular set of legal pleadings. And students could then access that. And I must say, just as an aside, the entire completion of the academic year at our university has been aided by the university